Still trying to. Oh, goodness. I'm still trying to get rid of that. That's what it is.
Hello, hello. Can you guys hear me? Great, thank you. I'm Kendra, the court reporter.
Hi, Kendra. Can you hear me? I just unmuted myself. This is Bob Jarrett.
Yes, I can.
Okay, thank you. I'm going to mute myself again.
Good morning, Ms. Tellez. How are you?
Good morning. Great.
Did I pronounce your last name correctly?
Yes, you did.
Thank you. So it's 8:58. We'll wait for 2 minutes. I believe Mr. Mokaka will be here.
Okay.
Mute myself.
Did you guys get snow in Santa Fe?
We did. Not exactly where I am, but certainly in the mountains. Up in the hills they did, yeah.
Good.
You were in Albuquerque?
Yeah, and they got it in the, just like you guys up in the Sandia area they did, but I live on the other side of town and not enough to count. Will you have everyone put their appearances on the record right away? And
Yeah, that's the first thing I'll do, and we'll test audio connections and all that when I do that.
Okay. I think we've only done one or two before, you and I.
I don't think we've done any, actually. I think this is the first. I've had Melissa Vigil.
Yeah, we have, because I just did one yesterday, and I pulled up the old title page, and you were the hearing examiner.
Oh, okay. I'm sorry, I don't recall that.
Well, you know, I'm forgettable. Okay.
All right, I've got 9 o'clock on the button here.
I'm ready.
Ms. Tellez, are you ready to begin? Good. You went mute again, Miss. Oh, there you go.
Yes, I'm ready.
Good. So we'll go on the record. This is the hearing for case number 19-00200 UT, 19-00200 UT. Today is March 25th, 2021. My name is Christopher Ryan. I was appointed as hearing examiner to preside over this case. This proceeding is scheduled for 2 days, and we will begin by taking appearances from the parties, and then in the course of doing that, confirm that everyone's audio works and everyone's complying with the order issued about Zoom protocol. So why don't we begin with the complainants? I believe I see Gary. Well, I shouldn't say I don't see Gary. I see a box entitled Gary, and I'm asking that person to unmute themselves. Okay, now I don't hear anything from Gary, nor do I see anything. And I will note that the Zoom protocol order makes clear that the complainants as parties were required to have video feed, and I don't see a video feed. I just see a box that says Gary. And I don't hear anything from Gary.
Can you hear me, Mr. Ryan?
I can hear what appears to be Miss Berg. How are you?
Oh, good morning. We don't know
Why the cameras?
we're here and we don't know how to fix the camera. Can you help us figure that out? I'm sorry, I don't know how to do that.
I without being in your actual office or wherever you are, I don't know that I can. We do need you to get video that will be necessary. There we are. I'm not sure that I hear you now. I see maybe you're laughing, but can you talk now? No audio. Now you're muted. Okay, you appear to be unmuted. Now you're muted. Unmuted. No audio. So there's a series of options. If you look on the bottom of your screen, you're going to see participants, and there'll be a little microphone looking thing. There's a little arrow to the right of the little microphone looking thing, and that will bring up a list of things like select your microphone, select a speaker.
Hello, can you hear us now?
We do hear you now, right? At least I hear you now. Okay, Mr. Sugar Ray and Ms. Berg, you are the complainants today. I'm trying to just talk to you because I want to hear your voices a little bit.
Yes.
There we go. That's good. I can hear you fairly clearly. All right, you're appearing today pro se, meaning that you do not have an attorney with you today.
We don't have an attorney.
Okay, very good. I'm just talking to you to see if your audio works. PNM.
Good morning, Mr. Hearing Examiner. Leslie Padilla on behalf of Public Service Company of New Mexico. With me today are the two individuals that will present as witnesses, Robert Jarrett and Aaron Baldwin.
Very good. Thank you, Ms. Padilla. And staff.
Good morning, Mr. Hearing Examiner. Are you hearing me loud and clear?
Very well. Thank you, Ms. Pagacco.
As you know, I'm here on behalf of the Utility Division staff. I'm accompanied by our engineer, Jack Sidler, and at your request, Mr. Ryan Jimenez from CRD will be joining us at 11.
Very good. I see a telephone number on my screen, 505-401-7543. Can whomever that person is identify themselves?
Yes, Mr. Hearing Examiner, this is Robert Jarrett. You should see my video as well.
I do. Okay,
I'm
I
dialing in
see.
on my cell phone.
Very good. Yeah.
Okay, thank you.
I think yeah, that's fine. I'll just note that that's you as well. I'll change the name. I think there's a way you can do it on, and it's sort of technical. I don't care. You can actually do that unique ID if you wish to use the Zoom video and then your cell phone for audio, and you can link the two. That gets a little more complicated, but I don't care. I'm just noting it. So if you wish to do that in the future, apparently you can do that. So. All right. Anyway. Moving on, the presentation of evidence in this matter, as identified in one of the pre-hearing orders, is governed by 1.2.2.33 subsection C of the New Mexico Administrative Code. The hearing examiner informed the parties that complainants will present first and sit for cross-examination, and the other questioning, PNM will present second, and staff will present last. Complainants are provided by the rules for have an opportunity to present rebuttal testimony. The rules specifically indicate what that is. If they wish to present that, they'll have to understand what that constitutes. No direct evidence will be permitted on rebuttal. Okay. Also in an order entered on March 6th, the hearing examiner instructed that the following all cross-examination of a witness, the hearing examiner may ask questions. Redirect shall be limited to matters arising from cross-examination and questioning by the hearing examiner. Scope of recross will be matters arising from redirect and questions from the hearing examiner. All parties were directed in a pre-hearing order to familiarize themselves with the provisions of the Commission's procedural rules governing conduct at a public hearing. That rule is found at 1.2.2.32 subsection G. The January 25th order entered by the hearing examiner in this case was an order entitled Order Identifying and Narrowing Issues for Hearing and Third Set of Bench Requests. In that order, the hearing examiner identified what he perceived as the meritorious claims in this case and did as much as possible to focus the parties on the fact matters that require resolution. It's my view that we are here today to resolve those issues. Parties are free to present whatever evidence they wish, of course, but that will be my focus. So proceeding this case, PNM also filed a motion to dismiss that was denied. And that was denied on the grounds that the hearing examiner perceived that there were inevitable fact questions underlying that motion. Those are also fact questions we're here to resolve today. Complainant should be aware that I presume P&M is likely to raise many of the arguments it did in its motion. And I say this only in part because complainants are not here represented by counsel. In a procedural order filed with the Commission on January 25th, the hearing examiner alerted the parties that complainants, P&M, and staff all had significant communication during the informal proceedings in this case. Representations and admissions were made in those communications. The hearing examiner intends to admit the informal complaint file. P&M actually identified it as one of its exhibits, and I'm just noting that for the record. The hearing examiner also issued a series of bench requests and elicited much testimony. He also intends to admit all responses to bench requests, and I noted the parties identified several exhibits already that were bench request responses. The hearing examiner gave time for the parties for an opportunity to file objections to evidence, for motions to exclude evidence, and motions in limine. No motions were filed. The complainants were directed to supply to the other parties any exhibits they intended to admit at this hearing. They supplied none. Complainants did not contact the hearing examiner with questions about what was necessary as far as exhibit filing is concerned. I see that P&M has identified several of complainants' documents as P&M exhibits. The hearing examiner also took the time to identify those documents complainants submitted, and that should be made part of the hearing record. So my view is that all the documents complainants have submitted be admitted either as P&M or commission exhibits. And when I say commission exhibits, I mean, of course, exhibits other than utility division staff, that this would effectively be the hearing examiner's exhibits as commission exhibits. So I guess as a preliminary matter, Ms. Padilla, I did see you identified several of complainants' documents as P&M exhibits. I'm happy to allow them to remain P&M exhibits, and then I'll just take responsibility over the other documents that I believe complainants have to submit. Is that acceptable to you, Ms. Padilla?
Yes, Mr. Hearing Examiner, I did put those on our exhibit list because I do intend to use those in my questioning of the complainants, and just wanted to be sure I had a good way to refer to them and that they would come in, although I did know you intended to, likely intended to introduce those as well.
Yeah, and I spent a considerable amount of time just compiling all the documents in this case, and I've created what I believe is sort of a master list. And everything that I want in, I'll move, but I didn't, you and I had some duplicates, and I think my judgment is I'm just going to defer to P&M to admit those. Is that okay with you, Ms. Padilla?
Yes, thank you.
Very good. So for purpose of the court reporter, did Ms. Kendrick-Hayes get bounced? Oh, geez, she did. You have to have the court reporter and have that conversation. There you are, Ms. Tellez. I didn't notice she went away. Hi, Ms. Tellez, how are you?
Sweating. So
Okay.
I'm everything. I mean, I when you said if you wish to do that in the future, apparently you can do that. Anyway.
Okay, so where did you cut out?
Right when you said that they could call in by Mr. Jarrett said his appearance, and you said that he could it's a feature of.
Oh, that's a shame. Okay, so I have to go back and say some things again. I apologize.
I'm so sorry.
No, that's okay. I'm sorry, I didn't pay more close attention to the screen. I will run through that again, just for purposes of, well, why don't we go on the record and we'll say what happened. Is that okay? Okay, so Ms. Sayers, all right, so we're back on the record. What just occurred is the hearing examiner went over some basic housekeeping matters. Some point in the dialogue, Ms. Tellez, our court reporter today, was exited the Zoom meeting for a whole host of, it doesn't matter why, it just happened. So She, as I understand, caught up to the appearances by the party. I was having a conversation with Mr. Jarrett, and then she went away. So I'm just going to quickly go over all the things that I've just said, and I apologize to the people who have to listen to this twice. So the presentation of evidence in this matter is governed by 1.2.2.33C NMAC. In an order dated March 19, 2021, the hearing examiner relayed to the parties that complainants will present and sit for cross-examination first. PNM will then go. Finally, staff and complainants have an opportunity to offer rebuttal evidence. The commission's rules identify what that is. They shall be admitted given the opportunity to present rebuttal evidence, but not direct testimony. So it's upon them to understand what that means. In the order entered on March 6th, the hearing examiner also made clear how questioning will be conducted in this case and the scope of that questioning. Following all cross-examination of a witness, the hearing examiner may ask questions. The scope of redirect will be matters arising from cross-examination and questioning by the hearing examiner. Recross will be matters arising from redirect and questioning by the hearing examiner. All parties were directed to familiarize themselves with the provisions of the Commission's procedural rules governing conduct of a public hearing. The hearing examiner will assume that that's been done. So in an order dated January 25, 2021, the hearing examiner issued an order basically entitled Order Identifying and Narrowing Issues for Hearing, and there was a third set of bench requests. The hearing examiner identified what he perceived as the meritorious claims and did as much as possible to focus the parties on the fact matters that require resolution. The hearing is largely dedicated to that. However, I've made clear that the complainants and whoever else in this case is free to submit whatever evidence they wish. Preceding this case, PNM filed a motion to dismiss. That motion was denied. It's effectively a motion for summary judgment. Complainants offered factual allegations, and that's the basis for the hearing examiner's denial. I'm simply noting this as I anticipate that they'll see that again. And I'm partly noting this only because complainants are not here represented by counsel. In a procedural order filed with the Commission on January 25th, 2021, the hearing examiner made note of the fact that there was significant evidence elicited during the informal complaint points in this proceeding, which occurred for a period of time. There's much evidence admitted and representations made. The hearing examiner will admit that informal complaint file that was filed on eDocket. The hearing examiner also issued many bench requests. Those bench requests shall be admitted into the testimony today. The hearing examiner gave time for all the parties to file objections to evidence, motions in limine, motions to exclude. No such motions were filed. Complainants were directed to supply the other parties' exhibits. They supplied none. And the last note is that Ms. Padilla and I discussed already before, when we lost the court reporter, how we were going to proceed to ensure that all the documents complainants submitted are correctly admitted into the trial transcript and in the record from this hearing. And our conversation basically resolved that some exhibits, which really are complainants' documents, shall be admitted as PNM exhibits, and the rest of the complainants' documents shall be admitted as commission exhibits, and by commission I mean the hearing examiner and not staff. And that phone is driving me crazy. So that's how far we got, and we did that twice, so now we can move along. Anything from any of the parties before we take the complainants?
Hearing examiner, there's the matter of our motion to compel and your order granting the motion to compel, which required immediate responses to our discovery requests. I'm sure you observed the complainants did submit something, and it was captioned or labeled as to the effect of being a response to the motion to compel. The document did not contain any supplemental discovery responses. It was a narrative document, and it essentially indicated the identity of, I believe, the electrician and the subcontractor, but it neglected to address outstanding discovery requests 8 and 9 as they pertain to Positive Energy Solar. And as you'll recall, I hope, the complainant's initial responses to discovery requests 8 and 9 were to simply claim that that information was irrelevant. And I think we made a sufficient enough case to show how it was relevant in our motion to compel, judging by the order that was issued granting the motion to compel. And I would just reiterate that that information was important. It was something that we would have liked to have had if the plaintiffs possess it, the complainants possess it. And it's obviously relevant because, among other things, in their response to question number 12 and third bench requests, they claimed that it was the solar company who alerted them to the supposed issues involving the rates as they apply to the complainant's property. And so I'm at a loss. Usually people are a little more forthcoming and compliant. I understand we're dealing with pro se complainants and that they are allowed some measure of latitude in these proceedings, but to totally disregard these discovery requests and then to disregard an order of Mr. Hearing Examiner, I think is something that staff cannot let pass. And I would just direct your attention to some of the legal authorities that were contained in staff's response in opposition to the complainant's motion to have you recused, which involve the imposition of sanctions. And if you'll recall, we cited Gonzalez versus Sergadev Corporation, a New Mexico case, 120 NM 151, for the proposition, among other things, that trial courts must unhesitatingly impose sanctions proportionate to the circumstances to assure effective discovery. Now, here we are at this point where the time for uploading our exhibits for purposes of this proceeding has come and passed, and we don't have pertinent information referable to perhaps one of the only outside entities that staff thinks likely had some information that was directly relevant and probably would have, we hope, revealed a little more information about how this system came to be set up and other information I think that's directly pertinent to the narrowed scope of issues pursuant to your third bench request and its companion order. So I would ask the hearing examiner to consider imposing some sort of sanctions or limitations for purposes of this proceeding, whether it be taking an adverse inference on the evidence that the complainants would present in support of their claims, or limiting their ability to object to questions on cross-examination, or I don't know if this rises to the level or if it is directly proportionate to their disregard for the discovery requests in your order granting the motion to compel, but perhaps the hearing examiner might entertain depriving the complainants of the option to do rebuttal today at this proceeding. At any rate, staff takes it very seriously and thinks that the latitudes that are granted to pro se complainants do not equate and should never equate to a blank check, basically disregard discovery requests and orders of this body. That's all I've got right now, Mr. Hearing Examiner. I hope you consider that.
Yeah, no, thank you, Mr. Rogacko. I understand your position, and I'll happily hear from complainants in a moment. Before I hear that, though, I will say, you know, in the order on the motion to compel, I made clear that to the extent to which complainants believe they've answered a question to their best of their ability, they're free to answer that is what they've done. That was not a statement to say that these individuals may simply rely on we've answered it best of our ability, and they must just sort of understand that to the extent to which it appears they certainly have information, but then respond, we've answered to the best of our ability, but never provided an answer. Well, that goes generally to their credibility and whether or not the commission should accept anything they say as true. As to what specific we do with, I mean, I think there's a meaningful cross-examination to come. I know I certainly have a lot of questions. I think staff's position is totally reasonable with respect to adverse inferences limiting the ability of the plaintiffs to object to questions to the extent to which they do. And then as to depriving for rebuttal testimony, my concern would be that like what constitutes rebuttal testimony is not something that's going to be fully understood by a pro se litigant, and the fine differences between direct and rebuttal testimony, I mean, could be lost on even lawyers. So, and the third one, I don't know that's too much of an issue. I'll just not allow testimony that's plainly just direct testimony. But all right, so having said all that, let's hear from complainants. You heard what Mr. Bagacco said. You've heard my comments right now. I'd like you, the complainants, to say whatever they wish.
Whatever I wish to.
Sorry, we can't hear you, Ms. Berg.
What do you want me to respond to, Mr. Bagacco? Is that what
Yes.
you're asking?
Yes, Mr. Bagacco said a number of things as to what I should do, given your non-responsive response. And what do you have to say to Mr. Bagacco?
Mr. Bagacco, as you are aware, Carol Anderson came into the picture very late in this process. Because I am unfamiliar with how to defend myself in a situation like this, she is the one that, when I talked to her about your request, she presented to me asked and answered and irrelevant. And so it was my belief that the solar company did not have anything to do with PNM's failure to inform and failure to assist us on the most economical rate class. And so I listened to Carol and put that down, not in any way, shape, or form to be disrespectful or disregard your concerns. I simply did not understand what positive energy had to do with PNM's failure to inform and failure to assist on the most economical rate class. So I do apologize. I hope that you can understand also that this process has been going on for 2 years and 8 months, and everybody will reach a threshold of tolerance when pushed beyond what I believe to be unreasonable requests, I guess, is all I can say. So it was never intended to be disrespectful to you or any of the parties. It was simply what Carol had suggested, and I just listened to her because I didn't know any better. Is that helpful?
Okay, so let me just say some Mr. Bagacco, I'll ask you to respond and you can make whatever arguments you wish there, but I'll say quickly to the complainants, we are not here today to discuss your respect for anyone or your feelings about any subjects. We are simply here today to determine the facts that bear upon the legal claims that you've made in your complaint. Your concern, complainants, is not as to Mr. Bagacco's feelings. They are not as to whether or not you're respecting or disrespecting him. He's basically made a legal argument to which you've just responded that you believed his questions were not relevant questions, and you listened to an attorney who has not appeared before this tribunal or sought to be admitted into the tribunal. I don't frankly know the rules in terms of if you're relying on someone as counsel without them having made a formal appearance, who have not been admitted into the bar through a licensed New Mexico attorney, Prohac Viche. I mean, that's its own bag of spiders. I guess my only comment is this proceeding shall not devolve into a consideration of people's feelings. I'm not concerned with anyone's feelings. And I'm saying this partly so that complainants understand this. The question is, as a matter of law, was Mr. Bagacco's questions relevant and likely to elicit testimony that would have bared upon the issues here? I think the answer to that is clearly yes. Mr. Bogacco already explained why that was so. And the responses from the complainants was they listened to an individual who claimed that they could just simply not respond. So anyway, Mr. Bogacco, anything you want to add beyond what I just said?
I agree with Mr. Hearing Examiner. My feelings aren't hurt. I'm just concerned with getting information that would have helped us to ferret out the merits of the claims at issue in this case. And as for complainants' reliance on advice of counsel defense, I would have that noted in the record, and I don't know what the implications that may carry, how this may develop, but I find that troubling. None of it's availing though, and I think that our requests for the limitations in accordance with clear violation and disregard for the hearing examiner's order, I'll renew those requests, please. And I think you've indicated where you're heading with those requests, and I think staff finds that acceptable in terms of how we're going to conduct this proceeding today in light of what's gone on in this case in terms of the motion to compel, non-responsive discovery answers, and the situation involving the disregard for your order granting our motion to compel. And I'll leave it at that, Mr. Hearing Examiner. Thank you.
Mr. Bogacco, I'll give the other party, PNM, do you have anything you'd like to contribute to the discussion here?
No, Mr. Hearing Examiner. I mean, I do think the staff's questions about Positive Energy's communications with, interactions with the complainants would have been helpful to understanding, exactly, what happened and what the role of the solar company was in helping complainants understand their rates. That's all.
Okay, thank you, Ms. Padilla. So we'll proceed forward. All of those objections were noted for the record. Staff requests are noted for the record, and I think we can just get into the factual presentation of this case and consider the impact of that on what we discover later on. Adverse inferences, limiting the ability to object, and what have you can all be addressed as we move forward. So we would have complainants first, and it's not entirely clear to me, Mr. Bogacco or Ms. Padilla can answer this question, but in district court proceedings, of course, the two witnesses don't necessarily stay in the room with one another when one's testifying, but I don't think that rule applies to the commission, is my understanding. And unless there's some objection, I believe Ms. Berg and Mr. Sugaray intend to just stay and present and be together in the room there. Does staff or PNM have any objection to that?
No objection, Mr. Hearing Examiner, provided that it's clear that the witnesses are not going to be coached by anybody outside of that room, including their so-called consultant.
I had the exact same concern, Mr. Bogacco, and I appreciate you raising that, and I want to say that right now to the complainants. If you, Ms. Berg, you indicated earlier that I saw the I don't know what I would call it, the communication you directed towards the commission that Ms. Anderson, who is an attorney licensed in California, is advising you now. Ms. Anderson cannot be providing you information or direction about how you are to present today through whatever mechanisms cannot be seen on Zoom. Mr. Bogacco said it, the thought was in my head as soon as that notification was provided. You are aware of that now. And Ms. Padilla, did you have any objection to the two individuals staying, Ms. Berg and Mr. Sugaray, in the room together as we receive testimony?
No, Mr. Hearing Examiner, PNM does not object, but I would note that we do have separate questions for both Ms. Berg and Mr. Echegaray that we will, I think, want to conduct in sequence.
Okay, and did you have a particular sequence in mind?
If Mr. Echegaray could go first, that would be PNM's preference.
Mr. Echegaray and Ms. Berg, do you object to PNM's request that Mr. Echegaray present his testimony first?
Yes.
You do object?
Yes, Mr. Hearing Examiner, have told you before that my husband has not been involved in this case. He has not read any of the material, and I regret to have taken him away from his work today to be here. And because of Gary's lack of knowledge concerning the complaint, I am asking that I do the bulk of whatever it is that I can help you with, because I'm the one that filed the complaint. I'm the one that has presented what I could, and Gary simply has not been involved. So I would like to ask the questions first.
Ms. Padilla.
Well, I have separate questions for both of the complainants. And while I could certainly proceed with Ms. Berg first, Mr. Echegaray, absolutely, it is our position that he has to make himself available for questioning, and I do have specific questions for him based on responses to bench requests that he provided.
What do you make of Ms. Berg's specific representation that Mr. Echegaray does not have information to supply here because Ms. Berg has been the main proponent of their claims?
Mr. Hearing Examiner, complainants have been, I mean, both individuals are the complainants in this case, and I think we should expect that they both have, they may have separate knowledge of the facts and they may have different knowledge of the facts, but in this case, both of them brought the complaint. Mr. Echegaray and Ms. Berg, developed their property together. Mr. Echegaray, I think, acted as general contractor for both of the structures on their property. So I don't see. I actually don't understand why Mr. Echegaray wouldn't know most of the important factual the issues that are at fact in this case.
Mr. Bogacco, do you agree with that?
Mr. Hearing Examiner, I think you'll recall question number 4 in the third bench request was specifically directed to Mr. Echegaray. And the answers to that, among other things, say, I don't know. So either Mr. Echegaray answered those questions or somebody else answered for him. I find this pretty troubling. And I think that Mr. Echegaray should go first because he is named as a co-complainant in this case. He has been participating, ostensibly participating in the case because the answers there are, I don't know. And those answers are verified by the complainants. I mean, they did file a self-affirmation with it, although it does have some imperfections in it. I took them at their word and it's signed by both complainants. So I think it's highly suspect for the complainants now to try to get Mr. Echegaray out of this case. I think he needs to go first. And if the complainants think that's a problem, then I don't know. I suppose there are a number of different options if they don't want to go forward under these circumstances. I mean, we could, if it pleases Mr. Hearing Examiner, convert this into a summary proceeding, move for a directed verdict, a demurrer to the evidence. I don't know. But like I said before, pro se parties are afforded some latitude, but not to the degree that the complainants keep implicitly and explicitly suggesting and requesting in this case. So I would ask that Mr. Echegaray go first, as PNM has requested, because he is a complainant in this case and he has answered questions under oath.
And could I add one additional thing, Mr. Hearing Examiner? Several, I believe 2 different sets of your bench requests, 2 complainants expressly asked Mr. Echegaray to respond to questions. So there really can be no question that he has been put on notice that he is responsible for providing and contributing to the factual record in this case.
I agree with what both PNM and staff have just said. So for the complainant's purposes, this matter is styled in the matter of the formal complaint of Gary Ashugare and Leah Berg against Public Service Company of New Mexico. Mr. Ashugare isn't a party to this proceeding. He's an essential party. The testimony that he has is essential to understanding the factual content of the representations underlying the legal claims that are brought forward in this proceeding. If Mr. Ashugare has to depart the proceeding after providing his testimony because he has business to conduct or whatever it is in his life, he's free to depart then, but shall not leave these proceedings until he testifies in response to all the questions the parties may have under cross-examination. So that's the ruling on that. And I also think it's reasonable for PNM to ask Mr. Ashugare to present first. We're going to have to spend a bit of time. Just the complainants failed to identify any of the exhibits that they wish to submit for the record. I understand that maybe as pro se litigants, they don't understand the difference between what e-docket is and these filings they submitted, and then what this hearing is about. Explaining due process and all that is probably not a useful, a good use of our time. I'd have to explain a lot to the complainants, but they need to just basically understand that they're going to be asked today to verify representations in documents are true and accurate to the best of their ability, to know that answer, and then to say that they would testify in the same way if they were asked to make those statements right here and now, and if they were lying, they would be subject to penalties of perjury. So that's what we're doing today, and the documents that the complainants have provided so far, none of them have been subject to admission based on that understanding. So we've got somewhere in the range of about 15 to 20 documents, all of which allege facts relevant to these proceedings and appear in different times. So I think we're just going to have to go through all the documents, sadly, and I'm just going to have to walk through this. Just go through all the documents, admit them, and ask the complainants, did you write this and would you write it again? Does anyone else see Ms. Padilla or Mr. Bagacco a way around that?
Mr. Hearing Examiner, I do not. I mean, I was prepared to ask the complainants about, their complaint and the bench request responses, but I think without what you intend to do and that first step of ensuring that the complainants, affirm what's contained in those documents and that you introduce them into evidence, I think what you're proposing is a better solution than me just asking questions about those documents.
Yeah, I assume you would agree, Mr. Bagacco.
Mr. Hearing Examiner, that's acceptable. Thank you.
It's troubling. Again, it comes down to administrative proceedings before a tribunal like this is kind of a strange thing, and I think most people don't just kind of their view of the law is sort of what you see on TV, and we're not doing that here, and it's sort of unusual. So I got to give folks a little bit of leeway. But many of these documents contain factual representations, and we're just going to walk through them all. I have them all laid out, and I'm prepared to do it all, and I think I can do it all relatively quickly. So we'll just do that. So for purposes of the complainants, have you understood what I've said so far?
Yes.
Good. So I'm going to ask you some questions now about several documents. And the reason why I'm asking you about them is, number one, we have a court reporter here today who is taking down all that is said in a verbatim way. And so what I'm going to ask you about are documents that you have submitted. I am not going to acknowledge that who among you submitted them, because you are both the complainants in this complaint. I am simply going to refer to both of you as complainants. And if either one of you responds affirmatively, I will take that as a response from both of you that you understand what the document is. And if one of you responds, yes, I remember writing this, then that's good enough for me, and it'll go towards both of you. So do you recall, complainants, Mr. Berg, Mr. Ashugare, a document entitled the formal complaint form, in which you wrote what it is you were complaining about in this formal proceeding, and you made representations and included several documents with that document?
Yes, I filed the formal complaint.
Right, and you recall writing that information on that document?
Yes.
And if you were asked to write those materials, or write those documents again right now, or make the representations contained within those documents again right now, would you make the same representations?
Absolutely. Yes.
Very good. So this is the complainant's formal complaint form. This is one of those matters that PNN had identified as an exhibit that it would submit for purposes of its questioning. And I would move that the formal complaint form be admitted as PNM Exhibit 6. And I believe, Ms. Padilla, that conforms with what you've identified.
Yes, it does, Mr. Hearing Examiner.
And just for the record, so that anyone reading this hearing proceeding in the future knows, there will be PNN 1 through 5. It just so happens that in the order of chronologically, this is the first document, and it happens to be identified as PNN Exhibit 6. So complainants, you submitted documents at one period of time. They were a bill from PNM. It is the bill that is due date 1/30/2018, and then also January 5th of 2018. And it's included in the notice of formal complaint from the commission, which was filed on e-docket on July 15, 2019. Initially, that notice of the formal complaint, it's the last 2 pages of the notice of formal complaint filed on e-docket on 7/15/19. And again, this is the PNM bills for Gary to Sugar Ray, and it relates to, it's 2 pages. It relates to the January 30, 2018 billing cycle. Do you recall supplying that to the commission complainants?
I guess so. Whatever I supplied to you, Mr. Hearing Examiner, I did so to the best of my knowledge that I was presenting materials that I thought would be helpful based on my knowledge of this process.
That's very good. That's all you need to say. That's fine. So this document, the last 2 pages of the notice of formal complaint, which is the bill, PNM bill for January 30, 2018, shall be admitted as Commission Exhibit 1 unless there's any objections. Hearing none, I'll admit that as Commission Exhibit 1. I have here in front of me a document that is filed on e-docket as additional information of formal complaint on October the 3rd of 2019, initially filed on e-docket. It is a letter from Ms. Berg dated 10/3/19, and in the pages that follow that, there are several letters to Ms. Berg to multiple people within the PRC. It just describes a series of communications. It's a multi-page document. It includes both emails, and then it also includes attachments, one of which is the certificate of occupancy for one of the structures on complainant's property. There's our pictures involved. Do you remember submitting this documentation, Ms. Berg?
Yes.
Very good. I'm inclined to admit this document as Commission Exhibit 2, unless I hear any objection. And I should say, Ms. Berg, you would submit these documents again, and they're true and accurate to the best of your knowledge, correct?
To the best of my knowledge, they're true and accurate.
Yeah. Okay, so this document would be admitted as Commission Exhibit 2, unless there's any objection. I don't hear any. We have a document filed on e-docket originally on October 7, 2019. It is a letter to the PRC and PNM from Leah Berg. Again, this document includes statements of fact, and then also varying attachments. Do you recall, Ms. Berg, writing a letter to the commission on, I don't see a date on this, but it was enclosed as a copy of our residential application for electric service by PNM. Do you remember submitting that document, Ms. Berg?
I believe so. It's been a long time with the hearing examiner, and I can't see what you're holding up. But
Yeah.
I submitted what I believe to the best of my knowledge was hopeful to reach a resolution in this case. So yes.
Okay, very good. And maybe I'll just have to accept, Ms. Berg, to the extent to which I ask you about a document that you have already filed on eDocket, and I think this is the most efficient way to do this. You continue to believe that all of the information you supplied to the commission was true and accurate to the best of your knowledge. And if you supplied it to the commission, this is your view of the facts in this case. And these representations you're making are true and accurate representations. Is that correct universally?
Yes, to the best of my knowledge, universally.
Okay, so
Thank you.
we'll accept that as just like a continuing proposition through all of these documents. October 7, 2019, filing response to David Black's notice of filing shall be admitted as Commission Exhibit 4. Excuse me, Commission Exhibit 3. I apologize, I got ahead of myself. I'm holding here another document that Ms. Berg submitted to eDocket on October the 8th of 2019. It is entitled Response to PRC and PNM. It's a multi-page document. It includes factual representations, W-2s, a statement from Lujan Drilling relating to the drilling of a well. This was submitted by complainants to eDocket on October 8th, 2019. This document shall be submitted as admitted as Commission Exhibit 4 unless there's an objection. I have in front of me now a document entitled Documentation to Further Assist in Formal Complaint Against PNM. This was filed on eDocket on July 14th of 2020. Initially, it involves varying representations by Ms. Berg to the commission. There are more documents related to the construction of their home, documents involving their billing for their electric service, document from the Office of the State Engineer, and then color pictures of their property and some of the structures on it. This was identified by PNM as an exhibit they would use to question the complainants. And I believe you intended to admit this document as PNM Exhibit 7. Is that correct, Ms. Padilla?
Yes, Mr. Hearing Examiner, that's correct.
This document shall be admitted as PNM Exhibit 7 unless there's any objection. I don't hear any. I'm holding here now a document supplied by the complainants to the commission on July the 15th of 2020. And the title of the document generally is Amended Relief Sought. In this, the complainants make allegations as to what else they're seeking in this case and offer factual representations relating to the solar company that was involved in this matter. And there are some additional documents. This document will be admitted as Commission Exhibit 5. Unless there are objections. Okay, moving on to, we have representations from the complainants to the commission in a document filed on 7/16/20, generally titled Communications from City of Santa Fe Regarding Business License. In these documents, the complainants make factual representations, then offer documents ostensibly from the City of Santa Fe relating to a company named Piece of Pastry. These documents shall be admitted as Commission Exhibit 6 unless there is any objection. I have another document here dated July 20th of 2020. It is entitled Amended Relief Sought. This is the second in a series of amended relief sought documents. Second identically titled document. In this document, the complainants talk about the relief they're seeking in this case. It's a short document, a single one page of content and a cover page. This document, unless there's objections, shall be admitted as Commission Exhibit 7. no objections being heard, then it shall be admitted. We then have a document filed on eDocket on originally on July the 29th of 2020. The title of the document is the 7/13/20 bench request answers. In effect, these are the complainant's responses to the hearing examiner's July 13th, 2020 bench requests. Again, initially filed on eDocket on July the 29th of 2020. This document contains representations by complainants to the hearing examiner's bench requests. It includes also documentary exhibits making factual representations in response to the hearing examiner's questions. PNM also identified this as a document they intended to utilize in the course of this proceeding and identified that as PNM Exhibit 8. Is that correct, Ms. Padilla?
Yes, it is, Mr. Hearing Examiner. I do have one comment on this, and I think at least one other set of the bench request responses by complainants, and that is that the complainants did not include the questions in their bench request answers. So it is difficult to, without your bench requests in hand, also it is difficult to know what the questions are responding to. And I did not attach the bench requests to the bench request answers, unfortunately, but I just want to note that in my question to the complainants, I will probably just verbally state what the questions were that they are responding to in their bench request responses.
That's a good point, Ms. Padilla, and perhaps it'll have to be that the bench requests themselves get admitted so that the transcript of the proceedings include the statements. I might have to come back to that after a break because I'd want to get that dialed down and sort of make sure it all makes sense for purposes of the record. But I think it's a perfectly legitimate objection, Ms. Padilla, or not objection, but a comment that is important to note. So I guess I'll ask complainants, the complainants, you submitted bench request responses in this case. Ms. Padilla just noted that in your responses, you didn't supply the questions. I don't fault you for doing that. I think I understand why you would just answer the questions and not restate the questions. But Ms. Padilla's point is simply that whoever after this proceeding was to review this record wouldn't know the nature of what you're saying in your response without knowing what it is you were asked. So you don't deny that well, I'll put the question affirmatively. I'm not use double negatives. You acknowledge that the responses to the bench requests in any of the responses you provided were predicated upon questions that I asked you in bench requests.
Yes.
Correct. Yeah, I heard. And your audio is a little quiet, Ms. Berg. So I think you and Mr. Sugar are going to have to speak up when you do talk. I don't want to make you yell, but it is a bit quiet.
Yes, I was answering your question.
Yeah, I understand. You understand, Ms. Berg, and I'm having to ask you that because from a court proceeding, we're creating a record. That record will be in written format. So we have to say everything in order for that to be communicated to a potential subsequent reviewer of this.
Yes, I
Okay,
understand.
so if it all feels a little bit laborious, it is. It's the only way it can get done. So in any case, I'm going to admit the responses to the bench requests issued by the complainants on July the 29th, 2020, and again, responding to the July 13th, 2020 bench requests as PNN Exhibit 8. And I did understand, Ms. Padilla, that's what you identified this document as.
That's correct.
Thank you very much, Ms. Padilla. Okay, the next document I have is a document entitled, at least on eDocket, live chat with PNM regarding rate class. This was initially filed by the complainants on July the 30th of 2020. In this document, they make some representations of fact and have included a live chat discussion printout. Unless there is any other objections, I'm going to admit this document as PNM Exhibit 9. Correct, Ms. Padilla?
That's correct.
Very good. So I don't hear any objections, and that shall be admitted again as PNM Exhibit 9. Next document I have before me is a document filed on eDocket originally on 10/28/2020, October the 28th of 2020. It is generally entitled Response to PNM's Statement of Facts. In this document, there's lengthy writing from complainants about a host of subjects. And this document I intend to admit as Commission Exhibit 8, unless there is any objections. Hearing no objection, it shall be admitted as Commission Exhibit 8. I've just seen Mr. Jimenez is asking to join as a guest. He was put into the waiting room, so now Mr. Ryan Jimenez, I believe, has joined us. So he doesn't need to participate at this point. We're just doing complaints. And I'm just saying that so he heard. So the next document I have here is a complainant's response to the November 2020 bench requests. This was originally filed by complainants on eDocket on December the 8th of 2020. The document includes the responses from complainants to the hearing examiner's bench requests. Again, issued on November 11th, 2020. As Ms. Padilla noted, we do not have a record of the questions. We only have answers here. As I noted previously, it's understandable why complainants would do that. And we will likely have to admit the questions to the bench requests so that we can see what the responses are replying to. Unless there's any objections, I shall admit this as PNM Exhibit 10. Correct, Ms. Padilla?
That's right, Mr. Hearing Examiner, that's correct.
Very good. Are there any objections? Hearing none, that will come in as PNM Exhibit 10. The next document I have here is a document entitled Further Discovery Submission. It is a letter to the hearing examiner dated March the 4th of 2021. And I may have switched something here. I don't think so. Might be one other letter. So in any event, this document, the further discovery submission, March the 4th of 2021, and I'm just confirming for myself I haven't missed something. If you just bear with me 1 second. Yeah, I believe this is the correct order here. All right, so this is going to be Commission Exhibit 9. Unless there's any objections. Good, no objections heard. And the last document from complainants is the answers to the third set of bench requests. This was originally filed on eDocket on March the 4th of 2021. In this document, the complainants respond to the last set of bench requests issued by the hearing examiner. And in that document, they make factual representations that are essential to this proceeding. And this was identified by PNM as a document that they would wish to admit as PNM Exhibit 11. Correct, Ms. Padilla?
That's correct.
Very good. I will admit this document as PNM Exhibit 11 unless there's any objection.
No objection, examiner, but may I clarify, since the answers to the third bench request from the complainants are pretty central to our narrow scope of issues in this case, are we also going to have the third set of bench requests marked as an exhibit for use in cross-examination?
Yeah, and so you're basically asking Mr. Bogecko the same question as Padilla did, that we need those questions in the record?
That's correct.
I guess what I'm going to do, Mr. Bogecko, if it's okay with the parties, is I'm going to have to take a bit of time to get that together and just make sure I got correct exhibit numbers and everything. So what I prefer to do is just after maybe we take our first break of the morning, I'll do that and then come back afterwards and admit those into the record. Is that acceptable to staff and PNM?
Acceptable to Mr. Hearing Examiner. Staff has also marked the third set of bench requests as Staff Exhibit 16. If that's any help to you, if you want to relabel it or whatever, but that's available if it pleases the hearing examiner.
That's good. And I'm not sure, Mr. Bagacco, if any of the documents that P&M issued as exhibits that are really complaints responses, I don't recall that you would be duplicating those. Is that correct?
To some extent, but if I can avoid duplication today,
Yeah,
submission of staff exhibits, I will do my best to do so.
I understand it's hard, and you know our court reporters, they've introduced documents, and there's actually it's irrelevant, but it's costs associated with, and we try to avoid duplication of exhibits. So we'll just do our best. So Ms. Padilla, is that okay if I at some point this morning I get an opportunity, I'll assemble the actual questions of the bench requests and then figure out how to admit those into the record as commission exhibits?
Yes, that would be very helpful. Thank you.
I'll do that. I just have to have time to do it. So I spent a lot of time compiling complaints exhibits for them, and that's what a lot of my time has been dedicated. So I did note there was one document that I do also want to submit on behalf of complainants as a commission exhibit, and it did fall out of order. I don't know how I did that, but I'll just figure this out right here. And this is a letter to the hearing examiner dated January 21, 21, submitted to eDocket on that date. And this document shall be admitted as commission exhibit 10, I believe, unless there's any objection. I'll have to make sure I get this correct. Okay, those are all these documents. And again, this was all the hearing examiner is doing because the complainants did not identify any of their documents they intended to submit at trial at this hearing. And I did the best I could figuring out what needed to be admitted. So, okay. With that, is there anything from the parties before we pass the witness, Mr. Ashukare, for P&M cross-examination, staff cross-examination?
Mr. Hearing Examiner, I do have one question about what P&M has marked as Exhibit 12, which is the informal complaint file. You know, I do intend to ask the complainants about some of the material in the informal complaint file. I don't know that it needs to be admitted. Well, it probably does need to be in the record. I mean, I don't know to what extent it had just having been filed in the docket is good enough for our purposes. But you know, the complainants may be able to authenticate some of the emails that they sent that are maintained in that informal complaint file. But it's, you know, it's a mixture of communications from different people.
Yeah, and this was Ms. Padilla commission. What did we start? P&M Exhibit 1, was it not?
P&M Exhibit 12.
12, excuse me.
Mr. Hearing Examiner, I don't know if it's something you'd be interested in, but I'll offer it up. If need be, if you think it's necessary, Mr. Jimenez is obviously on the line now and pursuant to your email requesting his involvement. I believe you had some simple questions for him that I suspect would be questions in terms of authenticating the informal complaint file and things of that nature. And I don't know if you're interested in taking him out of order for that specific purpose. And
yeah,
but I offer it.
Let me ask Ms. Padilla, if you mind, if I was to ask Mr. Jimenez a series of questions before you cross-examine Mr. Ashukare. Is that?
No, P&M does not mind that. Thank you.
And I believe Mr. Bagacco, Mr. Jimenez just has time constraints and he's got other stuff to do. Is that basically correct?
Mr. Jimenez runs Consumer Relations Division and he's a busy man. And
yeah, okay.
I appreciate your willingness and your sensitivity to his schedule.
No, that's fine.
You need to introduce Mr. Jimenez for the record, or will you do that yourself, Mr. Hearing Examiner?
I'll do that. Let me just verify one thing before we move forward further. And I want to just make sure I'm looking at P&M's correct exhibits and informal complaint file. Yeah, I just have it mismarked on my document. So let me fix that. Yeah, why don't we bring Mr. Jimenez in, Mr. Regecko, and then if the court reporter could swear the witness in.
Can I suggest also that everyone put themselves on mute when they're not speaking so that the background noises don't come in? And if you could please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Okay, Mr. Jimenez, how are you doing this morning, sir?
Doing good, thank you.
Very good. I have a document here in my hand. You're familiar with the case involving Ms. Leah Berg and Mr. Gary Sugaray, which is identified as case number 19-00200 UT.
Yes, it's been a while since I've dealt with it, but yes, I am familiar with it.
And do you recall, Mr. Jimenez, having a whole number of communications during an informal complaint proceeding with Ms. Berg and Mr. Sugaray? I mean, I'm just going to collectively refer to them as complainants. It's not important which one of them you spoke to. You refer having multiple email communications with the complainants?
Yes, I do.
And then those communications appear to be primarily email based, is that right?
Yes.
And eventually those emails, whether you're aware of this or not, actually were included in an informal complaint file. Maybe did you know that was the case, sir?
Yes, I do. Okay,
great. And then that informal complaint file was filed on eDocket on August the 20th of 2019. There was a notice of filing. It was signed by David Black, Associate General Counsel for the Mexico Public Regulation Commission. And that document is basically a record of all those communications occurring between yourself, Aaron Baldwin, and complainants. Does that sound correct to you, sir?
Yes.
And in those communications, you're making representations and communications. The best of your ability, do you recall that those matters were correct and true statements on your part?
Yes, I do.
Great. And so, to the extent to which this informal complaint file includes matters that Mr. Jimenez addressed with complainants, I'd seek to admit the document, and it is as PNM Exhibit number 12, unless there are any objections. Okay, great. So that document shall be admitted. And Mr. Jimenez, the questions I want to ask you are these. I'm just scrolling down to my questions. Just give me 2 seconds.
Sure.
Staff is all the way at the bottom. All right. So you and Mr. Baldwin were having communications with one another about complainants' difficulties with PNM. And I noted at certain periods of time that you were relating to Ms. Berg and Mr. Sugaray what their rights were vis-a-vis the informal complaint process and then the formal complaint process. Do you recall doing that in emails?
I believe I do, yes.
I can assure you that those documents reflect that you did inform them
Sure.
that there's this informal complaint process, and then if they wanted some other matters, then they needed to probably escalate it to a formal complaint, because the commission, and only the commission, has certain authority to do certain things. You recall generally doing that, right?
Yes, yes.
Good. And then my question to you is this. When you were communicating with Aaron Baldwin, do you recall whether or not he would have been aware, and I'm not asking you to guess, I just want to know if you know or not, whether the communications in which you're telling complainants about the informal and formal complaint, that Mr. Baldwin would have been aware that you have already informed them of that information. You understand my question?
If you could just restate it, please. That way I can make sure
Okay,
I
great. Yeah, I'll try to be very clear about this. You
Sure.
told the complainants you have a right to file an informal complaint and a formal complaint. You're having all these communications with Aaron Baldwin. Do you believe Aaron Baldwin saw you informing them about their rights for informal and formal complaints?
If I was emailing directly the consumer or the complainant, there would be no way for Aaron to know that we were advising him of the formal or informal process, or the formal process for that matter.
Did you have any communications with Mr. Baldwin about telling complainants, hey, I let them know about the formal and informal complaint process?
It's been so long ago, I can't remember exactly if I did tell Mr. Baldwin that I did inform the complainants about the formal process.
And part of the reason I'm asking the question is because I see in instances you forwarded Mr. Baldwin several documents or several communications from complainants, and then he's communicating with you, and you're sort of acting as this mediator of sorts. And what I really want to know is what does Mr. Baldwin know based on what you're telling him, and what do complainants know based on what you've shared with them, and how much you guys are sharing information with one another? Mr. Baldwin and yourself.
Well, for the most part, if I'm doing a mediation and I think that both parties need to be privy to the information that I'm sending, either one, they will have that information that I forward through an email. But I'm not sure on whether I advised Mr. Baldwin on if I did advise the complainants whether they should go formal or whether they need to go formal, or if there is if I did advise Mr. Baldwin that I did advise them of the formal process. I can't remember that, and I don't remember if there was any emails that I did inform Mr. Baldwin of this.
Okay, that's really the question I had for you, sir. That's all I wanted to ask. Mr. Jimenez, though, if you remain available for cross-examination, I would go in the order of the presentation of witnesses. So complainants, do you have any questions for Mr. Jimenez?
Mr. Hearing Examiner, Brian Jimenez was very helpful during the complaint process. I just want to stress that when I filed my complaint with the PRC, I did not know that there was a formal versus an informal complaint. At some point, I do recall when it was winding down after months and months of negotiation that Ryan Jimenez towards the end told me that I would have to take this further to the formal complaint process. And I do recall speaking with him on the phone so very long ago, and this was before I was made aware that you can't talk.
Okay, Ms. Berg, I'm not, if you could just stop, please, Ms. Berg. What I asked you was, and I'm not trying to be hard on you here, your ability to present direct testimony is limited to your ability to supply documentation that sets out your testimony. What you are now permitted to do is to ask Mr. Jimenez any questions. What you just commenced doing was to tell me about your experience with complaint. That's what is direct testimony.
Okay, I don't have any questions for Mr. Jimenez. Thank you. Thank you.
Okay, very good. And just, again, I understand you're pro se, I mean, you don't have attorneys here. The deal is when you are enabled to now ask witnesses questions, you must ask questions. When you're told you have an opportunity to ask a question, you can't then use that opportunity to begin further telling additional facts about your experience, because that all should have been, and I'm not trying to be too rigid about this. I understand you don't have attorneys, but there has to be some degree of whatever.
So, thank you, Ryan, for coming. Thank you. I don't have any questions for Mr. Jimenez.
PMM, would you like to ask Mr. Jimenez any questions?
We have no questions. Thank you.
Mr. Bogacco.
Yes, just one question. Good morning, Mr. Jimenez. How are you today?
Good morning, sir. Thank you. I'm doing good.
You are familiar with the informal complaint file in this proceeding, case number 19-00200-UT, correct?
Yes, sir.
I believe that informal complaint file speaks for itself, Mr. Jimenez.
I'm sorry, can you restate that?
Does, in your opinion, the informal complaint file that's been admitted into the record in this case as ENM Exhibit 12 speak for itself?
Yes, I think so.
Thank you, Mr. Jimenez. That's all I have, Mr. Hearing Examiner. Thank you.
Thank you.
Thank you, Mr. Jimenez.
Thank you, Mr. Hearing Examiner.
Mr. Hearing Examiner, to be clear, is Mr. Jimenez excused completely from this proceeding, or will you need him to be available later on?
You know, the only thing I would say is, you know, one of the claims we have here is the question about notice of the informal and formal complaint process. In PNM's own documents, they indicate that there's knowledge as Aaron's having conversations. He's also having, Mr. Baldwin is having conversations with Mr. Jimenez, and to the extent to which Mr. Baldwin says anything that I might ask Mr. Jimenez to come back, that would be the only circumstance I'd imagine.
Mr. Jimenez, is that doable today with your schedule?
Yes, sir. Should I just stay on
No,
throughout?
I don't think it's necessary for you, sir. If you have other things to do, please go do them, and we can just communicate with you if that ends up being a question.
And I
Thank
have
you,
your
Mr. Hearing Examiner.
Jimenez. Thank you very much, Mr. Hearing Examiner. Thank you, Mr. Jimenez. We may or may not see you later, but thank you for now. Thanks.
Thank you both.
Okay, Ms. Berg, it appears Mr. Sugar has stepped away. Is he going to, there he is.
Okay.
Unless there is any other business, we'll now turn over Mr. Sugar to PNM for cross-examination.
Okay. Good morning,
Mr.
Mr.
Sugar.
Shegare.
And let me make sure,
Good morning.
Ms. Tellez, could you please swear in the witness?
Sir, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good morning, Mr. Shegare. Can you hear me well, or do I need to speak
Yes, I can.
louder?
Yes.
All right.
Good morning to you.
Do you have PNM Exhibit 7 in front of you? That is the item that complainants filed on July 14th, 2020, entitled Documentation to Further Assist in the Formal Complaint.
No, I do not.
Okay. I will be able to share the portions of, hopefully, that I wanted to ask you about. And
Okay.
I don't have that many questions for you, but one of the things I wanted to ask about was the initial construction of your property, including the development of the well.
Yes.
Let me go ahead and share. Let's see if this works. And it didn't. 1 minute.
I saw a browser lock. You did share a screen, it just wasn't the PDF document.
I think I just need to reconnect to Dropbox. It'll just be 1 minute. Apologies. While we're waiting for me to pull up this exhibit,
I can do that for you, Ms. Berg. If you,
okay.
Ms.
Oh, I think I've got it.
Got it?
All right. Let's make sure I'm sharing. Okay. I don't know that. Okay, 1 minute.
We're viewing Leslie Padilla's screen, and then you
Okay.
have PNM Exhibit 7 highlighted. And I would think
I
if you
have
just
it
open that
highlighted, but I
document-
have, okay. There, okay, so it should open it. It's still
Windows
not
cannot
coming up.
complete.
Yeah, I'm sorry. Would you mind
Not-
sharing it, Mr.?
Yeah. I just got to pull it up on Dropbox myself. Let me get it open. PNM Exhibit 7, yes?
Yes.
And let me move my
Oh, shoot.
Zoom screen.
I'm going to stop sharing for a minute, and then why didn't it come up on my Dropbox?
Here we go. Exhibit
All right.
screen 2. I believe now they're looking at this one.
Yes. If you could go to page 10 of that document, Mr. Examiner, I apologize. At a break, I will make sure that I can actually control these exhibits myself.
Is this one?
Yes. Now, Mr. Shugri, you first, does this document look familiar to you? It was in this is the information that you submitted in response to some bench requests, correct? Actually, it was information that you submitted on July 14th to further assist in the formal complaint.
Yes, that document looks familiar.
Okay. And does this shows that you received a permit to drill a well from the state engineer in March of 2002, correct?
Correct.
Did you need electricity to operate the well once it was drilled?
Yes.
Do you remember approximately when you obtained that service, the electricity that allowed you to operate the well?
No, I do not remember that.
But was that the first service that you received from PNM at your
Yes.
property in Santa Fe?
I believe so.
Okay. So you got the water well permit in March of 2002, and then I wanted to. So that would have been the only equipment on your property at that time that would have needed electricity, correct?
No, I think we were living in our trailer at the time. We had a fifth wheel there and we had power for that also.
So you used PNM power to supply your trailer?
Yes.
Okay. When did you move your trailer onto your property?
Probably when I started construction on the guest house.
Okay. Let's see. If you could scroll down to the actually, one moment, sorry. And then at the very next slide, this is the certificate of occupancy. Sorry, just go one slide. This is the certificate of occupancy for your a resident, what you referred to as the guest house, correct?
Yes.
And that was issued in June of 2003. Do you see that at the bottom of the certificate of occupancy?
I do.
So there was a period between when the well was drilled and became, I'm not sure, I don't know that we know exactly when it became operational. Do you remember when your water well became operational?
Well, technically it was never operational. It went dry right away.
You don't use it now to serve your property with water?
No, I do not.
So how do you obtain water at the moment?
I haul water from the county.
Okay. Okay. Let me just see. Were you the contractor on the your residence, what you referred to as the guest house?
Well, technically I was not the contractor because you have to have a license to be a contractor. I was the homeowner that was allowed by the county to build his own house. So that's how I proceeded.
So you acted as the general contractor, is that correct?
I wouldn't say that. I can't be a general contractor without a license. So I did what I could. I followed the rules of the county, Santa Fe County, which allowed me to build my own house.
Okay. Would you say you did the same things that a general contractor would typically do in the construction of someone's house?
Well, I was able to hire subs to help me with the work, yes.
Okay. And you also then served the same role in relation to the second structure on your property, correct? The garage studio?
Correct.
All right. So when you initially sought, actually, let me find another document that I wanted to show you. It's actually on page 1, 2, 3, 4, 5, 6. The pages aren't numbered. Page 7 of the document that of PNM Exhibit 7.
Okay, give me just a sec. PDF page
Sorry.
7.
It's this page right here. Now, this is, it's entitled the Santa Fe County Authorization for Utility Service. Do you see that?
Yes,
And this was, it's dated April 16th, 2002. So approximately 2-3 weeks after you got the permit to drill the well, correct?
correct.
And this indicates, it says utilities are approved for, in the sort of the third box down, it says utilities are approved for, and it says a well. Do you see that?
Yes,
It does not check the box for mobile home or single family dwelling. Do you see that?
right.
So this appears to indicate that the county authorized service, utility service for only a well, correct?
Correct.
Okay. I'm going to try. I think that's all I wanted to use this PNM Exhibit 7 for. But I'm going to try to get, so I can control this a little better. Sorry. I'm going to ask you now about the meters on your property. PNM Exhibit 10 is the complainant's responses to the November 1st bench request. Do you have those in front of you?
Yes, I do.
Okay. Then actually, let me just, since you have those, I won't go to the trouble of sharing them. On page 1, again, these are responses that you submitted on December 8th, 2020 to a series of questions from the hearing examiner, correct?
Correct. Yes.
All right. Question B, actually, and since you just have the answer here, I'll explain what the question was. Question B was, when did you first become aware that a second meter was installed on the service base that supplies your structures with power? That was the question. And you responded, this is B, I don't know. I was at work and have no idea when the second meter was installed. And then the response continues a little bit. Oh, you said the double metering only came to our attention when we contracted to put solar panels on our studio. You see that answer?
Yes, I do.
Okay. But the two, you had electricity at both your residence and the studio garage the entire time those buildings have, you've used them, correct?
Say it again.
You've had electric service at your two structures the entire time those structures have been, that you've used those two structures, correct?
That's correct.
Okay. Well, this answer that you didn't know when the second meter was installed, you were at work and have no idea when the meter was installed, and the double metering only came to your attention when you contracted to put solar panels. Does that mean that over the 13 years that both meters were installed on the meter base that you never looked closely at the two meters?
I never really looked at those very closely, no.
Did you know that there were two meters there?
I think the only reason I knew there were 2 meters is because I was getting 2 bills. And I never understood why I was getting 2 bills.
Okay. But you did receive 2 electric bills from PNM each month, correct?
Yes.
Okay. And who in your household is generally responsible for paying the electric bills, or does it vary from month to month?
I never paid the electricity bills. My
You
wife
never,
did.
did you ever look at the electricity bills that you received over these 15
No,
years?
I did not. She pays her bills, I pay mine.
Okay. So you never opened any of the electric bills that you received every month for the, what, 15,
Oh, I
16
probably
years
opened
between?
them, but I didn't really take note too often. I would open them, look at them, look at how much they were, and that's about all I did.
Okay. So you did know that you were receiving 2 electric bills each month for all
Yes.
of this time.
Yes,
And you said that you did sometimes look at the amounts.
correct.
Okay. Did you ever look at the bills more carefully than just looking at the bottom line, the amounts?
No,
You never did. So were you aware that you had 2 different electric services?
well, I assume so because I had 2 different bills.
Okay.
But I never understood why I had 2 meters.
Okay. Were you aware that the 2 services were billed under 2 different rate classes?
Not until we were informed by a third party that our rates were different. I did not know that. I never looked at the rate. I just paid the bill, or my wife paid the bill.
Okay. Let me just see. So I think you said you knew vaguely that you had 2 meters, but really the only reason you knew that was because you knew that you were receiving 2 bills, correct?
I'm unsure of that.
You're unsure of which part of that?
Please state that again, please.
So you answered my question earlier when I asked about the presence of the 2 meters on your property, and I think you said that the only reason you were aware that there were 2 meters was because you were receiving 2 electric bills.
That's correct.
Okay. In your work as the I don't know what to call it, in the work that you did to build your home, did you you designed, I believe you did answer some questions actually about the design of the electrical in your homes. You designed the electrical in on your property, correct?
Well, we live on a piece of property that is solid rock, so I had to lay out the paths of the utilities. Yes, I did. I used several people to help me with that. So I would spray paint them on the ground, and then we would blast or rock hammer those trenches. Yes.
Okay. Then did you then outline the paths to the meters that served your property?
Well, the first thing we did is we blasted to put in the transformer. And then my electrician came in and he tapped into the transformer and set the meter path. And then from there, I outlined where roughly I wanted the lines to go.
Okay. And was that with regard to both the residence, the guest house, and your studio and the garage that came several years later?
Yes. We did the guest house. Well, we did the well first, then we did the guest house, and then we did the studio.
Right. So you say, I think in this set of bench requests that we're looking at, that you designed the home and studio. You said, and I'm quoting from one of your answers here, I had a homeowner's permit that allowed me to build our house, and this was the first house I had ever built. And you actually, that's just what you were recounting for me, correct?
Correct.
So when you designed and built the studio, actually, when you designed and built the residence, your guest house, what was your thought process about how it would be served with electricity?
I relied on my electrical subcontractor to help me with that. So
And who was, I'm sorry to interrupt, who was that electrical subcontractor?
his name was Don, and his company was called Don's Electric.
And then with regard to the design and construction of the garage and studio, what was your thought process about how that structure would be served with electricity?
I allowed, I don't know what you mean by the thought process of electricity.
Well, I'm just at you designed it and you constructed it. So I'm just kind of asking you what to, how did you anticipate in your planning of the building that it would be served with, if you could let me finish, how did, what were your thoughts about how that structure would be served with electricity since you were designing and building it?
I drew a line on a piece of paper going from the meter to the studio, and that was my intent on how that was going to be run.
So from the meter to the studio, so the meter that served the studio was the meter that serves the well, correct?
I assume so.
Well, let's not assume. We know, correct, that the meter that serves the well is also the meter that serves the studio garage, correct?
I'm not sure what meter served what building.
I know that, Ms. Padilla.
We're
No,
hearing from
Ms.
Mr. Sugar Ray, Ms. Bergen, and let me just say something for the record. When questions are asked, you have to wait for the end of the question before responding, Mr. Sugar Ray. And the reason that is so is because the court reporter cannot have two people speaking at the same time because that cannot be transcribed accurately. So attempt the best you can to wait till the question is fully asked before responding.
Understand.
Okay. So I think what I was just asking about to kind of get the baseline of information here that's kind of important to this, to your complaint. And that is that the meter that serves the well is the same meter that serves the garage and studio. You just expressed some uncertainty about that. Is that right?
I'm not sure what meter goes to where, to be honest with you.
Well, have you, Ms. Berg, I'm still asking Mr. Sugar Ray questions here. In the course of this complaint, the back and the different submissions that PNM has made, that you and your wife have made, that fact has not been clear to you, that the meter that serves the well also serves the garage and the studio?
Well, now it is, but when I laid out all this stuff, I have so many conduits in the ground, I can't remember which one goes where.
Okay. I'm sorry, you have so many, I missed the word there. You have so many what?
Conduits. I have conduits in the ground. I have spare extras, things for future buildings. And when you look at the meter, there's so many pipes going into that. I don't remember where they went. It's been 20 years.
That's kind of why I was trying to ask what the intent was when you designed the home and studio. What were you intending?
Build a main house, a guest house, and a garage. That was my intent.
Because we looked at that Actually, are you familiar with your request for electric service? That it's in the record. I can find that if we need to look at it. But Ms. Berg has submitted a portion of that, or the complainants have submitted a portion of your request for electric service back in 2002. Do you recall that initial request for electric service? You may
Yeah.
recall because, yes, because there was a line extension.
Yeah, I met with the P&M and I think I filled out that paperwork and
Okay.
that was when they installed the transformer.
Okay. And that was the initial, your initial electric service that initially was intended to serve the well, correct?
Correct.
And then when you built the residence and completed construction of the residence the second year, do you, actually, let me just find my questions on. At some point, do you recall a second request for electric service from P&M to serve your residents?
No, I do not.
Do you have any records of requests to P&M to serve your residents?
I may or may not have those. I haven't seen them in a long time, so I probably have forgotten if I have.
So have you also forgotten that a second meter was installed at that point to serve the residents?
Well, was it installed for the studio? I don't remember.
No, the residents, because when your home was constructed and you received the certificate of occupancy in June 2003, at that point, well, maybe you don't recall, and if you don't, that's a completely fair answer. Do you know whether that at that point, whoops.
Well, if you have the documentation and I've signed it, then I must have done that, but I do not recall.
Okay. Let's see.
Ms. Padilla, is it possible, can we just take a 5-minute break so we're going about an hour and 45. I need to myself had a lot of tea this morning, so I'm wondering
Certainly.
if that would be acceptable. So we'll just break for 5
Certainly.
and why don't we come
Okay.
back at, what is this? At 10:50.
Okay. Thank
Okay,
you.
thank you very much. Ms. Tellez, are you there?
Ms. Padilla, were you asking me, Mr. Hearing Examiner?
No, I'm trying to just make sure where we should go back, but I just want to make sure that our court reporter is present before we.
Okay.
I'm here.
There we go. Very good. So we just took a 5-minute break there. We'll go back on the record.
Okay.
And Ms. Tellez, can we proceed?
Yes.
Good. Ms. Padilla, please resume.
Okay. Thank you, Mr. Hearing Examiner, and I do think I can control sharing of some documents. So I'd like to show Mr. Echegaray PNM Exhibit 8. You may have this because that is the July 13th bench request answers that you filed, Mr. Echegaray. Do you have that? Hopefully we'll be able to show that on the screen here.
Is that the third set of bench requests?
No, it's entitled 7-13-20 bench request answers. I
No,
think
I
you
don't have
filed it on July 28th, 2020.
I do not have that.
Okay. I should be able to share and no, it's not going to the. No.
Do you want me to do it, Ms. Padilla?
Yeah, yes, I'm sorry. If you wouldn't mind.
It's okay.
It's PNM Exhibit 8. And I'll be looking at the page 9 and 10. It should be on page 9 and 10.
This is what we're looking at?
Right there. Here we are. Mr. Echegaray, do you see what's on the screen?
Yes.
You submitted this as part of the your responses to July 13, 2020 bench requests. Now, you said earlier that you didn't look carefully at the PNM bills that you received for all of these years, 15, 16 years, correct?
Correct.
But I just wanted to show you these two bills. This is your bills for your two services from June 2009. You see that, correct? They're dated June 4th, 2009?
Yes.
And the service address on the first one, the top one, states 19 San Marcos Trail Special Well. I think that's what SPC stands for. You see that?
Yes.
And then the second bill says service address is 19 San Marcos Trail SPCB.
Right. I see that. I don't know what that means, but I see it.
So you don't know what the top one means, well, when it says well, you don't know what that means?
The other one, I didn't know what it was, no.
Okay. Does this not indicate to you that the two bills were for different services?
Yeah, it looks like it, yes.
Okay. Now, I don't know exactly what would have appeared in the address window. I'm assuming, though, the service address would have appeared in the address window. I mean, do you think that's a safe assumption?
I don't know.
Okay. But in any case, you it's your position that you didn't look at the bills carefully enough to know that these were for two different services?
No, I did see that one was said well, and the other one was, I guess, specials B. I did notice that, yes.
Okay. Oh, so you did have some knowledge of what these two bills were for.
Yes.
Okay. Well, that seems inconsistent with your statement that you only knew about the two services.
No,
And
I
your
knew
two
about
meters.
services, but I didn't really know we had two meters.
Okay, so you knew that you were getting two bills, correct?
Right.
Did you ever call PNM to ask why you were getting two bills?
No.
Did you ever ask a neighbor whether it was something that whether they received two bills?
No, the only time I was really looked at it is when somebody told me that we were getting charged two different rates. So then I took notice of that.
Okay. Okay, we can stop sharing this now, Mr. Hearing Examiner. Thank you so much. I did want to ask the last question was about the solar that the solar panels that you installed on the garage and studio, correct?
Right.
And in some of your bench request responses, you have explained, if we need to go there, I can, but I think I can just ask some general questions. In some responses to your bench request, you have explained both that you didn't know about the two different rate classes that you were being billed at until the solar company came to I guess give you an estimate quote on what your the solar project would be. Is that correct?
Yeah, that's correct. They actually didn't even talk to me. They talked to my wife, and she informed me of the different rates.
Okay. Could you just explain a little bit about what the solar installation looks like on your property?
We added 12 solar panels to the studio. And the work was performed by Positive Energy. They did all the work for.
Oh, why did you decide to put the panels on the studio rather than the residence/guest house?
I can't remember why. I think it was probably easier. I don't remember.
You said you think it was probably easier?
Yes.
Okay.
It has a bigger roof area. So I couldn't get 12 panels on the small house. It's too small to put 12 panels on the guest house.
Okay. So you're able to put a larger installation on the garage studio because it has a larger roof space.
Yes.
Okay. But then, and this is according to some of the bench request responses that you submitted in March, then it appears you realized, well, let me just actually say what the bench request says. The only way that our solar credit applies to any and all electricity we use is to have one PNM meter rather than two. So I think that what that means is you realize that the solar production from the rooftop solar panels, that credit applies only to the electricity that's metered on your studio, correct?
Correct.
Okay. And you're not then able to use any credit. Your bench request responses refers to, over 1,200 kilowatt hours in the bank, and that you can't apply that to electricity that's being used from your used at your residence that's under the other service, correct?
That was what my wife told me, yes.
Okay. What was the solar panel when you installed the solar on your garage and studio? How did you size that?
I had Positive Energy size that for me.
Okay. Did they size it based on the usage of your garage and studio only? Do you know?
I'm not sure. So, you know, I was planning on adding solar to the guest house also. So,
Okay. You're not
and
sure.
I do have a permit for that.
What was that last thing? I'm sorry, I didn't hear you very clearly.
I do have a permit from PNM to install 8 more solar panels on the guest house.
On the guest house. Okay. Okay. All right. Mr. Sugar, thank you so much. I think that's all the questions I have for you. I appreciate your time this morning.
Thank you.
Very good. Mr. Bogacco, your opportunity to cross examine.
Thank you, Mr. Hearing Examiner. I'm going to try to get this share screen option to work here. You'll just permit me a moment. Excuse me, Mr. Hearing Examiner, I'm having some technical difficulties here.
I'm looking at your screen share. It's looking at the answer to the third set of bench requests.
Thank goodness, because it's not giving me any positive indication my end. So thank you for that.
Sure. No, I think it just surrounds the screen in like some color, I think is all you'll really see, but whatever.
I've got 2 screens and I believe it's working though. So if you can see it, that's perfect. Mr. Ishigure, if I may, I'd like to direct your attention to what's been marked as, excuse me, PNM Exhibit 11, which consists of the complainant's answers to the third set of bench requests that you filed on March 4th, 2021. And I'm going to scroll down here to page 1 of that document. Are you able to see that, Mr. Ishigure?
Yes, sir.
Okay. I understand that Mr. Hearing Examiner will be admitting the third set of bench requests into this proceeding as a separately marked exhibit. And in the interest of not running up the bill with our court reporter, who is terrific, by the way, I'm going to let that happen. But as we discussed earlier, one of the problems that we have in making a record here is that the complainants did not duplicate the questions contained in the third set of bench requests and their answers, and that's fine. But with that understanding, I'd like to review a couple of those with you. I direct your attention to, there on page 1, in answer to question 4 of the third set of bench requests, you say, "I don't know, we relied on the electrician." Do you see that, Mr. Ishigure?
Yes, I do.
Thank you. And I'd note that throughout this page, there are multiple references to a quote unquote electrician as well as a quote unquote electrical subcontractor. For example, down there on your answer to question number 8, you say we relied on the electrical subcontractor. Do you see that, Mr. Ishigure?
Yes, I do.
Now, it's my understanding that the electrician and the electrical subcontractor referenced throughout your responses to the third set of bench requests are one and the same. Is that correct?
That is correct.
And so when we talk about the electrician and the electrical subcontractor, am I correct in understanding that you're talking about Don's Electric?
Yes, sir.
Thank you, Mr. Ishigure. What was the last, when was the last time that Don's Electric set foot there on your property over there at 19 San Marcos Trail?
I could not tell you. It's been a long time, 15 years.
Thank you. And do you think that the last time he was on your property was probably in connection with the so-called studio building on your property?
No, I think he was in connection with the guest house.
Thank you. Now, when we look back at your answers to question 4 of the third set of bench requests, I'll warrant to you that, let's start with answer 4A. Do you see that where it reads, I don't know, we relied on the electrician? Am I reciting that correctly?
Correct.
And I'll warrant to you that that answer is in response to the following question from the hearing examiner's third bench request. Page 3, paragraph 4, first bullet point. He says whether he planned from the beginning to run power to both the well and studio on one supply route. Is that correct to your recollection, Mr. Eshugare? I'm sorry, I keep mispronouncing your name.
Is what correct?
Okay. So am I correct in understanding then that when you say we relied on the electrician, that is it Don's Electric then that did the planning in regards to the electrical supply routes for the electrical needs of your property there at 19 San Marcos Trail?
Well, honestly, I think we both sat down and tried to figure out the best route to run this stuff. Yes, I worked with him on doing that.
Okay. So then moving along, back to page 3 of the third set of bench requests, paragraph 4, second bullet point. The next question is whether he planned, and when it says he, I believe this question is directed to you, Mr. Eshugare, just for clarity. It says whether he planned from the beginning to run power to the guest house and the home. Complainants have not yet built from another and independent electrical supply route. And then turning back to your answers to those third bench requests on page 1, your answer at 4B says, I don't know, we relied on the electrician. So is your answer that you relied on the electrician as set forth in your answers to the third bench request? Is that still correct?
That is correct.
So then when we move down to example, let's go to 4D there on page 1 of your answers to the third bench request. And I'll warrant that the question that triggered that answer found on page 3 of the third bench request is as follows. It says, why is the studio not on the same supply route that serves the other residential building, i.e. the guest house, and who made that choice and why? And your answer, which is contained on answer 4D of your answers to the third bench request, reads as follows. I don't know, the electrician, I don't know. Am I reciting your answer correctly, Mr. Eshugare?
I think let me look at that again. I think the electrician made that determination.
Okay. And once again, when we say electrician or electrical subcontractor in the context of this discussion and your answers to the third bench request, we're talking about good old Don's Electric, correct?
Yes, sir.
Thank you for that. Then moving along, let's see. I'd like a little more clarity on another one of your answers. Let's move along to answer number 6 there in PNM Exhibit 11. And answer number 6 is submitted by you in response to this question contained in the third bench request found on page 4, paragraph 6. And it says, Mr. Eshugare, did you hire an electrical professional or other construction professional to install the 2 sets of equipment that house the 2 meters PNM supplied? And your answer there in PNM Exhibit 11 on page 1, paragraph 6 says, we relied on our electrician and PNM to provide us with the most economical system possible. Is that answer still correct, Mr. Eshugare?
Yes.
Now, still focusing on answer number 6, what do you mean when you use the word relied? Excuse me, I've got, check for a moment. I'm sorry about that. Bear with me if you would for a moment. I've got too many dogs. I'll be right back.
Sure, it happens. The Zoom world.
Sorry, this is the perils of working from home. Are you still hearing me?
Yes.
Yes, sir.
No
We're
problem.
talking about answer number 6 contained in PNM Exhibit 11 on page 1. And I was asking Mr. Sugaray what he means exactly when he uses the word relied in that answer.
Well, I'm not an electrician or electrical engineer, and I relied on my subcontractor to give me the best advice.
Thank you, Mr. Sugaray. And then moving along in that answer, where you say provide us with the most economical system possible, what's entailed in your use of the word economical in that answer?
Most efficient, best rate.
Thank you, Mr. Sugaray. And so then based on that answer, isn't it possible then that Don's Electric communicated with PNM about the nature and configuration of the electrical system on your property? Is that fair to say, Mr. Sugaray?
That's a possibility, yes.
Okay. Now going back to, I believe, down there on, still on page 1 of your answers to the third bench request, paragraph 12, and that is in response to the third bench request question number 12 on page 4, which reads, when did you first learn, stating the month, year, and day if possible, that you were paying a commercial rate for the meter that serves the well and studio? And your answer to that is set forth in PNM Exhibit 11 on page 12, states, I first contacted PNM about the incorrect billing on 9/7/2018 and spoke with Burl. When the solar company informed us that we were not billed in the residential rate class, but in the commercial rate class, I called PNM immediately. Is that a correct recitation of your answer there on page 1, paragraph 12, Mr. Sugaray?
I did not answer that question. My wife did.
Your wife
Yeah,
did.
so let me just, I think Mr. Sugaray answered several of the questions, but Ms. Berg answered this one, Mr. Bagacco. But I think Mr. Bagacco, if you want to ask Mr. Sugaray these questions, if Mr. Sugaray doesn't know the answers to these questions,
No, I
you
do
can say
not.
so, but it's a fair question.
Fair enough. Mr. Sugaray, if you have knowledge of the communication between your wife and the solar company regarding this situation, please answer. If you don't, it's sufficient to say you don't know and to defer that question to Ms. Berg.
I would like to defer that question to my wife, Mrs. Berg.
All right, very good. Thank you, Mr. Sugaray. All right, I'm going to stop share for a moment and then switch gears a little bit here, if you'll just bear with me. All right, do you have a document showing up on your screen at this moment?
No.
I don't either.
Let me try again. There we go. How about that?
Yes.
All right.
Yes.
Mr. Sugaray, I'm directing your attention to an email from Ms. Berg, but the way it's configured, it's put in the terms of we. Do you see that, Mr. Sugaray?
Yes.
And this is not something that's been admitted previously. If I've marked it as Staff Exhibit 15, labeled as completing agreement to PNM settlement terms. Do you see that down at the bottom, Mr. Sugaray?
Yes, sir.
Do you also see up at the top that it has a notation that reads Attachment A?
Yes.
And then we can source this document by the footer down at the bottom left, where it's part of an order identifying deadline for joint motion to dismiss and extending deadlines for complainants' responses to third set of bench requests. Do you see that, Mr. Sugaray?
Yes, sir.
Okay. Would you please read that email into the record, Mr. Sugaray?
This is the first I've seen of this email, and I would like my wife to read it.
No, Ms. Bird is not testifying right now, Mr. Sugaray. If you can read, you can read it.
We would like to settle this case. We will agree to the proposal set forth on that date by PNM. If you disagree with our assessment to settle, I would like to request 1 week extension in submitting the answers for the third and final bench request. Thank you, Leah Bird.
Mr. Sugaray, did you, the complainants, end up settling this case?
I don't know. This is the first.
I'm sorry, I didn't hear that answer.
Yeah, I heard a chime too. Could you respond again?
This is the first I've seen this, and I do not know.
Fair enough, Mr. Sugaray. Thank you. Mr. Hearing Examiner, that's all I have for the complainants, given the robust record we have in this case. And everything else, I won't belabor the point any further, so I would pass the witness to Mr. Hearing Examiner. Thank you.
Sure. So I have some questions, Mr. Sugaray, for you, sir. And I want to just have my screen. If you see me not looking at you, it's because I have other screens present that I am, in fact, examining you as you answer. So why is Don's Electric not submitted testimony in this case, Mr. Sugaray?
I do not know.
Did you ever reach out to Don's? If you don't know the answer, that's fine, Mr. Sugaray. To your knowledge, did either of you ever reach out to Don's Electric to present any evidence in this case?
No, I believe he is not in business anymore, but I am not sure.
Okay. And am I? You've answered several of Mr. Bogaco's questions by answering that you don't know. And I'm not criticizing you. I'm just acknowledging that in fact was your statement. Yes.
Yes.
And I assume the reason why you say you don't know is because this was 15 years ago. Much of this discussion was really matters that are effectively kind of ancient. It's kind of like not entirely true, but it's a long time ago.
Yes.
Do you understand the commission has rules that indicate that the amount of time that you can protest rates goes back a single year?
No, I did not know that.
Did you know that? Do you have a guess as to why we would have that rule?
No.
Does your not knowing much of the answers to the questions you've been asked give you any indication of what the answer to that question might be?
I don't understand the question.
In other words, you don't know a lot of this information because it happened so long ago. Is that maybe the reason why we only allow people to test what goes back for a single year? Because otherwise, who knows what the real reasons were for anything?
That makes sense.
Right? I mean, in some sense, the onus is on the complaining party. I'm not making up a rule. This is just the rule. It says you can only go back for a single year. And one of the reasons why that rule exists is because once you get beyond a year and go back 15 years, all the way back to 2002, we're simply not going to have answers for a lot of the problems that may have happened, which caused billing increases that someone might protest. So for instance, if I was in 2051 to say, I don't like what happened in 2021, should I be able to do that?
No.
It's just difficult. It's not because we don't credit PNM and believe them only, or that we disbelieve complainants and people who feel something wrong was done. It's because after a certain point in time, we cannot establish what occurred and who is to blame. Does that make sense to you?
That makes sense.
Okay. When you said earlier that the well died almost immediately after you began utilizing it, Could you be more specific? When exactly, how long did the well function?
Probably a matter of days. And then it comes and goes. As we get more moisture, the water table comes up and I'm able to use the well. But for the last 5-6 years, there's been no water out of the well.
So the power that's been utilized for the second, I mean, in my mind, when you guys had the well and the studio on one, I had this idea that, well, it's the well and studio takes the power from that one, meter, and like that's where all the use is going there. But if I understand you, does the well draw power even if there's no water down there, or do you guys turn it off, or how does that work?
No, the well does have a booster pump in it. So that's so what I do is I have a storage tank next to the well, and in the well pit there is a underground storage tank and a booster tank, and the booster tank is what pumps the water to the house.
I see. So you're still using the pump for the well, but
Yes.
It's not drawing from the ground, it's drawing from a source that you supply yourself.
Yes, I've actually turned the well power off, and I'm only using, the heater, there's an outlet, and the pump inside the well pit.
Okay, so it's not like all of the components for the well are turned off, just one component. Is that?
Yeah, the one component that goes down into the well, that motor is shut off.
How soon after did you install all this subsidiary equipment to function the well really quickly after the well was installed, or what was the story with that?
Well, the well people installed it, then I've had it upgraded several times, and I've had the water checked. I broke the motor. I've had lots of work done on that well.
Do you know what the power of the motor is?
I think it's a horsepower, maybe a horse and a half.
Okay.
And then the booster pump is a pretty good sized pump, and it probably uses some power.
So in essence, the usage we see on the meter that feeds the well and studio, that power is drawn for purposes of producing water for you guys, even though it's not coming out of the ground. I mean, I kind of said that already, but I just want to confirm that's a correct statement, right?
That's correct.
Okay. You also testified that the studio or the garage, I mean, I think it's as easy as to call it the studio because we all been using those words. You say that's larger than the guest house you built. And I know there was a main house you planned on building, but the studio is larger than the guest house. Is that right?
That is correct.
By how much larger is the studio?
Oh, 100, 150 square feet, maybe.
Okay, not substantial or anything.
Not much, no.
And is the plan still to build the main house? Is it still in the cards?
I don't think so. Not with what's been happening here. No, I may not build that.
Okay. So you're an estimator for a commercial builder, is that right?
Yes, sir.
Can you give me a better sense as to exactly what that means? Like, what do you do and how do you do it?
What I do is I receive plans from different developers or owners. I review those plans and then I put numbers to those. So for each item, for example, drywall, sheetrock, concrete, earthwork, electrical, mechanical, I put all that together and then we will submit that to the owner for approval.
And if you're saying it's an estimator for a commercial builder, are the plans and stuff you're looking at, is that like for malls and like restaurants, banks, or what is the?
Yeah, it would be restaurants, churches, things like that.
Okay. And are those jobs, I mean, is it true that like commercial work would be potentially more complicated than residential, or is that not true?
It could be true.
Does it depend on the project? Is that the idea?
Yeah, I mean, the commercial is usually more complex than residential.
Because you're just trying to achieve lots of stuff. I mean, houses are pretty straightforward. You have one source of heat, one source of power, and maybe in a commercial space, you got to break it up. Is that the idea?
Yeah, or it's a remodel. When you do a remodel where you're demoing and rebuilding and trying to add on, it gets complicated.
So in your line of work, you have to have no knowledge of construction practices, I assume?
Yes.
Would you agree with me if I said that your understanding of construction is above average? And by average, I mean suppose you could use the average homeowner who calls a plumber to turn up the heat on the thing. My mom has done that. It's sort of embarrassing. Frankly, she threw money out the window. All she needed to do was turn a dial. I mean, let's not use her. Let's assume a person of average ability of construction. You're above that person, I assume.
Well, I've only been doing this since after I built my house. Before that, I was a urban planner and I worked in Denver. So that's my background. And when I moved
Okay.
here, I changed careers and I've been learning the estimating and project managing aspects of my job ever since. So I
So
did
when
not
you-
have the background back then, but I do have it now.
Okay, so when you said in your bench request response that this was your first house you built and you didn't really know what you were doing, I'm guessing that the answer you just gave me there is that this was at a time that you were doing this construction when you were sort of new to reading plans. Am I understanding your testimony correctly then?
Well, I knew how to read plans, but I had never built the house and I had never dealt with the electrical, the plumbing and mechanical aspects.
But you felt comfortable enough that you felt, I can figure this out.
Well, it was something I always wanted to do. So I did figure it out. Whether it was the right way is debatable.
Okay. So Ms. Padilla drew your attention to the certificate of occupancy earlier, and that indicates on the box where it says who is the licensed contractor, and you had indicated yourself. You even though I know you're saying technically you're not a general contractor because you have to have a license to do that. You served as the general contractor as is permitted by the County of Santa Fe.
Yes.
And you hired, you said subcontractors, one of whom I understand was a licensed electrician, Don's Electric. We just heard that discussion from Mr. Bogacco. You hired other professionals to work on the house as well?
Yes, many.
Many? And those individuals were all specialized. So for instance, you got the well drillers to come do the well.
Yes, sir. Then I had a mechanical, I had a plumber, I had an earthwork guy that blasted the trenching. I had painters, carpenters, roofers, framers, all that.
The whole nine. Okay. So as and I don't, maybe you can answer this question for me. Is the general contractor required to obtain permits for work, or is it something that under your understanding as a GC, or you sort of function in that role, were you concerned with permits, or were you letting the subs get permits?
Well, it's my job to get the general permit, and each sub, for example, the electrical sub, the mechanical, and the plumbing sub, they have to pull their own permits. So I relied on them to do their work. I didn't look over their shoulders.
Okay. Do you know if the electrician that you hired obtained permits to do work that required permits?
I hope he did.
But you never had that conversation with him? Did you ever say, hey, where's the permit for this?
I had just assumed he was going to pull his permit. That's his job. That's why I pay him.
Okay. So, okay, let's just stay there for a second. So when the testimony from PNM in this case is that in order to install a meter, you first have to have the equipment that houses the meter. And in order to have the meter inserted and electrification to occur, that has to pass a permitting process. That they just do not show up at places and be like, oh, here's a meter and a whole bunch of voltage. Like that's not going to happen. That in fact, there had to have been a permit obtained for the enclosure that includes that meter. Do you have any reason to doubt that testimony, sir?
I do not. I agree with you. There should have been a permit for that.
And do you know whether there was a permit?
I do not.
And Don's Electric never presented you a permit?
No, he's not required to. He's only supposed to provide, he has to provide his own permit, just as the well guy does and everybody else.
You were never privy to any conversation. Well, I'm going to put it as a statement. Were you present for any conversations Don's Electric had with PNM?
No.
You relied on Don's Electric to communicate with PNM for you?
typically on all my projects, I rely on my subs to do their job.
But you had indicated a moment ago that you hadn't been doing a lot of this work, but at the time you were doing your house.
That's
So-
true.
But so you just said, hey, Don, you're doing this work. I'm not going to deal with it. You figure it out. It's kind of the way you treated this.
I don't know if that's true. Yeah, we discussed what we wanted to do and he did it.
Did you ever think about suing Don's Electric?
No,
You think it's Don's Electric fault for you guys having maybe 2 meters?
it's a lot of people's fault. I blame myself. I blame Don's Electric, and I'm upset with PNM too, and of not informing me. I don't know why I have 2 meters. No, I'm not going to sue anybody.
Okay. What year did you guys buy the Rancho Alegre property?
2001, I think, somewhere around
Okay.
there.
So shortly before the well goes in.
Yes.
Did you come up with the plans for the design before you put the well in? Like, was it all figured out? Like, hey, here's what we're going to do, and now let's put the well in.
No, I think we did the well. We got the homeowners association to allow us to put our 5th well on site, and then I started working on the plans.
Okay, so I own a lot myself right now, and the homeowners association I have is like, they don't allow you to go live there until the house is built. But you didn't have to submit the homeowners association the plans for what you intended. You guys could go live there and then come up with plans?
Yes, we lived there, came up with plans, and once I finished the plans, I submitted them to the homeowners association for approval.
And did you make the plans entirely on your own?
Yes,
Okay. The well was installed in 2002. I don't think you dispute that. I mean, that was, we saw the document earlier that Ms. Padilla directed you to. I believe it was
Yeah.
March of 2002, right?
correct.
That was the Office of State Engineers documents. When you were planning the well, did you? I know there was the drawings, and was that your choice as far as where the trench was going to go?
Well, when we drilled the well, we relied on our well driller to pick the spot. He witched it, and then once that was drilled, then we went with. I think we installed our transformer, and then we ran the power to the well.
Okay, and I know if I'm thinking correctly now, I believe when Ms. Padilla was talking about that, I think you said that you and Don, or if there is a Don, whoever the person was in charge of that business, you guys collaborated in terms of determining where the trench was going to go. Is that
Yes.
right?
Correct.
And sorry, go ahead.
Yeah, you're right. Yeah, we
Okay.
both figured it out.
So when you were doing the trench, had you figured out like, okay, well, hey, we've also got to think about where the guest house is going to go, where the studio is going to go, where the main house is going to go, and this trench has to serve all those things. Did you guys think about that when you're doing this?
I think if I can remember, I think what I did is I just put more conduit in the existing trench we did, and then when we added them, the additional structures we would tie off of that and extend them to the different buildings.
Okay, so you were loosely planning. I mean,
Yes,
I'm obviously I'm editorializing, but you're loosely planning for all the structures when you're digging that trench.
correct.
Okay, and so when you reached out to PNM to ask for new residential service, this is to get the well up and powered. Did you, to the extent that you recall, do you communicate just about the well, or did you talk to them about the full plan?
I don't remember. I know I met with PNM and we talked about the transformer. That was probably the only time I met with PNM, and they told me where I had to put the transformer. So I had my dirt work contractor trench that for me. So that's the only meeting I think I had with PNM.
And I'm asking the question because, Ms. Padilla brought up a document earlier and she noted to you, hey, look, this only has the well thing checked. There's no check mark for house or whatever other things are there. And I'm wondering, is it possible that when you spoke with them, that you said, hey, I want to put a well in, I need well service. And so therefore the only thing that gets checked is the well.
Possibly.
So once the well is in, you all then transition to work on the guest house, right? That's the next step in this process.
Yes,
And did you use power supplied to the well to use that for construction purposes?
yes.
Did your subcontractors tie into that for power?
I believe they did.
And as the construction of the guest house was going on, you're functioning as a GC, but you're relying on your subs to do the work. I mean, is that more or less correct?
That is correct.
Did you do any of the framing?
No,
You hired framers to do that?
yes,
And Don's Electric, they did the electrical wiring for the guest house?
yes.
And do you recall when do you have any recollection of the time when it came to provide power to the guest house?
No,
I mean, that must have been a somewhat critical moment because you guys are living in a fifth wheel, you've built the guest house, and then at some point it's like, okay, we got to power this thing. And I assume you're going to be planning to live in there because that's what you ultimately did. And you never built the main house, and this guest house basically became your home. You don't recall that moment in time when the power for the guest house comes?
are you looking for a date?
Yeah, I mean, or just generally recalling the circumstances that lead to the powering of the guest house.
I think that was up to my electrical subcontractors to power it up and then request a meter.
Okay, so you just said to request a meter, and I guess that's kind of the crux of the whole thing, because this is where the problem starts, right? Like
Yeah.
the guest house power becomes the second meter that now you folks said is wrongly installed. And I really want to know how that happens, where the well exists, it has power, and rather than extend the well power to the house, and I guess you've told us many times now, you just don't know how that happened.
No, I do not. I wish I just had one meter.
Right, so my question to you, and this is why I asked right when we started this conversation, why isn't Don's Electric here? I know you indicated maybe they're not in business. Do you have any idea? Are they in business?
I have no idea.
Were you guys ultimately dissatisfied with Don's Electric? Is that why you're using another electrical subcontractor?
No, I was not. I think when I think as I recall, he was moving after my job, but I'm not sure. I don't remember exactly.
You don't recall. Okay. So it's that
I couldn't use him.
P&M's. You go ahead. No, you talk.
I couldn't use him for another job because I think he left town. But I
I
don't
think you left
remember.
out. Okay, because P&M's position here too, their testimony is very clear. Is they also could not have installed a second meter unless the request came from the homeowner. That they don't show up on people's property and just put meters in without request or authorization to do so. So somewhere, I mean, do you contest this? I mean, does that strike you as a correct statement on P&M's part?
I don't believe I requested the meter. I believe my electrician requested the meter.
Okay, so you think it's a possibility that Don's Electric, if it's true that P&M is not just going to show up in the dark of night and give you a meter, somebody requested this thing, and you admit that it's possible that Don's Electric did that.
Possibility.
And we don't know because Don's Electric is not present and has not provided any testimony.
Correct.
Do you guys make any effort to communicate with Don's Electric?
No,
And I should say, guys, I'm gonna say no more specifically. Did you, Mr. Sugar, because I'll ask Ms. Berg the same question later, and I did hear your answer was no. So I just want to clarify for the record. Okay. I think we've exhausted that subject. I think we got where we needed to go there. You're not, I mean, where is the picture? I think this is Mr. Sidler's testimony. If we can pull that up, I want to look at, just give me 1 minute. I got to find something and then I will, here it is. I'm going to show you something. This is Jack Sidler's direct testimony. It's the photograph. I don't think we've had an admission of that document yet by staff. Am I correct, Mr. Bogacco, about that?
We have not moved that in yet, Mr. Harrington, but we do have it available.
Sure. And I just want to, for the record purposes, Mr. Bogacco, I'm sure will move in Mr. Sidler's direct testimony later on in these proceedings, but let's just so for purposes of whoever's listening to this in the future knows what we're talking about, it's Mr. Sidler's direct testimony and it's PDF page 7 of 14, if that's sufficient for identification. Now, let me share my screen here. I don't want to share the Zoom. I don't know what happens if you share the screen, Zoom is open on it. Seems like we'd go into infinity. Anyway, this is the meters, is that right?
yes,
Is it your testimony? Has this existed in this state since basically forever?
I don't remember if there was always like that. It's been, yeah. I don't know if they were both there or just one was there at the beginning. I don't remember.
I see, is that your house on the back on the right? Like there's only a tiny bit of like structure. Is that where your house is?
Yes,
That's your house back there?
yes.
And do you go by these things when you come in and out of your house, or how does that?
They're very unsightly. They're very unsightly.
Okay, so you see them coming and going from your home.
Yes,
Are you testifying today that you didn't know these two things were there ever since they were there?
I never noticed that. I didn't pay any attention to that stuff.
I mean, it's giant, right? It's look at the size. I mean,
Yeah.
these are big things.
Yes, they are.
So, I mean, is it fair to infer that you must have known that these two things were there whenever they were installed?
There's actually another meter on the other side, and there's going to be 4 meters. So
Why would there be four? Why is there going to be 4 meters?
you have to have another meter for the solar power.
Okay. I have no ability to evaluate if that's true or not. I'll just stop showing this picture. That's
Mr. Hearing Examiner, can I ask you a question? Not yet.
I guess the answer is it depends. If it's going to be an attempt to testify, then no, you should have testified. This is an opportunity for me to question you. If you have a question related to no, I don't think no. I think the answer is no. I think if you want to make a point, you can later in the context of speaking with Mr. Sidler about these pictures, or, you know, I know Mr. Sidler, for instance, testifies, obviously you guys wanted 2 meters and you have them, and that's just your problem. If there's a proposition you wish to establish about these meters, you may do so later when questioning Mr. Sidler. Does that satisfy you, Mr. Sugaray?
Yes, sir, it does.
So I have my opportunity to ask questions. You may want to make a point. The tricky thing about being a lawyer is when do you make that point and how do you make it?
Okay.
That's why it's always, so I'm telling you that if you have some point to make about these meters, the time to do it would be when Mr. Sidler testifies, and you'll have an opportunity to speak with him.
Thank you.
So, to your best of your knowledge, Mr. Don's Electric would have installed this equipment that houses that meter?
Yes,
Okay. And did you ever ask Don's Electric or bring the subject up about the nature of the 2 meters and why there are 2?
No,
Okay. You and Ms. Padilla looked earlier at a picture, or not a picture, it was the actual bills themselves. It was I'll just pull it up again because it'll be easiest. And I understand your testimony was that you don't really look at the bills, that Ms. Berg effectively deals with that. And is that correct? Is that more or less what you told Ms. Padilla?
that is correct.
So let me just pull up that bill again so we all know what we're talking about. So yeah, this is the June of 09 bill. And I'm loath to remember which of these P&M exhibits this is. Does someone recall?
Mr. Hearing Examiner, it's Leslie Padilla. It's P&M Exhibit 8.
Exhibit 8. Thank you very much, Ms. Padilla. So, right, so Ms. Padilla did this with you a bit, Mr. Sugar Ray. We're looking at this together, right? Like we can see there's 2 separate account numbers. We can see there's 2 separate meter numbers. We can see the electrical kilowatt hours are charged are different. We can see one of these is small power EN01. The other one says residential ER01. The sum totals are different. There's lots of evidence on this piece of paper that you were receiving 2 bills for 2 different things for 2 different services at 2 different rates.
I can
You
see
agree?
that now. Yes,
But your position was, I don't look at these things, my wife looks at them.
I never knew I had 2 meters, and I don't, if we did, why do I have 2 meters? I would like to know that also.
Would it be permissible to infer that if you have 2 different meter numbers, you have 2 different meters?
I never looked at the numbers. This is
If
the
someone
first
did
time-
look at them, should they infer that that's in fact the case?
Yes,
Because it's patently obvious based on the document that there are 2 separate meters installed on this property. It says so directly on this piece of paper.
I see it right there, yes.
Right.
How many people look at their bills? They just pay them.
You wouldn't believe my wife. She's a wild woman. She looks at everything, but she's as frugal as they get. And that's not a judgment on anybody else. It's just the life I live. I don't get to go to the grocery store. Let's put it that way.
That's why we're here. My wife prepared this.
I appreciate it. I think you have to agree with Mr. Sugar Ray that these bills themselves, I mean, I'm not sure if you're aware of this or not, but P&M submitted evidence in this case in which they actually had litigation and opened a case with the commission to be sure that ratepayers could correctly understand the information that appears on these bills. And a casual glance at this document tells you a great deal of information about the nature of what you're receiving. It's not something that requires a lot of attention to detail.
No, I agree with you. Yes, you're right.
And I'm not trying to in any way cast aspersions on someone who doesn't see this. I understand your position on some level, or Ms. Berg will tell us later, is, I don't understand these bills. It's a lot of data. But on another level, I mean, look, if the world can't rely on people to say, hey, here's some tax documents, fill them out. I mean, most people would just be like, I have no clue how to read tax documents. And maybe that's why HR Block exists. But you are expected to understand tax documents in the same way people are on some level expected to understand the bills they receive. And I that's not something we have to have this discussion about. It's really a kind of a legal conclusion. But I think it's hard to argue in this case, as a matter of fact, that you all did not have notice of these 2 separate meters because it's right there. In any event, you don't have to agree with me.
Well, what difference does it make if I have 2 meters? I'm being charged a different rate. And that's the problem here.
Okay, so then if the position is that the 2, fine, I accept that statement.
This has nothing to do with the meters. It's all about the rate. And the different rates were being charged unfairly. That's it.
Okay,
I don't
And-
care about the meters.
you don't, okay. So with the rates themselves, The testimony from P&M in this case is in part the reason why you were billed a commercial rate initially had to do with and I'm not making P&M's arguments for them. I'm just telling you what the testimony indicates, and you can respond to me with your own position on the subject. Is that you put the well in before any structures existed at this place, and that is one explanation for why when the well goes in, it's functioning as a commercial well, a commercial rate, because it's not serving a residence. I mean, do you agree that at the time the well was installed, there was no residence on this property?
I had my fifth wheel trailer there and it was supplying water to that.
Was P&M aware of that in any way?
I don't know. I don't think so. They are aware of it now. They can change the rate right now.
Okay, so but when you initially had the fifth wheel, I mean, this gets back to that document where there was just the well marked. I mean, it appears as though when you requested initial service, it was singularly for the well. And it's unclear how P&M would have possibly known that you had a fifth wheel parked there, because I mean, they just don't get into those details.
Correct.
Is that possible?
Yes.
So, and you also indicated that the power being drawn to build the house by the subcontractors was being taken from the well itself. And obviously, like, I mean, I don't disagree with you that there's a question about what is, and as a matter of fact, if you read testimony from P&M, they say a well on a residential property can be billed as a residential well. But they point out that it's the timing of these events that perhaps explains why it was initially a commercial rate. And I guess I think you haven't testified today inconsistent that, you know, right, we had men working using that power to build our house, and we had the well, and the fifth wheel is there. I guess I don't need you to answer any of those questions. I'm sort of just thinking out loud, frankly. The only question I have for you, Mr. Sugar, but I don't know that you'll be that helpful because you've indicated that you don't look at these things all that carefully. Going back to the bill, I'll just share it again real quickly. Share screen 2. This designation right here, you see where my cursor is? I just highlighted.
Yes.
Non-res small power EN01, residential ER01. That those two bills also made clear that these two meters were in fact charging different rates. And it doesn't sound as though, I'll ask it as a question. You never had a conversation with Don's Electric about 2 meters and the rates at which those meters are being powered?
Did not.
So to the extent Don's Electric is communicating with P&M, whatever those communications are, and we don't know what they are because they're not a part of this case in any way, you're never addressing with Don's Electric, hey, I'm getting 2 bills, and those 2 bills are for different rates, and what's up with all of this? That conversation's never happening.
That never happened.
All right, Mr. Sugar, I appreciate you being as candid as you have been with me. I'm not trying to tell you what happened. I'm just telling you I've spent a lot of time reading all these documents, and I have sympathy for you all in that, you know, some things occurred initially which set into motion some other things. And I think you've seen, and through our discussion, you know, one explanation as to how this all happens and what it means. So I guess what I'll say, Mr. Sugar, right now, as you said earlier, you got a question for me. Why don't you go ahead and ask me?
Well, my question is, when the gentleman came out and set the second meter, he was a representative of P&M. Why didn't he look at that and go, why does this residential house have 2 meters? Why didn't he call his supervisor and ask the question, this doesn't look right?
Okay.
Somebody would have told me I'm going to get charged a higher rate for 2 meters. I would have corrected the problem.
If I understood you correctly, though, earlier, Mr. Sugaray, you said your objection is not to the existence of 2 meters, it's to the existence of a commercial rate on one of those meters?
That is my, that's mine. That's not my wife's. My wife's got her separate, she's got her different reasons. That is my reason, yes.
Okay. Let me just make sure I haven't left any questions out before I turn you back over for redirect, which means the attorneys who are present today will have an opportunity to ask you questions based on what our discussion has just been. Oh, there is one thing. Good, I'm glad I went in here and looked. The electrician you got, Dell, I think, was it called Dell's Electric? Is that what was it called?
Oh, Dell's Electric, yes, sir.
Dell's Electric, right. So their service or the estimate they gave you for the work that would be needed to be done to reduce to 1 meter is to take a 200 amp service and a 100 amp service and combine that into a 300 amp service.
That is correct. There's another way to do it too. We could, after talking with him, since we're not going to build the main house, we could just reduce it to a 200 amp service and then do what he tells me a branch off, which would be a lot cheaper.
Okay.
So what I told Dell's Electric is that I was going to build my main house and I needed at least 300 amps. And he's saying, yes, you do. But if I don't build that, then I don't need all this power. And I can reduce it down, I believe.
Okay, so if I understand you correctly, your position or what you just said to me was that your plan as originally drawn up with the main house, the guest house, the studio, and the well, you understood that it required a 300 amp service. Is that what you just said?
Yes, that's my understanding.
And okay, sorry, I didn't mean to cut you off. Go ahead.
From Dell's Electric, that's what he told me. If I wanted to build my main house and it needed, I needed to be 1,500 square feet, I would need at least 300 amps.
Okay, so the service that initially went in for the well, I mean, I'm going to ask Mr. Sidler some questions about this because he's our electrical person. Because I have knowledge in the law, but my knowledge of electricity, exactly how it works, is only as much as it is. The 200 amp service that they installed for your well, I mean, obviously that wasn't going to be enough for the whole project then. It was your understanding that you needed 300.
Well, that's what Dell told me, yes.
Okay. Okay. I think I'm glad I caught that subject. All right, Mr. Sugaray, I think at the end we're going to be finished here. Now, I do have to say, sir, that I may direct that you be recalled as a witness after we speak with your wife. And the reason why I'm saying that now is because you presented a moment ago that you and your wife have maybe different perspectives too about the nature of this case. And that's a little confusing, frankly. I mean, that's not a criticism of you guys. I'm just saying, like, from a perspective of a person trying to resolve a complaint, I need the complainants to be saying the same thing.
Okay.
So I'm not suggesting you've said something that's problematic. I'm just simply saying that in the event that Ms. Berg tells us things that I'm going to require you to ask some more questions. I do realize you said, hey, you're a busy guy, you've got a life to live. I'm done for the moment, but I might need you to ask more questions. Are you amenable to that, Mr. Sugaray?
Yes, sir.
I appreciate that, sir. Thank you very much. I mean, now, Mr. Sugaray, you're not ready you can't go yet. So what happens now is based on the questions and the discussion you and I have just had, counsel for P&M will have redirect if she has any, and the staff from the P&M or from PRC will be able to ask you redirect. So, Ms. Padilla, do you have any questions for redirect for Mr. Sugaray?
I do, just 2 or 3, Mr. Sugaray. When I questioned you earlier about the initial drilling of the well, you responded that the well didn't perform almost immediately. It didn't perform, if that's the right term. Do you remember that?
Yes,
And then the hearing examiner asked you some additional questions about it, and actually, elicited the information that you actually do use the well. Well, actually, you said a couple of things. You said the well sometimes has worked until about 5 or 6 years ago, and in that time you have not gotten water from it, correct?
correct.
And you also said that you use the well because that is where you have your water deliveries. Is stored the right word? You would store the water there, and that you use a pump inside the well to pump water for your use.
Yes, it's called a booster pump.
Okay, I actually think I made that note. And you said, I believe that you started using the well for water storage and the booster pump almost right away after you drilled the well. Is that right?
Correct.
Okay. So you were using electricity for that well starting in approximately, would it have been March or April, whenever that well was finished? Is that March or April 2002? Is that about right?
That sounds correct.
Okay. But then your residence, the guest house, wasn't completed until June of 2003, correct?
Correct.
So there was about a year when the when electricity was serving exclusively the well, and now we know, as a result of questions that came up in this hearing, the power to your fifth wheel, correct?
Correct.
Okay. I also wanted to ask you some questions about Mr. Bogatko's questions about the answers that you gave, where you were answering questions from the hearing examiners. Which ones were they? The third set of bench requests. Do you remember that series of questions that Mr. Bogatko asked, and the answers that you had provided for the most part were, I don't know?
Yeah.
Okay. And actually, in one of those questions, though, the first one, he asked, the question was that you, Mr. Shegre, will explain whether he planned from the beginning to run power to the well and studio on one supply route. The answer that you provided was, I don't know, in your written responses, but when you were just speaking to Mr. Bogatko, you actually responded that you worked together with Don's Electric on that. Does that make sense?
That makes sense.
So you did work together with Don's Electric to plan the power to both the well and the studio?
Yes.
Okay. But then the responses to most of the other questions that Mr. Bogatko was discussing with you were I don't know, I relied on Don's Electric, correct?
Correct.
But when I was asking you some questions earlier, there seems to be a little bit of a conflict. If you look at, oh goodness, PNM Exhibit 11, no, sorry, PNM, which one is this? PNM Exhibit 10, the bench request answers from the November 11th, 2020 bench requests. And this was a question I asked you earlier. Actually, let's go ahead and find, do you have the November 11th, 2020 bench request responses?
Yes, I do.
Okay, if you go to the third page, F, there's a question, who designed the electrical supply routes to the varying structures on the property? Did this individual also direct the excavation work, blasting, and trench digging that was performed on complainant's property? Now, the answer, that was the question. You may not have the questions in front of you, and I apologize. So the answer, though, to F was I did, and that's you, correct? That I did, that means you did, right?
Yes, I worked with Don's Electric and we came up with the plan.
Okay. So
I had to come up with something in order to get these trenches dug.
Okay.
So I worked with Don's Electric and we came up with, I guess, a route.
Okay.
Then my blaster came in and he blasted these trenches so that we could put the conduit and the electrical lines in the ground.
Okay. All right. So you told the hearing examiner that your issue in this case about the 2 meters and the 2 rates isn't so much the fact that you have 2 meters serving your property, correct?
Correct.
And that your issue is really that you're being billed at 2 different rates. And I guess I assume that what part of the issue for you is that one of those is the non-residential rate. Is that right?
Correct.
Well, do you understand that if you were, just hypothetically, if both meters were billed at the residential rate, you would still receive 2 bills? Do you understand that?
Yes. Unless I decide to convert them into 1 meter.
Yes, good point. And if you did receive 2 bills, even if they were at both the residential rate, you would still have 2 sets of some of the charges, like the customer charge, for example. Well, you may not know, since you have said that you haven't really examined P&M bills. I'm sorry, I didn't hear what you'd said.
I don't know what that, but I don't look at that, so I don't know what that is.
Okay. But in any case, notwithstanding that, you would have no objection to continuing to have 2 meters at your property and receive 2 separate electric bills, provided they were both at a residential rate. That's your position?
That's my position. That may not be my wife's position. So.
Okay. Those are all the questions I had. Thank you so much.
Thank you.
Mr. Bogacko, your turn to speak.
The hearing examiner, Mr. Chagre, it's lunchtime. I'll keep this as brief as possible. Mr. Chagre, in response to a couple of the hearing examiner's questions, you referenced an estimate or a proposal from Dell Electric. Do you recall that?
Yes, sir.
And I believe you were discussing that estimate in terms of combining your existing service into one single 300 amp electrical service. Is that correct?
That is correct.
Do you recall the dollar amount of that proposal from Dell Electric to combine the services into a single 300 amp electrical service?
I think that was about $6,000, as I remember.
Okay, thank you, Mr. Echegaria. It's about $6,000 if I heard you correctly.
Yes.
Okay, and then I believe you also referenced an alternative approach to solving this issue, which you, I believe, said would be a lot cheaper. Do you recall that?
Yes, sir.
Do you know how much cheaper the alternative approach to solving this issue would be in comparison to the existing $6,000 approximately of an estimate you have from Dell Electric?
I could take a guess if you'd like, but no, I don't know exactly.
Well, hazard a guess, if you will, Mr. Echegaria. Do you think it's in like the $2,000 to $3,000 range or the $3,000 to $4,000 range?
I think it's probably in the $2,000 to $3,000 range.
And this alternative approach is something that's been proposed by a licensed electrician, correct?
No, it was something I came up with myself. Just
Okay.
trying to, what I was planning on doing is just adding on to the guest house and making it a little bigger. And that wouldn't require much more additional power.
Okay, well, thank you very much for that explanation, Mr. Echegaria, and thank you for being here today to shed some more light on these not uncomplicated issues. That's all I have, Mr. Hearing Examiner. I pass the witness.
Thank you, sir.
Very good, Mr. Sugaray. We are done. I won't ask any follow-up based on those questions that were just asked, but as I indicated to you earlier, sir, you just said to Mr. Bogacko again that you and your wife may have different perspectives about what's most important in this case. So to the extent to which your wife has testimony after lunch, that we're going to have you back. I do ask that you make yourself potentially available for this afternoon at some point. Are you going to? Is that going to be possible?
Yes, sir.
You're not leaving. You'll be around the house.
Yeah, I will go. I'm actually at work, and we're doing this at my office, and I'll just go have lunch, and I'll be back.
All right, that's fair. All right, so let's let Mr. Sugar Ray go. We'll take a lunch break now and go off the record. And why don't we plan on returning? It is now on the cell phone 12:11. Why don't we just say 1:15? Is this acceptable to everyone?
Yes, sir. Thank you.
Yes.
Great. Okay. Thank
Yes.
you very much, everyone. We'll go off the record for a lunch break. And please be sure you mute yourself when you leave, because if you go, and I'm sure people won't say bad stuff about people, they'll hear you. So turn off your.
No, listen, I'm glad I could speak quiet. All right, I'm done. All right, what do you need to eat? I don't know how to turn off the 30. You have to, you hit stop. Go to another file, then you just turn the power on. I don't want to turn any of this off because I won't be able to get back to it. I'm gonna get better. No, I like working the other way. My little sketches for that. look at my drawings. Here. And that looks pretty there, doesn't it? Shit, I'm done. Bill's up next. What time do you say that's what, 12:45 and then 1:45? Yeah. Leave it here. Want to see the bathhouse plans? Hundreds of years? How many Indians were there? You were in town yesterday.
That's all right.
They don't do it. Somebody's got. You got 5, that's 7.
Ms. Taz, can you hear me?
Yes, I can. Can you hear me?
Fine, thank you. Yeah, can I ask a quick off the record question just about
Absolutely.
exhibits? I don't want, doesn't need to be on the record.
Oh, no, I'm not.
I'm trying to just make sure where I left off with commission exhibits. You probably heard the discussion with the parties. I was going to admit some bench request questions into the record. And I don't know where I ended up.
Okay, let me look. I already translated it.
I'm just looking, I think we ended at commission exhibit 10.
I'm looking, just so you know.
Yeah, that's fine. I assume it was going to take you a bit of time. That's why I thought I'd try to catch it.
Okay, are you there?
I am, yes.
And you said, this is a letter to the hearing examiner dated January 21, 2221, submitted to the eDocket on that date. And this document shall be admitted as Commission Exhibit 10, I believe, unless there's any objection. I'll have to make sure that this gets corrected. Okay, those are all of the documents.
10. So then I got to 10, and then I think I have 3 more. Well, I'll have 4 more. So that answers my question. So I just want to know where I left off.
Okay, that's great. And will you be sending those to me?
Yeah, that's what I was just going to know too. I think what I would prefer to do, if it's okay with you, is after the hearing today, I'll just upload them into that Dropbox transfer file.
Sure.
And then if like tomorrow you just or like later today or however you do this, I don't think there's a way that you can just download some from the transfer option It just requires you to download the zip file and then all the documents end up. So
Yeah.
there's no way to avoid a bit of a duplication. So you just do it later, you'll get all of them. Does that make sense?
Okay, that's fine.
I'll do it at the end of the hearing today, upload those documents.
Okay, and this is off the record too. Is this gonna last 2 days, really?
I don't think so. I think it seems as if we'll have Ms. Berg go now and see where we get.
Yeah.
I believe P&M will be relatively swift, and then I don't believe Mr. Sidler will take too much time. So I think we'll be okay.
Yeah, that's what I was thinking too. Okay, great.
Great. Okay. Thank you very much.
Uh-huh.
Yeah, I thought that would be cool. Yeah, I had one.
We can hear you guys, just so you know.
Now they make concrete big beams. If you want to do a concrete beam, look,
Ms. Berg?
you just stick it on and then stuff around it. It's made out of concrete, but it never won't decay. It won't rot.
Ms. Berg? Can you guys hear me? Can you guys hear me? I can hear you. Can you guys hear them? Or am I just talking?
Oh, isn't that nice? This is what that does.
That's beautiful.
Oh. But it's
Always in.
it's always recycled.
Sorry.
Yeah, recycled.
Trying to get to something famous, Tejas? You trying to?
I was trying to let them know that we can hear them, but I don't think they can hear us.
Well, this is-
I don't know. I don't even want to hear what they're saying.
I know, I was trying to warn them that we could, you
There we
know,
go.
out of,
I just muted them. I don't think they knew they were unmuted.
but I don't think they could hear me, which I thought, oh my gosh, did I get thrown out again? Or is their speaker out?
No. I think, yeah, they're having some issues on their end.
Okay, great. Thank you.
Yeah. Um, oh. I think he was unmuting her on purpose because just to make sure it worked.
Oh, okay.
But I keep muting them because I don't know, don't want them to feel like they can't talk, right? Because so people
Well,
do
that's why I
stuff
was
on Zoom.
trying to warn them that we could hear it.
Yeah, no, I know. People forget about that. They say all kinds of stuff, and even sometimes you'll say stuff off the cuff, and you're not really meaning any of it. You're just saying words, right? Like it's.
I've been able to hear them clear through lunch, so.
Yeah, I told everybody to mute.
And I mean, that may not have been them. There wasn't anything on the picture. It might have been somebody in the office. I don't know.
Yeah.
And see what's bothering me or I'm concerned about is I don't know if they can hear us now. Can you give us a thumbs up if you hear us? Okay,
Yeah,
great.
okay.
Great.
close my door. Guess we'll just give Ms. Padilla a few more minutes. It's 1:15 on my cell phone, so I'm sure she'll be back shortly. Ah, there she is.
Yes, I'm here.
Oh, okay, good. I can't see your video. Maybe it's just your.
Oh, sorry.
That's okay.
It should
Kick in.
be on now. There we go.
Okay. Ms. Tejas, we ready to go back on the record?
Yes, we are.
Okay, so we're back on the record now. This is 19-00200. We've just returned from a lunch break. It is 1:15 p.m. I was having a brief off-record conversation with Ms. Tejas about numbering for commission exhibits, and I was doing this because the parties asked that we admit the bench request questions themselves into the record. And so in communication with Ms. Tejas, I discovered we ended with Commission 10. So then I would propose to admit the documents filed on eDocket filed by me on eDocket, July 13, 2020 bench requests as Commission Exhibit 11, the November 11, 2020 bench requests as Commission Exhibit 12, and then the order identifying and narrowing issues for hearing and third set of bench requests that was initially admitted on eDocket, that was initially received on eDocket on January 25th, 2021. Excuse me, that would be identified as Commission Exhibit number 13. And I fairly confident those 3 bench requests were all bench requests unless there was a 4th. And I don't believe there is because I'm looking at all my orders. So again, that's the July 13, 2020 bench request would be a Commission 11. The November 11, 2020 bench request is Commission 12, and the order identifying and narrowing issues, which include the 3rd set of bench requests, would be Commission Exhibit 13. Any objection to the admission of those documents? Those will be admitted into the record. So with that, I suppose at this juncture, we would now turn to the testimony of Ms. Leah Berg. We've already admitted all of the complainant's direct testimony. So we would then simply pass Ms. Berg for cross-examination, and Ms. Padilla on behalf of P&M would have an opportunity to question Ms. Berg.
Would you like to swear the witness in first, Mr. Hearing Examiner?
Yes, Ms. Tejas, if you could please do that.
Sorry, please raise your right hand, ma'am. And you're on mute.
Yeah, she's muted. I'll prompt the screen to tell her. I believe maybe Gary will come and do that. Or maybe Ms. Berg will do it. There she goes.
Please raise
Can
your
you
right
speak?
hand. Oh,
Sorry, no, could you just let us, can you talk real quick, Ms. Berg? We're gonna be able to hear you?
Hello?
Yeah.
Hello?
Okay.
please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. I'm going to have you speak up a little louder, please.
Yes, I do.
Okay. Good afternoon, Ms. Berg. I just have really 3 sets of questions for you today. So it shouldn't take long. The first questions I wanted to ask you are similar to those I asked Mr. Shegre about the bills that you received. Is it a fair summary of your complaint on this point that the P&M bills you received did not adequately inform you of the rate class at which your 2 meters were being billed?
Could you say that again?
Sure. Is it a fair summary of your complaint, one of the points of your complaint, that the P&M bills you received over the years did not adequately inform you of your rate class?
Correct.
Okay. I'd like to look at the same exhibit that I looked at with your husband, P&M Exhibit 8. I'll pull that up. Although, let's see if I'm successful in doing this. Can you see what I'm sharing right now? It's entitled 7/13/20 bench request answers.
Answers. Okay. Yes, I see.
Go ahead,
I
Ms.
see.
Berg.
Okay. And I'm going to go
Sorry,
down
no,
to the page.
Ms. Padilla, real quickly, I'll tell you what I'm seeing. I'm seeing a folder, a Windows folder with a whole bunch of exhibits.
Okay,
Yeah.
one moment. Then let me correct this. Guess you have to have the exact document open before you share. That should be
Yes.
okay. Ms. Berg, now do you see the this is P&M Exhibit 8. It's complainant 7/13/20 bench request answers.
Yes, thank you.
Okay. I'm going to scroll down to I'm going to make this a little smaller. Hopefully you can still see. This is about this is the 11th page of this exhibit. Now this, what you've provided with your bench request answers is a copy of this bill. It's dated January 28th, 2015. You can see that at the top, correct?
Yes.
And the service address on this bill says 19 San Marcos Trail, SPC well. Is that right?
Yes.
Now let's go to the second page of this bill where it describes your current electricity charges, correct?
Yes.
Do you see the box here that says rate and it says rate 2A?
Yes.
But your contention is that this is insufficient to properly put you on notice that this is a bill for service at rate 2A. Is that right?
Yeah, it doesn't mean anything to me. I don't understand it. 2A.
Let's look at the second bill that you included. I think this is for the same month, January 30th, 2018. Actually, this is still the special well. Let me see. I think you provided. I thought you'd provided another bill for your residents.
Yes.
I may have to look at another. Well, let me ask you this before I go find another exhibit where you submitted the bill for your residents. Do you recall that some of your electric bills, instead of saying rate 2A in this box, said rate 1A?
Only after the solar company pointed it out to us.
Okay. You know, I would like to find. Well, no, we can look at these other. So, when you looked at this bill, did you ever see the box that said that rate 2A or rate 1A?
No.
You never even noticed this box here.
No.
Okay. Did you know that the service address was different on the two bills that you received every month?
I never paid attention to that either. I just paid the bill.
So you did receive these two electric bills each month, correct? Once you started receiving service to both meters, correct?
Yes. We got two bills, and we just thought that was the way it was supposed to be. We didn't know
Okay.
why.
So for, I guess at that point, because the house was completed in 2003, and the house is on rate 1A, right?
Yes, because the
And
solar.
you were already receiving.
that out.
I'm sorry, I interrupted you. Say that again?
I'm sorry, the only reason we knew about this little box with the letter and the number is because the solar company pointed that out. It never came
Okay.
to our attention before.
Okay. So as of 2003, you started receiving two bills from PNM each month, correct?
I believe so. I don't know the exact date.
Okay.
Yes,
And then
I am aware of the two bills.
you filed a complaint with the PRC in, well, actually, let me say you inquired with PNM starting in late 2018, correct?
Yes,
So for that's 15 years of receiving two separate electric bills, correct?
yes,
That had different service addresses each month, correct?
I never paid attention to any of the specifics. I just paid the bill.
Okay. Well, let me look at an earlier set of bills, and this is also in the information that you provided. This was a bill from September of 2009. And this bill at the top of the page, the service address is, I'm trying to highlight it here, so I'll make it more, 19 San Marcos Trail, SPCB. You see that, right?
Yes,
Now, the bill format is different on this bill, right, compared to the bill that we just looked at?
okay.
Well, do you see that instead of just designating the rate with a letter and a number, this bill looks different. It actually spells out residential. Do you see that?
I see that on the bill now, but I never saw that before until the solar company pointed out. I just didn't see any of that. I just paid the bill, Ms. Padilla, that's all I did.
Yeah. Well, had you looked more carefully at this, do you think that this, as an explanation of the rate class, is sufficient? This says residential, ER01.
I understand what the word residential means, but I don't know what ER01 is, and I didn't know what the little letter and the little number in the box. I just never came to my attention, and I didn't know there was a problem.
Well, on this one, I want to be clear. On this bill, in September of 2009, the bills didn't just have a little number and letter in a box. It actually spelled out the word residential. You see that, right?
I see that now. I just didn't see it before.
And on the second bill that you provided, this is the same month, September 2009. This one is directed to a different service address. It's still your address, 19 San Marcos, but actually it says 19 San Marcos Trail, SPC Well, correct?
Yeah, I see that.
Okay. And this one, in the same place where the previous bill said residential, this bill, the well bill, says non-RES, comma, small power. Do you see that?
Yes, I see that now.
So your testimony is that for 15 years, you never noticed the difference in the rate classes on your bills.
Correct.
Okay. Did you notice anything? Did you notice any other differences in the bills?
No.
For example, the customer charge on your residential bill, and it's right here, customer charge. This line towards I'm trying to highlight it. The customer charge on this bill was $4. You see that?
Yes.
And the customer charge on the well bill was $7.75, correct?
I see that now. I just never saw that before. I just paid the bill, Ms. Padilla.
And we in asking Mr. Shigure earlier about the bills, he did say that you had been responsible all of this time for paying the bills, correct?
I have been responsible for paying the bills, I would say 90% of the time. If I'm out of town, my husband, he would pay the bill if I was out of town. But we just looked at the amount and paid the bill. But I have been paying the bills ever since I applied. Well, the only reason I ever accessed bought the internet was so that we could go paperless. And so I was paying the bills electronically at that point. And that was the only reason we got the internet.
Okay. So if your testimony is that you didn't know these two bills were for two different rate classes, then I guess you never even would have thought to call anyone at PNM to ask about what the rate codes meant, right?
I didn't know that there was different rate classes, and I never called anybody because I didn't know there was a problem.
Did you think it was normal that you were receiving two different electric bills?
I thought that was what was required because I'd never built a house before and I've never lived out in the country before. And so we just thought that was the way it was, that was the way it was required to be.
Well, you know, PNM's position is that was required because you got service to your well first and then service to your home later on a different meter. So in PNM's view, that was what was required, these two different electric bills. You understand that's PNM's position, right?
Yes, I understand that's P&M's position, but
Okay.
it's not my position.
Okay. Did you ever look at P&M's website for information about your bill?
No, I didn't know there, no, ever. I didn't know there was a problem, so I couldn't formulate questions if I don't know there's a problem. I just paid the bill.
Okay. I also wanted to ask you about the informal, I'm going to stop sharing this at this one moment. One moment. Okay, stop sharing. Try to share some. I wanted to ask you a little bit about the informal complaint process. Now, you filed the informal complaint. I'm actually not sure if that was filed only by you or if you also filed that in on your husband's behalf. But you filed that in, let's actually, one moment, sorry. It's P&M Exhibit 12. I'm going to bring up the informal complaint file. That's the document that the hearing examiner asked Mr. Jimenez about earlier today. You heard that conversation, didn't you, Ms. Berg?
Oh, yes.
Okay. Let me pull up. I have to be here, and then I have to share. Sorry, I'll have to walk through all my sister is much better on this because she's a kindergarten teacher. Okay. One moment. I'm pulling up P&M Exhibit 12, the informal complaint file, and I will share that now. Okay. Do you see, Ms. Berg, I'm sharing a document that's entitled Notice of Filing?
Yes.
Okay, good. And at the very beginning of what this document is, and the hearing examiner went over it with Mr. Jimenez, this is the commission's file of the documentation related to your informal complaint, right?
Okay. Okay.
You understand that, right? Okay.
Yes.
This, on the very first page of this file, is a description of the complaint. And this is fairly long. I won't read the whole thing, but this appears to be basically, from your perspective, a verbatim explanation of why you're bringing the informal complaint to the commission's attention. Do you want to just skim that and confirm that for me, that this is your description of what your informal complaint was about?
I believe that's correct.
Okay. Now on the second page, so this, what we're seeing here is your description, your explanation of why you're bringing the informal complaint. And at the
I didn't know there was an informal and versus a formal complaint. And I sent that document that I printed out, Ms. Padilla, to the PRC, and I believe you must have gotten it as well, that gave me a receipt when I filed with the PRC, and there was no mention anywhere on there that there was a difference between a formal complaint and an informal complaint.
Okay. So are you saying this language here in the complaint file is what you had sent the commission?
That looks like my writing.
Okay.
Yes.
Well, I wanted to, there's a place, I think this must be in the informal complaint form, but there's a place that asks the complainant for their suggested resolution. Do you see this? And it asks, explain what you feel would be a fair resolution of this matter.
Oh, yes, I see that.
Okay. And I think, is this what you requested in the informal complaint? Issue a full refund of the entire amount of overcharges for the 13 years of overbilling.
Yes,
Was that what you were seeking in the informal complaint?
Yes, at that time I thought it was just for 13 years, but I was mistaken on that. number, and we realized later that it was the commercial rate was charged from day one. So it came out to be, well, it's going on 20 years now.
So right, later on in the informal complaint process, you changed this 13 years to 18 years, correct?
Yes.
Okay. I'm going to go down to the very bottom of this, the end of this document, which actually is it seems to be the beginning of the communication in this file, because this first email, and this is at the very end of the document, I think it's the very last page. There's an email that appears to be from Mr. Jimenez to you, and the date is dated January 23rd, 2019.
I see that.
Okay, so what he's saying here is we have received your complaint and have sent it to PNM for their review and response. So this appears to be his first confirmation to you that they received the informal complaint, correct?
Yes.
So in January of 2019, he explains to you that I'm reading from the third line here. Please know that our process is just that, quote unquote, informal. Per our rules, we're only allowed to ask for refunds from a year back. So later in this message, he says if they do not want to refund these monies and there have been violations or discrepancies discovered in their billings, you may opt to file a complaint in our formal process, in which the case is expedited to proceed in front of the commission so that they can determine a refund based on 13 years of overbilling your account. Do you see that?
I see that on the screen here.
Okay. Let me just see. So at this point, fairly shortly after you filed your informal complaint, Mr. Jimenez did explain, actually, I'm getting a little off track here. Sorry, I wanted to, let me go back to what I was talking about, the goals of the informal complaint process. On February 26th, I'm going to scroll up to page 24 and 25 of this document. Right here, I think this is starting at page 23. This is an email from Mr. Baldwin to Mr. Jimenez, where Mr. Baldwin explains that that they didn't have, we weren't in possession of all of the records that dated back through November 2007, but they had simulated what had we been billing the customer at what we thought at that point was the correct rate, they would have saved $1,644.36. You see, so that's in, let's see what the date is again on this. This is February 26th. You see that? So at that point, Mr. Baldwin let Mr. Jimenez know through the informal complaint process that PNM was willing to credit your account for the approximately $1,600, right?
I see that on the screen, yes.
He also noted here that the credit would be first applied to your balance, and then there were any remaining amount of the credit that would be paid to you in the form of a check, right?
I see that, yes.
So Mr. Baldwin here asks Mr. Jimenez to please let me know if the customer accepts this offer or if you have any further questions, right?
I see that.
Okay. And actually after that, Mr. Jimenez initiated some questions to Mr. Baldwin asking whether it would be possible for PNM to look back even prior to November 2007. Do you see that right here? He says, I know P&M doesn't have records before November 7th, 2007, but would P&M be willing to simulate more of a refund
I see that.
based on, okay.
Yes.
And is it your understanding that Mr. Baldwin actually ended up doing that? He actually did run numbers all the way back to, I think, would have been 2002?
I believe that's what Mr. Baldwin said he was going to do. I have no idea what you do when I'm not there.
Okay. Let me see. On March 5th, Mr. Baldwin communicates back to Ryan Jimenez. This is this email I'm showing right now. March 5th email. Mr. Baldwin says, Ryan, we've been able to estimate the difference in charges from November 3rd, 2007 back to October 22, 2002. He said that period would add an additional $747. Adding that to my previous offer of $1,644, we're looking at a total refund of $2,391.36. And that offer was conveyed to you, correct?
Yes.
Okay. But you did not accept that offer when it was made to you at that time, right?
No, because all of the other issues were disregarded. All of the issues on my complaint have been disregarded.
Well, we could go back and look at how you explained the informal complaint, but when you brought the informal complaint to the commission, you were complaining about what you believed was an overbilling of the service that to your well and the studio and guest house, correct?
Yes.
In fact, I think what you may be suggesting is that later, Mr. Jimenez became aware that you had issues with the fact that there were 2 meters serving your property in the first place, correct?
Yes.
Okay. Let me see. Let me see, because Mr. Jimenez actually does acknowledge in these communications, let's see if I can find it really quickly, that Mr. Jimenez actually was not under the impression that you were, here we go, right here. Well, this is Mr. Baldwin actually responding to Mr. Jimenez. Mr. Baldwin did not realize that the issue was with how many meters were installed on the property. Mr. Baldwin had actually just been looking at the differences in the rates, correct?
I believe that's, I remember him saying that.
Okay.
Yes.
And here, as I said before, Mr. Jimenez also was unaware that part of your issue was having 2 meters on your property. This is an email from March 7th, 2019 to Aaron, where he actually says, I'm sorry, Mr. Call. I had to go into a meeting before I left for the day. As far as your last email is concerned, Ms. Berg did not relay the issue of having 2 meters on her property to me until the last conversation I had with her. So do you understand that neither Mr. Baldwin nor Mr. Jimenez understood until March of 2019 that in addition to, the alleged overcharging, you also had an issue with the fact that you had 2 meters on your property?
I see that.
Okay. So ultimately, you did not accept P&M's offer that was made in the informal complaint process. As you explained, you said that it was because other issues you, in your opinion, were not addressed, correct?
Yes, but there was no, they didn't provide me with any informed consent on where that number came from initially. It was only until much later at the very end of what you're calling the informal complaint process that P&M made the choice to do the forensic math. That was their choice. I felt that was important because I didn't know where that first number came from, and I didn't know where the second number came from.
Okay.
Because they gave me a list of numbers.
Ms. Berg, Mr. Baldwin offered to meet with you at the PRC offices, right, to explain the refund calculation. Do you remember that?
Yes.
Did you take him up on that offer?
No, because I didn't trust them, P&M.
Okay.
Not
All right.
necessarily Aaron, but I just didn't trust P&M at that point. Because there had been so much story changing, I didn't trust them.
And how would it have been possible to document for you that the calculation that P&M made to reach this, $2,400 number was actually correct and based on an accurate simulation if you weren't willing to meet with P&M?
I asked P&M to come out to the house multiple times to see that we weren't a business, and I invited Aaron Baldwin to come and explain because I felt comfortable with Aaron. Initially I felt comfortable with him, and I thought if you could come to the house and meet me and we could sit down and iron out some of the issues, I was willing to do that.
Okay. I haven't seen.
Nobody
Yeah.
came to my house when I invited them, P&M, multiple times.
I did not see any mention of that offer in the informal complaint files. That's why I was just asking you about the offer that's reflected here in the informal complaint file to sit down and meet with P&M at the PRC, in the presence of Mr. Jimenez or commission staff. But you did not think that was adequate, apparently, right?
Right.
Okay. So ultimately, even though at the outset of this informal complaint process, you had stated here, and I'm showing you again, this is what you had explained would be a fair resolution of this matter, a full refund of the entire amount of overcharges for the 13 years of overbilling. Ultimately, that was not, in your view, a fair resolution of the matter, correct?
I didn't know if that number was correct. And at that, I based on what had transpired over the 8 months, I felt that the ethics violations that I believed to have taken place, all of the issues were important to me, not just that specific number that you present. And what I had hoped is that the PRC and P&M would recognize how much time of mine was being consumed, and the stress and being faced with issues that I really didn't know how to deal with on my own. I felt that all of the issues were important at that point, not just the money.
Well, let me ask you a question about the time that it took. After you filed the informal complaint process, Mr. Baldwin was in touch with you. We could go back and look at the communication. I don't think it's necessary, but if you want to, we can. And he, in my review of this file, he let you know what he was doing and the steps he was taking to try to resolve your issues. Is that correct?
Mr. Jimenez or Aaron Baldwin?
Mr. Baldwin?
Oh, yes, Mr. Baldwin was in communication in trying to get this resolved.
He told you several times, in fact, that the work that it took to do the simulation would take some time, and he told you several times, I think, that, you know, he didn't have a quick answer for you, that it would take some time to work out, right?
Yes.
Okay, I just wanted to. All right, I'm going to stop sharing this. The last thing I wanted to ask you about was the you know, your complaint about PNM's compliance with its rules to help its customers. In your answers to the third set of bench requests, that's the that's your December 8th, 2020 document. Actually, no, I'm sorry, it's the March 4th, 2021 document. And I can pull that up if you need me to. You objected to PNM's claim that Ryan Jimenez suggested that you could file a formal complaint shortly after you filed the informal complaint. You said that you quote that I believe that statement to be false. Do you recall that?
Yes.
Okay. But again, if we go to the very beginning of this informal complaint file, this first, and back to the informal complaint file, this is PNM Exhibit 12, the very last 2 pages. In this first email from Mr. Jimenez that we reviewed earlier, he let you know in this January 23rd email that you may opt to file a complaint in the formal process. Correct? He said this on January 23rd to you, correct?
I'm not sure which email you're talking about. January 20th. So much time, Ms. Medina.
Oh, am I not sharing anymore?
No.
Am I? I'm
No.
sorry. I'm sorry. I stopped sharing and I didn't mean to.
Okay.
Okay. It's this first email that's in the informal complaint file, January 23rd, 2019.
Yes, I see.
Where he says, Mrs. Berg.
That went right over my head. That's the truth. It just went over my head. And I do remember Mr. Jimenez telling me later in the game that this was all he could do and that I would have to take it to the formal complaint.
Okay. So let me, if I could, so this was January 23rd. I just wanted to, yeah, in fact, on January 30th, just 7 days later, let's see, it's on page, it's hard to file the, page 27, 28.
He told me on the phone not to file a formal complaint. He said that PNM would want to deal with this matter as is because PNM would not want attorneys to be involved, right? Mr. Jimenez told me that on the phone.
Well, I'm looking at an email right now from January 30th, 2019. It's on the screen where he says to you, I apologize for your frustration in this matter. As I advised you initially, we can only attempt to resolve these matters in an informal setting. And then later I'll highlight this. He says, I would highly advise you to consider taking this matter to the formal complaint level so that the Office of General Counsel can bring the issue to the commission. So this was just 7 days later. He once again mentions the formal complaint process, right?
I see that on the computer and I just, because so much time has passed, I don't know how far along, how many months had passed before this came, before he sent this to me. All I know is that on the phone, he told me not to file a formal complaint because PNM did not want attorneys involved and they would want to settle this through this process. And P&M never initially told me my rights in the first place. So this appears in my heart to be irrelevant.
Well, I just wanted to establish that you did have notice of the formal complaint process. This email shows that he actually even sent you the formal complaint form on January 30th. Do you recall receiving that?
No, I don't
Okay.
remember. I don't remember. All I remember was when I filed the complaint, initially I did not know that there was a formal versus informal complaint. And I see what you are printing up here, but the significance of it did not register with me because this is not my area.
Okay.
I was just simply doing the best I could.
Understood.
Thank you.
But after having reviewed this material with me today, I mean, you're not still asserting that you were never told about the formal complaint process, whether by P&M or the commission, right?
I put in my complaint that P&M failed to inform me of my rights. It doesn't say there that it's Ryan Jimenez's job to inform me of my rights or anybody else. It says in the PRC rules and regulations that P&M is responsible for informing me of my rights
Yep.
to contact the PRC if a resolution is not reached.
Right.
And that was something that I learned from my neighbor. So I find this in my heart to be irrelevant. And I understand what you're saying, and I see these words, but the significance of it all just did not register with me at that time. And I'm sorry.
So at this point in the informal complaint, Aaron at this time is working to try to simulate the bill credit, right?
Okay.
Well, was he in January 2019? This was shortly after you filed the informal complaint, and at this point, wasn't Aaron trying to assist you at this point?
I believe Aaron was trying to assist me, all along, except for his first email to me was the only one that I believe he didn't know the significance of my complaint or why it was brought about. And
Okay.
so I felt like I had been disregarded at that point. But beyond that, Aaron, I believe he was trying to help.
And he in fact continued to try to assist you through March, when, let's see, in February he told Mr. Jimenez what the initial credit offer would be, and then it was later, I believe in March, that he made the additional calculation back to 2002, correct?
Yeah, all of these dates, Ms. Padilla, are just lost on me because
Okay.
I can't remember, but I remember the sum of the $1,600 that was brought forth, and I remember the sum went up to 2,000, something like that.
Yep.
And so, but the dates, all of these dates, I can't even remember when I filed what.
Well, the question I really wanted to get at was Mr. Baldwin assisted you throughout the informal complaint process, correct?
Yes.
Okay. At what point did it become clear? Well, it's probably a better question for Mr. Baldwin. At what point it became clear we were not going to be able to resolve the dispute informally? I'll wait, and we can maybe raise that with Mr. Baldwin later. I think that's all I have for you. Thank you so much.
Okay.
Mr. Bogacco.
Thank you, Mr. Hearing Examiner. Good afternoon, Ms. Berg. I'll keep my questions as brief as possible. If you'll just permit me a moment. There's a document I'd like you to look at, and I'll pull it up shortly.
Okay.
Here we go. Are you able to see what?
Mr. Bogacco, could I interrupt you one moment? Mr. Hearing Examiner, my witness, Robert Jarrett, I think is waiting to be let back into the meeting.
I see him as a guest. If he's trying to connect audio, he's here. I
Okay.
have a Robert Jarrett as a guest. I don't know if his audio isn't he's not being allowed in on his cell phone.
Yeah, I don't know. We'll try to I think he can't hear. Okay.
Can't hear.
I rejoined audio, but Kendra has not admitted me.
No, I would be in charge of admitting him. I'm not prompted to admit him into any place. I see his
Okay.
he should be able
I'll
to
ask him to retry.
Sure, and I'll keep my eye on the participant panel, and if something pops up, if it's his cell phone again, I'll just let him back in.
Okay. Thank you. Sorry to interrupt.
No problem. Do we still have Ms. Berg online?
We do.
Very good. Ms. Berg, I would direct your attention to what I've put up on the screen, which has been provisionally marked as Staff Exhibit 19, and it is complainant's answers to staff's first discovery requests. Do you see that document, Ms. Berg?
Yes.
I'm going to scroll through it slowly. It begins with the certificate of service that you put together to go along with those answers. And down there in the right-hand corner is our staff exhibit label, 19, as I just discussed. And then the next page consists of your answers to staff's discovery requests. Do you see that 1-1 through 1-9? Is that coming through clearly, Ms. Berg?
Yes, it is.
And then moving along to the next page is a copy of the Dell Electric estimate that you submitted along with your answers. Does that look to be an accurate copy of what was submitted, Ms. Berg?
Yes, it does.
And then moving along to the next page, we have your self-affirmation where you've signed and dated. And then I included as part of this exhibit the March 19th, 2021 email that carried your discovery answers. Do you see that, Ms. Berg?
Yes.
Does that appear to be an accurate copy of the email that you sent out to carry your answers to staff's first discovery, Ms. Berg?
Yes.
Thank you. With that, Mr. Hearing Examiner, I would move for admission of Staff Exhibit 19, carrying complainant's answers to staff's first discovery requests.
Any objections from any of the parties?
What did Mr. Bogacco say? I'm sorry, Mr. Bogacco, what did you say to the hearing examiner?
I asked Mr. Hearing Examiner to admit this copy of your answers to staff's discovery requests into the evidentiary record.
Okay. Okay.
And I asked if
Thank you.
there was any objections. I heard nothing from Ms. Padilla. Mr. Bogacco is not going to object to his own document, of course. And then Ms. Berg, if you have an objection, or if your husband, he's out of the room, obviously, you can
No.
state that now.
No.
Okay, the document's admitted.
All right, and with that, Mr. Hearing Examiner, I would move to admit one more item. If you'll give me just a moment to cue it up. And Mr. Hearing Examiner, I would move to admit the actual requests that staff submitted to the complainant in this case for the same reason that we've discussed in connection with the answers to the bench requests, in that The questions which prompted the answers were not included in the complainant's answers to the first discovery request. So for accuracy and completion of the record, and so that anybody else who might get into this record or read any briefs that may be subsequently filed, they'll be able to understand the context of the complainant's answers. So I have here on the screen in front of everybody a copy of staff's first set of discovery requests to complainants, which I've provisionally marked as Staff Exhibit 18 and labeled appropriately Staff's First Discovery to Complainants. It consists of, as you can see, 6 pages of instructions and requests, and I've reproduced the questions that prompted the complainant's answers. And then I've also included the original certificate of service that accompanied the requests. And so for purposes of completion of the record, and so that we can understand the answers in context, I would move for admission of Staff Exhibit 18 into the record.
Any objections to this document? Okay, Exhibit 18 for staff will be admitted.
Thank you, Mr. Hearing Examiner. And with that, I would pass the witness. That's all I have for Ms. Berg. And I thank Ms. Berg for her presence today and her answers to the various questions that have been posed to her so far.
Thank you.
Okay, thank you, Ms. Begacco. So Ms. Berg, that becomes my opportunity to ask you some questions. So to begin, is it fair to say, Ms. Berg, that yourself and your husband is playing some role in all of this, but you've had the chief responsibility for directing this case? Is that fair to say?
Yes.
I asked your husband if there was any thought by either yourself or him to have anyone from Don's Electric submit evidence in this case. His answer was no. Do you answer in the same way?
I don't have anything from Don's Electric.
Did you think it was relevant to submit anything from Don's Electric?
I don't think so.
Did you consider the possibility that Don's Electric was the source of why you have 2 meters?
I never blamed P&M for anything the electrician did, Mr. Hearing Examiner. My only complaint was that we were not informed or assisted on the most economical rate class. And as this conflict grew, I guess is what you could say, I started to question the validity of why we had 2 meters, because I didn't think that was necessary either. As this conflict escalated, I questioned that as well. But we have not had any contact with Don's Electric since our little house was built. And I have no idea where he is. And my husband did point out that he thought he moved. So I felt that the questions or anything from Don's Electric, I never blamed P&M for anything that Don's Electric did. I only questioned why P&M did not inform and assist us on the most economical rate class, and why they did not, assist us on the first meter or the second meter, because we just didn't know that either one of them had different rate classes, and we didn't know why we had 2. And now we feel that that was a wasteful expenditure. But I never blamed P&M for anything.
Okay, if the reason you have 2 meters is because Don's Electric set it up that way, who should be responsible for that?
I think P&M should be responsible, because had they informed and assisted us on the most economical rate class when the first meter went in, we would have never had a commercial rate, and we would have been informed that that meter needs to be attached to our house. I felt that P&M wasn't giving us a chance to complete a project that takes time, because everybody has to wait their turn when they build a house. People's schedules are busy.
Okay, Ms. Berg, I'm going to cut you off. I'm just going to ask you questions and you can answer we need to move forward. Your husband indicated that he doesn't have an objection to the presence of the 2 meters. Is that a statement that we should hold to you as well?
I think my husband doesn't care about any of this. He's tired and he's working.
Okay, so
He's not involved. He doesn't have time. And I heard him say that he doesn't care about the 2 meters because he can't take on everything. He has to work and that's it. You can only do so much.
okay, so I just want to clarify a few matters with the settlement discussions. During the course of the proceedings here, you've indicated that some of the settlement proceedings, when you've been discussing settling with P&M involved, you were blackmailed, subjected to duress and coerced. You did write those things?
That's what I believed was happening.
Do you agree that the commission therefore has appropriate authority to inquire into settlement discussions in light of the fact that you are alleging you've been blackmailed and coerced and duressed and subject to duress?
I'm sorry, what did you say?
Do you agree that the commission should be probing into questions regarding settlement in light of the fact that you've alleged that settlement involves blackmail, coercion, and the subjecting you to duress?
I don't know what the PRC's role is in that.
Okay.
I don't know. I don't know what your role is in any of this. My neighbor told me I should contact the PRC. And so I have never known, Mr. Hearing Examiner, what could ever be resolved concerning my complaint. All I could do was present it, and you eliminated some of my concern, like the one on, you eliminated that concern on the failure to inform on the bill, which was deeply important to me because I never saw that little letter and that little number, and I didn't know what it means. And so, and I know that my neighbors, when I talked to them, they agreed. They didn't know what that meant either until I presented it to them. And so I don't know what you can do to help me. I'm just here to present it to you, my complaint. And I accept whatever you decide, and I'm just sorry that it has gone on this long, and I am deeply sorry if I have been a poor communicator and a poor writer. I was
Ms. Berg,
frustrated.
can I just stop you? You understand, Ms. Berg, that my personal feelings are entirely irrelevant to this proceeding. I understand on some level I don't believe can separate that view, and I don't blame you for that, and that's not a judgment. What I feel in my life is totally irrelevant to anything we're discussing here today. And the other thing I will say to you is oftentimes when you speak, you say matters that are untrue. So for instance, when you said to me a moment ago that I have eliminated a claim, and I can't remember exactly which one it was, that was an inaccurate statement. It's unnecessary for you, Ms. Berg, to concern yourself with my feelings, with Ms. Padilla's feelings, and with Mr. Bogacco's feelings. None of those things matter. All that matters is whether you are entitled as a matter of law to the remedies which you seek, what are the legal principles that govern here, and what are the facts. All we are concerned with right now are the facts as you understand them. I'm trying to get clarification from you on some matters. For instance, with the settlement discussions, there is a rule that says the hearing examiner is not to probe into settlement discussions or disclose them. Of course, you've also alleged that you were blackmailed, submitted to coercion and duress. My view would be, well, as a hearing examiner, I know I'm not supposed to probe into that, but well, if she's going to make those claims, then I probably should. It would be pretty irresponsible for me not to. I don't believe that there has been blackmail, coercion, and duress here, because I understand, and we'll hear more from perhaps, I don't know where, or maybe an argument. What informed me that, that never happened. There's an explanation for what you think blackmail, coercion, but these are just disputes that we don't need to get into. So just when I ask you questions, just give simple answers. Don't worry about my feelings. Don't worry about anything. Just answer the questions. Does that work?
I'll do my best.
Well, you don't need to try. You just need to answer them truthfully. You shouldn't have to try. If you're just speaking the truth and you just say whatever's true.
I don't have anything to hide from you, Mr. Hearing Examiner.
That's fine. And you have to acknowledge as well, earlier we heard your husband say he doesn't care about the fact that there's 2 meters. Well, you have represented as the main proponent of complainant's claims in this case, that the question of the 2 meters is somehow deeply important. You both have to believe either the meters matter or they don't. It can't be one is doing one thing and the other is doing another thing. That doesn't make any sense.
I tried to tell you that my husband was not involved in this and that I brought the complaint before the commission.
The name of this action, Ms. Berg, is in the matter of Gary Ashugare and Leah Berg. Your husband's involved. He indicated earlier that he is concerned about the commercial rate, and he did reiterate the claim that you have asserted repeatedly that you were not informed of what your rate should be at the time P&M set that up. So if what he has said is, as far as he's concerned, the meter issue is out, well, that's great, but you are not saying that as far as I can tell.
No, I think that the issue of the 2 meters is a concern because had we been informed and assisted with the most economical rate class, we would have never had 2 meters in the ever. We would have just.
I would propose to you that it is possible that Don's Electric, as your husband had to admit, may have done what was why you have 2 meters. They set you up with a service that didn't adequately supply the 300 amps you needed. We heard all of this testimony. There's documents to suggest all of this. My understanding is you don't actually have any evidence to answer that. It's conjecture on your part. If there's any part of this.
The question,
Sorry, go ahead.
Hearing Examiner, that you asked Gary about the 300 amps, we didn't know how many amps we needed when we built our home and the well. The 300 amps that Gary was referring to was Dell Electric told him that we would need 300 amps. We have no idea how many amps we need. We didn't know back in 2001, and we didn't know in 2021. Dell's Electric told my husband that we would need 300 amps if we ever decided to build the main house, which we are not going to do. But back in 2001, we had no idea what kilowatts were, or amps, or meters, or any of that stuff. We simply relied on P&M and the electrician.
So, Ms. Berg, if I ask a question, when you say we, if I understand correctly, you and your husband do not even agree on whether or not your complaint should be for 2 meters. Why would I be crediting what you're saying with respect to what your husband knows?
I don't understand your question.
You and your husband do not agree on what is even in dispute in this complaint. And then you're now testifying to me that you have knowledge of what your husband knew at the time he was building this house. I spoke with your husband extensively some time ago, and he gave me different answers. And I'm questioning, well, let's put it this way. We're not here to question your husband further. I don't need you to make a testimony on behalf of your husband. I'm just going to go back to my questions that I have prepared for you, and we'll start from there.
Okay.
So if your testimony, as I understand it, is that you first learned and discovered that you had bills at the commercial rates, that the first time that you ever discovered this was September of 2018.
Yes, the solar company pointed that out, that we had a commercial rate.
The solar company pointed, and how did they point that out to you? What did they see that you didn't?
Well, when you apply to have solar panels, they ask you for a copy of your most recent bills. So
Okay, so they looked at your bills,
yes,
and they saw what your rate was on your bill.
they saw that, but I think that they were just really looking for how to recommend how many panels we would need to offset the bill.
Okay, thank you.
Yes.
So how long did it take them to see on your bill that you were being billed at a commercial rate?
I have no idea.
Did you hand them the bill? Did they say right away to you, oh, look, you got a commercial rate?
I believe that I may have emailed the bills to the solar company. I don't remember handing them the bills. I believe, well, I may have when he came out for a consultation. I think he may have said, please have copies of your current bills. I can't remember if I emailed them or handed them to him. And I don't remember when he pointed out that we were in a commercial rate. All I remember is that when he did point it out, I called P&M immediately.
Okay, and your testimony though was that this was discovered by the solar company examining your bill.
Yes.
Ms. Padilla went through the bills with you and she pointed out the writing and the lettering on there. Am I to understand that your testimony is that you pay all your bills without ever looking at them?
I never knew there was a problem. I looked at the amount and I paid the amount. I only called P&M once.
Do you pay bills you receive, credit card bills, insurance bills, any bills? You just pay whatever they say is there?
Well, my husband pays the insurance, so I don't know anything about that bill. And my credit card bill, I do check to see that the charges are for charges that I made on that particular bill. It just never crossed my mind that we would be, that there was different rate classes or that we were being charged more than what is the most economical rate. It never came to my mind. So I can't formulate questions if I don't know there's a problem.
So you're testifying that you read some bills you receive, but you just elected not to read the P&M bill.
Yeah, I didn't examine the P&M bill in a forensic way. I never did that.
Did you think it was ever necessary to read the bill, like ever?
No, it never crossed my mind that the electricity would be more than what we were using. It just never came to my mind.
You saw the testimony that P&M or the documents that P&M submitted in which they had a case before the commission where they were discussing how to make sure the bills were most effectively readable to customers and presented information in such a way that it was clear and transparent what the bill charges were. Did you see those documents submitted by P&M?
I probably did not look at those. I remember you telling me, I believe in one of the pre-hearings, that the billing issues were decided some time ago, and that's the way it is. And so I believe that particular issue was not going to be addressed.
What do you think would be necessary for P&M to effectively communicate to you that one of the bills was charging you rate 2A and one was charging you rate 1A, if not expressly listing on those two bills that one was for 1A and one was for 2A? What would have been necessary to alert you?
Well, if they would have listed all of the different rate classes and how much the customer service fee is for each class and who is applicable to which class. None of that was presented to us when we bought our land and Gary first went in to get the extension line agreement or something like that with P&M. We just were never informed that we thought when we requested electricity that the lights would go on when you flip the switch up and the lights would go off when you went down. That's all we knew about electricity. And I had never built a house before. Gary had never built a house before, and we were both at work. We simply relied on the professionals in their specific field to assist and inform.
Is Don's Electric one of those professionals that you relied upon?
Yes, Don's Electric did the electrical work for us. I don't remember ever having a conversation with that man ever, because
your husband said that he had no conversation with Don's Electric about their interactions with P&M. Why would you have knowledge about your husband's non-conversations with Don's Electric?
Why would I have? Can you say that again?
Had conversations with your husband or anyone when your husband himself did not have conversations with Don's Electric. Your husband's testimony was he never spoke to Don's Electric about any communication they had with PNM.
Right.
You cannot have communicated with your husband about conversations he's not having. So in some ways, when you say that you relied on professionals, I agree with your statement, but on another hand, I have to point out to you that you really did rely on those professionals because they basically did stuff that you did not check, according to your husband.
Yes, that sounds correct.
Okay.
Yeah, I mean, I didn't know that there was anything wrong occurring.
Right, and that in part could be as a consequence of the fact that you all never asked Don's Electric what he did with PNM.
I didn't know that that was my job.
I understand. I understand your testimony. You pointed out during the course of these proceedings too, you said on multiple occasions that your minimal energy usage should have signaled to someone along the way that it was unnecessary for you to have 2 meters. And I'd ask, why wasn't that thought sufficient to trigger you to call PNM to say, why do I have 2 meters?
Because when we got the 2 bills, we thought that that was the way it was supposed to be. When we never questioned it because we didn't know that that was a wasteful expenditure. We just didn't know. We've never built a house before, and
You've had electrical bills before in your life. I mean, you're
yes.
you're not a young person, and I'm not meaning to be ageist there. I'm not a young person either anymore. I'm in my 40s, and that's like miserable, but whatever. So you know, you've certainly paid electrical bills before.
Yes, my husband and I had a house in Denver. That was my first house, and
Okay.
his
And
first house.
did you have 1 electrical bill or 2 electrical bills at that house?
1.
Okay, so when you got 2 electrical bills in the mail, did you say, oh, this is weird? We use no energy and we have 2 bills.
No, it never crossed my mind.
Okay. So if I understand your testimony correctly and what Ms. Padilla walked through with you, it appears very clear in the informal complaint file that Mr. Jimenez most definitely informed you that there's something called an informal complaint and something called a formal complaint. I mean, we've sort of just been through that, and you have to acknowledge that that's true, right?
Yes.
Okay. Your position, if I understand it, and I understand this position. I don't know that it's a good one, but I just want to confirm that I understand it. You're saying it's not enough that Ryan Jimenez said those words to you, that PNM has to say those words because Commission's rule says that he has to say them.
Yes, I don't.
Even if you know them.
I think it was PNM's responsibility to inform me of the PRC and my right to file a complaint with the PRC. It wasn't Ryan Jimenez's job or my neighbor's job or anybody else.
Okay, so now, and I just want to be clear on this. I understand that argument. I'm not dismissing it, but it's more of an argument than it is facts. What I want to know, as a matter of fact, would be what is achieved, and there might be an answer, so I'm not asking this as a rhetorical question. What is achieved if Aaron Baldwin tells you something you already know?
What is achieved if Aaron Baldwin tells me something I already know?
It's not a trick question. I'm not trying to trick you.
I
It's a
don't
legitimate
understand.
fact question.
I don't understand what.
That's fine. I won't force you to answer. I just was wondering if there's some facts you can elicit to describe to me why it is that PNM must in fact tell you these words, if in fact they've already been clearly communicated to you. You heard me ask Mr. Jimenez earlier, did he in fact communicate to Mr. Baldwin that he had informed you about the formal and informal complaint process? And that sort of closes the loop. But what you're saying is, well, Aaron Baldwin had to tell me these things. And I'm just trying to understand why you think it has to come from Aaron if it's pretty clear that you were aware. And your answer could be simply, well, it's just a formal requirement that must be done. And I don't know if that's what you believe is a matter of fact. And I guess I'm not sure that's even a fact question as much as it's a legal question. But I'll leave it there. We don't need to explore that further.
Well, I believe that the formal and the informal, it really just went over my head until later in the game. And because I believe at one point, Mr. Hearing Examiner, that I said, because when I got my receipt, when I filed the complaint, it never told me there was formal versus informal. And in my heart, I feel that this is, when Ryan said on the phone, Leah, don't file a formal complaint because P&M doesn't want to get attorneys involved, and we should just try to resolve it through this process. I believed him. And
okay, well, so yeah, well, so maybe what you're saying, Ms. Berg, is this: you're saying, look, it's confusing to customers, and therefore it's necessary for P&M to say these things, even if it's duplicative, because that ensures I'll know. Is that what you're trying to say?
that sounds reasonable. Yes.
Okay.
Yes.
So I understand that. This is why I'm saying to you, Ms. Berg, I'm not asking you trick questions. I'm asking you just to speak whatever you think, because I want to know what you think. And as long as it's a fact matter, then you should be able to have the opportunity to say it. So let's talk about one of your claims here is that the P&M's internal complaint process is inadequate. And you point to the rule that talks about, qualified representatives. And you speak at some length in one of your answers to the bench requests about all the reasons why P&M's customer service representatives, they use the acronym CEA. I don't remember what that means, customer something assistance. Doesn't matter. We all know what we talk about when we say customer service representative. I think it's the more colloquial expression. So what do you say over and over and over? Here's examples of how people aren't qualified. I'm not asking you to sort of say in the legal sense what the word qualified should mean. I just want to know, what is your expectations when you are saying that a person is qualified? Like, what does that mean to you?
What it means to me is that I don't get different answers each and every time I call. And I don't get answers that sound made up. Like when one person told me that the PRC is in charge of our billing, and one person told me that we were charged what we were because we were using too much electricity. And that answer sounded made up to me because
I'd like to ask a clarification question. So when you say those things, is there evidence apart from your assertions in this case that anyone at P&M said that? Can you point me to any place where there is evidence these things were said? Or do I have to rely on your assertion that I've heard?
It was on the phone, and so I have no record of that. I don't record phone calls. I don't know how, and I would never think to do that.
Okay. All right, so I didn't mean to cut you off. So I just wanted to get, because you said those two things, I've read those same those claims. But can you be more broad about, so those are two concrete examples. And if you're just gonna point back to your testimony, then I won't pursue it further. I'm just trying to understand how in your view, someone's qualified in a way that isn't really restricted to like your definition of qualified.
Well, I don't know what to say other than when the very first email I got from Mr. Baldwin, he made a statement in that email. This is probably why this complaint was brought forth in the first place, which was completely false. I didn't feel that Mr. Baldwin even knew why I had filed my complaint, because his answer was incorrect. And I don't remember what he said to me. I just remember how I felt after the email. I felt like I didn't matter.
Okay, and this is another question I have for you are the customer service representatives at P&M, in your sense of the word qualified, are they supposed to be managing the feelings of customers?
I think they need to be professional and honest. And if they say they don't know the answer, I would prefer someone says, I don't know the answer to that. Let me get back to you. And if they say they're going to send you the documents that you request, that they actually do it, or if they can't, they still get back to you. And none of that happened in the first 5 interactions I had with P&M representatives. Nobody called me back. Nobody sent me the documents that they said they would send me. And I got different answers from each representative. And I'm not blaming the representatives, Mr. Hearing Examiner. I believe that training comes from the top and it filters on down. So
okay, no, glad you said that. All right, so that's good. So let's transition to that. So you talked about this at great length in your writing too. Did you ever ask any of those customer service representatives about how much they are trained?
No.
Did you issue any discovery requests to P&M to identify how they train their customer service representatives?
No.
Do you have any knowledge or information about anyone else's perspective about the training of these individuals apart from whatever it is that you believe?
Will you repeat that, please? I'm sorry.
So what I'm trying to understand, Ms. Berg, is you keep telling us these people are obviously not trained. How do you know that? And if you're simply saying it has to be the case they're not trained because look at what they did to me, that's fine. But I just want to hear you say that if that's what your position is.
I believe that they were not trained based on some of the ridiculous answers that I got, answers that I believe to be ridiculous. And I spoke with one P&M representative just recently and she flat out told me that she was not trained to take my meter reading when I called to submit a meter reading. She said, I'm not trained. And I said, you're not trained to write down 5 numbers that I have to give you, and and you're not trained to take this meter number. I said, I don't think that you need to be trained to do that. That's just writing down 5 numbers and the number of a meter. So she flat out told me she was not trained and that I would have to be transferred to a different department.
Okay. Again, is it the case that you don't have evidence of these conversations apart from your representations today? Is that basically true?
I have no evidence of these phone calls, no.
Okay. I just want to go back to the informal complaint file, and I'm looking at something 21319. My numbering on these pages, the numbering in all this is hard because it's on PDF. So I'm just going to find it and give me 1 second.
Okay.
Where is it? It's got to be here someplace. This is page 23. My numbering. I'm going to start at. Well, you know what I'll do, Ms. Berg? Instead of pulling up on the screen, I'll just read it to you. So this is a email from, I believe it's Good evening, Ryan. I'm getting there. I'm sorry. I wish I could find it. It's like so annoying that you can't find something. There's a message from Aaron to Ryan, and I'm going to ask you to just think about it and tell me a little bit about this. Here it is. Okay, I'm going to share it. It's actually it's exactly the page I had, but whatever. Let me pull this up. Share screen number 2. Okay, you're seeing this message from Baldwin, Aaron. See my cursor down here? I'll just highlight this.
Yes.
Oh. Okay, so this message here, this again is P&M Exhibit 12. It's an email from Aaron Baldwin at P&M. sent on February 25th at 5:28 p.m. to Ryan Jimenez of the PRC. Thank you for allowing the extension to our answer for this complaint. I'm just going to read this so that we were able to go back and simulate what the customer would have been billed historically if they had been billed at residential rate 1A instead of commercial small power rate 2A. I do have to state up front that we only have billing records going back through November 07 for our customer accounts. By law, PNM is only required to hold records for 7 years. And a New Mexico Administrative Code rule states that if there is a billing error, we would only be required to go back and rebill the last 12 months of service. However, since we do have records that go back all the way beyond that to 2007, we decided we would try to do our best by the customer. Our simulation shows that we had been, I'm going to read that again actually. We decided that we would try to do our best by the customer. Then he goes on simulation shows that we had been billing the customer at the correct rate. They would have saved $1,600. Attached are the results of the simulation, yada, yada, yada. It goes on and on. So this bottom part here where my cursor is. We are willing to have a credit issued to Ms. Berg for $1,644. There are currently unpaid electrical charges, blah, blah, blah. Then we can send the remaining count to her. And then he says, please let me know if the customer accepts, if you have any further questions. Regards, Aaron Baldwin. So my question to you is, your basic assertion here is this informal complaint process is inadequate. It's in violation of the rule. And yet here's an example of them doing things they don't have to do to help you. Does that strike you as inadequate?
I can't remember that because I don't know if the where the math was coming from. So the dates are all a blur to me, Mr. Hearing Examiner. And so
well, what's not a blur here, however,
the number doesn't make
Ms. Berg, let me just, I understand you spoke with Ms. Padilla about the numbers and you have concerns about the numbers. All I'm saying to you is that there is definitive evidence in the record that shows that, we lose her? Oh, no. Can you, is there audio?
Are you talking to me?
I hear you.
Oh, good. Okay. So do you think that this is evidence that I mean, if they're going above and beyond what they're required to do, is that inadequate? And how?
I don't think that when there has been an overbilling, it is my belief that you should make the correction to go all the way back to the beginning. Even though it says in the rules we're only required to pay back one year, I think it's the right thing to do by going back to the beginning. And so I do appreciate the fact that Aaron Baldwin made that attempt to do that, but I just wasn't sure about the numbers and where they came from. And
So, okay, well, so let me just say that. So then, are you saying then that you are satisfied so long as the math is correct?
Yes, with that particular aspect of my complaint, absolutely. As long as the math is correct.
Okay, let me just be very clear about this. What you just said was that your beef with the way Aaron did this was that you had issues with the numbers, and you're agreeing with me that, like, well, he's going back way beyond the time he has to try to figure out what they might owe you. You're bothered by whether the numbers are correct. But if I understood Ms. Padilla's sort of, interactions with you, she pointed out that in fact that's exactly what they did, and they came up with a number that they did believe accurately reflected what you were owed, and then you rejected it.
I don't know. I believe it was at that point there was multiple areas of concern on my complaint, and it wasn't ever just about the money. It was about the ethical violations that were important to me, and I had no idea what the PRC role is in bringing solution to any of it, but it was all important to me, not just that small amount of money.
I understand that. I am very familiar with your assertions about the money situation. Can I ask you, did you write an email to, I believe it was Aaron Baldwin, or it might have been Ryan Jimenez, in which you indicated that what the message you wanted from PNM was, here's $10,000, and we think this is what will make you happy, Ms. Berg, and that's what you were hoping to receive as far as a response from PNM? Do you recall that email?
I recall that email. Yes.
You wrote those words, right?
I believe that there was the amount of time and wasted time and energy that had been put into all of this should have reflected an amount that, and I honestly didn't know what the overcharges were going to be, because I couldn't possibly do all that forensic math. That was their choice. But I felt that based on all of the aggravation and the overbilling and the, getting different answers from different representatives over and over again, and all the story changing, I felt that if you want to really settle an issue, put together an offer that sounds fair. That's how I feel.
So did you want PNM to compensate you for your time?
Absolutely.
Is that part of the reason? Is that part of the reason why you rejected the settlement, or not the settlement, but the offer that was provided to you in the informal complaint, because you wanted to be compensated for your time?
That would have been really nice, but I didn't know if that was an option. The issues that I put forth in my complaint were all important, and what is most important for me to try to convey to you is that I didn't want this to happen to anyone else, because it's stressful, it's exhausting, and people have enough problems in their life, not just this one. I mean, there's a mountain of other issues that go on in people's day-to-day lives that tear us away. And so this was just piling on more stress that did not need to be.
So I understand that you've said that multiple times, but and I'm not trying to be argumentative with you, Ms. Berg, but I just have to ask this question. Isn't the solution to ensuring this doesn't happen to other people is to make sure people read their utility bills?
Yes, they need to read their utility bills. Yes, they do.
Should you have read your utility bill?
Apparently so. I just didn't know that there was a problem. So
I understand. Thank you, Ms. Berg. I have no other questions. It's all. We go to Ms. Padilla for any redirect.
Okay. Thank you, Mr. Hearing Examiner. Ms. Berg, in the course of your discussions with the hearing examiner, you mentioned several times your assertion that PNM failed to assist you with determining the most economical rate class, correct?
correct.
But so I just wanted to go back and understand, make sure if you understand that your first service was a well, correct?
The service that we requested was to provide electricity to our home, our well, and any other future hen house, outhouse, doghouse. It was just, we needed electricity to live. And that was why we turned to PNM to get electricity. And it was not just for the well, it was for our home as well.
All right. Well, the evidence that I've seen really supports only that you sought electricity for the well, and that suits the time, because initially all you had to serve at the property was the well.
What we
Well,
failed to point out was that at the top left of that same document says residential. We did not buy a piece of their land and plan to go out and drill
Okay.
a well. We plan to build a home
understood.
and needed electricity for all of our needs. And the
Understood.
well needed electricity and the house
So
needed
the
electricity.
first, all right, the first service though was ostensibly served your well, which a strong indication of that was the fact that the bill itself for years has said well, right?
Yes, but you never gave us a chance to finish our house. You just want to direct that electricity to the well. But the only
Okay,
reason we asked for electricity was so that we could have a house that had
And-
water.
but Ms. Berg, and then a year later, whether it was Don's Electric or whoever, you obtained a second service at a different rate class, correct? I want you to, the
Yeah.
first,
That is what has been brought to our attention. Yes.
okay. So in terms of economical rate class, do you understand that it's PNM's position, that a water well on its own, unconnected to a residence, that's in place a year before a residence exists, that well is properly on a non-residential rate?
That is the documentation that you sent me 20 years too late.
Okay. So you do understand PNM's position that a service to a well, and I'm sorry if I'm repeating this, that is not at that time serving a residence is correctly on rate to a non-residential rate, correct?
No, I do not understand PNM's position regarding that matter, because our intention was to build a home that had water, and we need water to take a shower, and we need water to live. And so,
All right.
and we also
And-
had our trailer out there, our fifth wheel. And so we did not turn to PNM to specifically put utilities that have to come in first. You put your plumbing in, your electrical, you get the water. You never jackhammer the floor. You don't tear down the plaster and put those things in after the fact. We turned to PNM and the electrical subcontractor so that we could have
Okay.
a home with water.
y-
And what you guys do with your rates, I have no control over. I'm just doing the best I can.
Right.
We were not informed and assisted when either meter was put in. PNM had two
right.
opportunities to inform and assist, and they failed both times.
Did you seek PNM's assistance in selecting the appropriate rate class?
I had no idea there was a difference between rate classes. That is your job, to inform and assist the customer on the most economical rate class.
Okay.
I only knew that the lights would go on and the lights would go off. That's all I knew about electricity.
Mr. Hearing Examiner,
My job to inform myself. You were supposed to inform us. It says in the
Mr.
rules-
Hearing Examiner, one moment.
Sure.
On this point, I would like to look at, well, I don't think we need to look at it, but in the complainant's complaint, the complaint cites rule 17.5.410.25 assistance to customers. Could I share that rule on the screen, Mr. Hearing Examiner?
Yeah, you want me to pull it up?
I've got it right here.
Okay, yeah, if you'd like to bring it up, go for it, sure.
Well, let's see if I do have it. Maybe not. No, it's here it is. Hang on, sorry. So I have the, hang on. have this. This is the rule. Oh, it's Word. One moment. I apologize. Okay. All right. Here it is. All right, Ms. Berg, do you see I've pulled up, this is a portion of the New Mexico Administrative Code, Title 17, Chapter 5, Part 410. Do you see this rule that I've pulled up?
Which one are you looking at?
Just looking at the document. We'll go to the correct page in a minute. I just want you to
Yes, I
confirm
see
that you are seeing this.
Yes, I see that.
Okay. I'm going to go down to section 25. This is assistance to customers. This is what you cite in your complaint. You say that in PRC rule 17.5.410.25 assistance of customers. Anyway, you cite this in your complaint that I wanted to see if you could. Well, I'll read it for you. This is the provision of the rule that you assert PNM is in violation of. The utility shall assist the residential customer or prospective residential customer in selecting an appropriate rate tariff and furnish such additional information concerning that tariff as the residential customer may reasonably request. I think you just said, did you not, that you did not request any assistance from PNM when you first obtained your service, correct?
I did not know that I had to do that.
Okay. I'll stop sharing. In a moment. Stop. Okay. So you believe PNM should have assisted you even though we didn't know that you needed assistance?
It was my understanding, Ms. Padilla, that it was PNM's responsibility to inform and assist us on the most economical rate class. I didn't know that I had to go and learn about all of your rules and regulations before we built our house.
Okay. Well, the obligation, as I was just pointing to in that rule, the obligation for PNM or any utility to assist a customer is only as a customer may, reasonably request. I don't believe it's. I don't know if. Anyway, that I won't provide my own opinion. Sorry. Okay. You mentioned you had a recent conversation with a PNM customer service representative about a meter reading. Is that correct?
Yes. I went to submit my meter reading, and the lady on the phone, the first time I submitted my meter reading, I had no problems. I gave her she asked me the meter number, and I gave her the meter reading. And then the second month when I went to submit my meter reading, the lady on the phone said that she was not trained to take my meter reading for the solar meter. She was able to take the meter reading for one meter, but she was not able to write down the reading for the solar meter. And so she flat out told me she was not trained to do that. And I said, well, I don't know exactly what I said. I said, I believe that you're smart enough to write down 5 numbers and the number to my meter, and I don't believe that you need training for that.
Okay.
But she was very nice, and she said, I'm going to have to transfer you to a different department. But she did tell me that she was not trained to do that. I didn't have any trouble the time before submitting my meter reading. It was when I went to the next month when I went to submit my meter reading.
Okay.
They refused to let me do it.
All right. How often do you submit your own meter reads?
I just started doing that because I was overbilled in the month of January of 2021. And it said on the back of my bill that the meter was estimated, which was false, because I saw the meter man. I was home, and when he got finished reading the meter, I went out and I also read the meter at the same time. And so when we got our two different bills, it said the bill for the studio was correctly recorded according to our readings, and the bill for the house was, we were overbilled, even though the meter man came and took the reading.
Okay. I was just wanting to understand how often you did your own meter reads.
I'm going to do it from now on. Yeah, I just
Okay.
started at this video. I just
All right.
started reading my own meters because of the overbilling.
Okay. In your discussions with the hearing examiner, you were discussing the refund that P&M had offered you during the informal complaint process, when it was our understanding that we had overbilled you, that it was our understanding that what you had told the customer service representative initially was correct. What you had told the customer service representatives initially was that your garage and studio and well should be on a residential rate, correct?
I believe that we were in the wrong rate class.
Do you understand now, though, that P&M does not believe that? P&M's understanding is that is the correct rate class for the water well and the studio and garage, right?
Yes, I believe that's your position. That's what you informed us of.
But even after we realized that and communicated that to you, that we thought that the well and the studio meter was in the correct rate class, we still said that we would honor the refund, correct?
Yeah, but you never sent the check.
Okay.
Never
That's all I have. Thank you so much. I'll pass the witness.
Mr. Pagacco, any redirect?
Mr. Hearing Examiner, no redirect of Ms. Bird is necessary, but staff thanks Ms. Bird for her time on the stand this afternoon. And with that, we would pass the witness.
Very good. That would conclude complainant's presentation of evidence. And we would now move, why don't we take a break for 10 minutes? Is that acceptable?
Yes, sir, please.
Yes,
Yeah,
good.
Mr.
We'll take a, yeah, go ahead.
Mr. Hearing Examiner, could we make it just a 10-minute break? We are going to try to ensure that Mr. Jarrett, I think we would like him to go first if possible, but he may still not be in the Zoom meeting. So we'll try to resolve that.
He's got his audio and his video is up. So I left him wasting in the waiting room for a bit of time there. He finally did it.
Okay.
So
Mr. Jarrett, could you, if Mr. Jarrett's in the meeting, we can take whatever break that you would like us to take, Mr. Hearing Examiner.
Yeah, and then maybe you and Ms. Padilla, you guys can just sit and confirm that his audio works, or we can just do that. Mr. Jarrett,
Okay.
Is your audio working? No, we don't hear you, sir. You're muted on your phone.
Yes, my
There we
audio
go.
is working.
There you go.
Okay.
So now
Sorry.
we'll take a 10-minute break. It is 3:06 on my cell phone. We'll just come back at 3:15, so we'll call it 9 minutes. And
Okay, thank you.
thank you. And we'll just wait for complainants.
Tomorrow? No, April 2nd.
There we go.
Okay.
Okay, so we'll go back on the record. And Ms. Padilla, PNM's opportunity to present evidence.
All right. Thank you, Mr. Hearing Examiner. And I think what I should do first is introduce and move for the admittance of some of PNM's other exhibits. PNM Exhibit 1 is PNM's answer to the formal complaint of Mr. Echegaray and Ms. Berg. But unless anyone has any questions for Mr. Jarrett about our answer to the complaint, I would prefer, if it's okay, to wait until Mr. Baldwin testifies. He will have to explain a correction in that exhibit.
Okay.
So at this point, and I'm just going to go ahead and list PNM exhibits 2 through 5. Is it 2 through 5? Yes. And then I'll ask Mr. Jarrett some questions about all 4 of those. PNM Exhibit 2, what I've uploaded to Dropbox as PNM Exhibit 2 is the response of Public Service Company of New Mexico to the hearing examiner's July 13th, 2020 bench request order. This was filed and is available in eDocket, filed on August 27th, 2020. What I have uploaded to Dropbox as PNM Exhibit 3 is entitled A Response of Public Service Company of New Mexico to the Hearing Examiner's November 12th, 2020 bench request order. This was filed and is available in eDocket, filed on December 11th, 2020. PNM Exhibit 4, as labeled in Dropbox, is entitled Supplemental Response of Public Service Company of New Mexico to the Hearing Examiner's November 12th, 2020 bench request order. This was filed on December 15th, 2020, and is available in eDocket. And then lastly, what I've uploaded to Dropbox as PNM Exhibit 5 is entitled The Verified Response of Public Service Company of New Mexico to the Hearing Examiner's January 25th, 2021 order. Can I go ahead and move for the admission of those exhibits?
Yeah, and my understanding is admission is you'll be verifying the answers provided through testimony of the witnesses who will be presenting in the next bit of time and sitting for cross-examination. Is that correct?
Yes, so I can go ahead and ask Mr. Jarrett some questions about those.
Sure. I mean, I understand how you're doing it. I just want to note for the record that that's
Okay.
basically what's going on.
Sure. Mr. Jarrett, could you please state your name and your? Oh,
Sorry,
go
what was
ahead.
that? Was Ms. Berg saying something?
That was
I
Kim
think it was the court reporter.
saying I needed to
Oh.
swear him in.
Very good. Please do so.
Mr. Jarrett, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right. Mr. Jarrett, would you please just state your full name for the record?
Robert Jarrett.
Okay. And what is your position at PNM?
I am manager of distribution engineering for New Service.
Okay. You just heard me list the 4 exhibits. Was it in fact 4? Let me just make sure. 1, 2, yes. The 4 exhibits, it was a series of PNM's responses to bench requests. You heard me list those, correct?
Yes, I did. I apologize.
Did you, oh, no, go ahead and turn that off. Did you participate in the preparation of responses to those, the bench request orders that are the subject of exhibits, PNM exhibits 2 through 4?
Yes, I did.
Okay. And if you were to answer the same questions, I realize some of the questions you answered and some of them were answered by Mr. Baldwin. But if you were to be asked the same questions today, to the answers to the questions you provided answers for, would your answers be the same?
Yes.
Okay. And do you were the answers true and complete to the best of your knowledge?
Yes.
Okay. Mr. Hearing Examiner, PNM will move exhibits 2 through 4.
Any objection to the omission?
Sorry, 2 through 5. 2 through 5.
2 through 5.
2, 3, 4, 5. Yes. Okay.
I don't hear any objections. I didn't fit any necessarily, so those
Right.
documents will be moved.
Okay. Thank you. And with that, I would turn Mr. Jarrett over for questioning.
Ms. Berg, in the order of the parties, you would have the first opportunity to ask Mr. Jarrett any questions you would like for purposes of cross-examination. You're muted, Ms. Berg.
Mr. Jarrett, I saw your name in some of the documents that PNM submitted. I think it was through the bench requests. And I don't remember where I saw your name. If you could remind me which bench requests were your answers given, because I was looking for them on the break, because I remember seeing your name. Do you remember when you answered questions? Because I saw your name somewhere in there.
I believe it was Exhibit 5. I'm trying to look at that now.
I don't know what exhibits are. I just wondered where your answers were in which bench request, if somebody knows the answer to that. And maybe I won't have time to look for that, but I just see here in this paper here from July 13th bench request order, it says here that on the top paragraph, it says, for commercial customers, all accounts are automatically started at rate 2A, and their usage is evaluated for 3 months to determine further rate class placement. PNM places commercial customers on rates based on factors such as kilowatt hour usage, demand, and load factor. For the vast majority of customers, there are only a few applicable rates. PNM's customer service agents are trained as to which rate is appropriate for new customers. These issues were never discussed with me or my husband. And
Ms. Berg, could I interrupt once and just could you just repeat where you were reading from? It was PNM's which responses?
Ms. Padilla, I am on July 13, 2020 bench request order, and it says these were
What page?
page 3. It's the
Okay.
top paragraph. Response to bench request P is in Paul.
Got it. Okay, thank you.
And so when I read that, and I don't know who wrote that, I just wanted to express that we were never informed that there were different rate classifications, and we were never told that we were never assisted on the most economical rate class. And since we learned that our first meter, that the first meter that was installed on the property was classified under a commercial rate, it says here that we were to be reevaluated for 3 months to determine further rate class placement. None of this was ever brought to our attention. And so this is really
Ms.
just
Berg,
the basis of one of my major complaints is that we didn't know that we were put in a commercial rate. It is not the most economical rate class. And
Ms. Berg, do you have a question for
Yeah, I
Mr.?
was going to interject and make that point myself. So, Ms. Berg, this is an opportunity for you to ask Mr. Jarrett a question. And if the question is, why didn't PNM comply with this writing? Is that your question, Ms. Berg?
that would be helpful. Thank you, Mr. Hearing Examiner. Yes.
Yeah, so the question, Mr. Jarrett, is Ms. Berg appears to be suggesting that per your own writing, the question was, look, if there's a valid basis for being uncertain about which rate class these folks fall into, and then, I mean, I'm sort of, putting Ms. Berg's gloss on this. Well, look, you put us on 2A. Now you're supposedly going to be reevaluating me in 3 months. Well, you didn't do that. And that's what I understand. Is that a fair is that your question, Ms. Berg?
Yes, your face is gone.
Oh, I just stopped my video. Sorry.
Thank you, Mr. Hearing Examiner. That helps me.
Is that your question?
Yes, that's helpful.
Okay, well, I guess that's your. So, Mr. Jarrett, you can respond. You heard what I.
Okay, thank you. Ms. Berg, I don't recall specifically if that was my language in that response, but I do recall discussing that amongst ourselves with Aaron and whatnot. But in reference to the reevaluation after 3 months, that's with the assumption that the correct commercial tariff was applied initially, or that the correct class was applied originally, that being a commercial or non-residential tariff. And those tariffs then are reevaluated, or the energy use is reevaluated after 3 months to determine if it should be moved from one commercial rate to another commercial rate, not to evaluate it as it to its merits of whether it should be a residential or a commercial rate.
Okay.
I hope that helps.
I just want to know why my husband and I were not informed that we were being placed in a commercial rate class from the beginning. That's what I would like to know, why we were not informed and assisted of the most economical rate class.
Ms. Berg, this is also not a proper question. So I'll just ask you to, ask Mr. Jarrett questions based on the bench request responses that we've introduced to the record, or any other questions that you have for him.
Well, wait, hold on, Ms. Padilla. So I think, Ms. Berg, you're trying to say, your question is, what is the nature of the scope of PNM's responsibility to advise a customer like them? And Mr. Jarrett, maybe you can answer that first.
Okay, I can't speak to the specific instance or this particular account. While I was employed at PNM at that time, I didn't have responsibility for this group, and the records that we were able to uncover didn't really specifically address whether or not the customer was consulted on the rate or not. So I can't say, what those conversations were or what may have happened in that instance. Could you repeat the question?
So, yeah, can you answer? So the basic situation we have is with these particular, and I'm trying not to ask questions for Ms. Berg, but I think generally I understand what she's trying to ask, and so we're trying to just satisfy her and do our best we can. So the basic question she's trying to ask is, it appears as if PNM has by regulation some obligation to make an assessment of the customer's needs. And that has to do with their rate class as well. And so, what was the general protocol for PNM when they go out and have to answer like, hey, here's a new service person and here's the rate they should have? What should PNM have done? Like, what should Ms. Berg and her husband have expected? Does that make sense?
Yes. And in most cases, I will tell you when customers apply for service, the rate selection is pretty straightforward. And so in most cases, probably there's not a discussion with the customer about the appropriate rate. If it's a residential home that's getting service, then it would be very obvious that it would be the residential tariff that would be applied. Normally, as the permit comes into our office, the permit release or the release from the authority having jurisdiction, allowing us to connect that customer. If that permit release comes across as a residential permit, in most cases, it will be set up as a residential tariff. If it comes across as a commercial, it would be set up on a commercial rate. However, there are instances where if the home does not exist yet, that it would initially be set up on a commercial rate as opposed to residential if the home does not exist at the time that service is being provided.
So when we come back to the response to bench request P, and it says, for commercial customers, all accounts are automatically, okay, I think you answered that question already. You said that would only be true, but I guess her next question will be, she stays on the commercial rate, and now she wants to know why I was left on the commercial rate. So why was my needs not evaluated for 3 months? And if your answer is the same, you can answer the same, Mr. Jarrett.
Yes, it would be evaluated for the proper commercial rate after 3 months.
Ms. Berg, if you want to ask follow-up questions, you feel free.
Well, I don't really.
Once the house was built, why was it?
Why was if PNM determined that we belonged in a commercial rate class, which we were never informed of, why was it not changed within 3 months, when our house was there? Because everybody knows that you need water to live. And so we never applied for electricity specifically for the well. We applied, all of our documents with P&M on them say residential, residential, residential.
Okay,
And
now
so-
get to the question, Ms. Berg. And if Mr. Sugar Ray needs to come into the room and assist with the asking of the questions, I hear him in the back. We can just make it much easier. He just comes in.
Thank you.
You're both the complainants. We're not relegated to having one ask questions. So Mr. Sugar Ray, it sounds like you have questions.
Well, we're obviously still in a commercial rate of some sort, and the house has been built for what, 12 years? Why wasn't it changed?
Mr. Jarrett.
The original service that was set up on the commercial rate, it's my understanding, does not serve or provide power to the house itself.
I'm not sure that's true.
I just, all I can say is that we were never informed that the meter would have to be hooked up to the house in order for it to qualify as a residential rate. And this information is important to all customers, I believe.
You need to ask a question, Ms. Berg, and I'm not trying to, you've submitted testimony, you've submitted a lot of the things you're saying already. We know your position. This is your opportunity to ask Mr. Jarrett questions.
Thank you, Mr. Jarrett. I don't know what else to ask you. It's just not my area. So thank you for your time.
Mr. Sugar Ray, do you have further questions for Mr.
No, I do not. Thank you.
Okay, Mr. Bagacco, do you have any questions for Mr. Jarrett?
Mr. Hearing Examiner, I do have a few questions for Mr. Jarrett. Good afternoon, Mr. Jarrett. How are you today?
Doing great. Thank you.
Take it I'm coming through loud and clear.
Yes, I can hear you very well. Thank you.
Mr. Jarrett, have you been present for this public hearing since the beginning this morning?
Yes, all but a brief period where I lost the audio connection and was able to get onto YouTube. So I was listening to portions of that, but there was a probably 15-minute period where I lost the audio.
Okay. Do you recall questions from the hearing examiner concerning a photograph that is contained in the pre-filed direct testimony of our staff engineer, Jack Sidler?
Was that the photograph of the 2 meters?
That's correct.
Yes, I recall that photograph.
Mr. Hearing Examiner, if I may, I have not admitted Mr. Sidler's pre-filed direct testimony yet into the record, but would it be all right if I brought it up so that I can view that photograph with Mr. Jarrett?
Yeah, no, the view of the hearing examiners is that even exhibits not admitted yet into the record are fair game for cross-examination. So we had this issue with Mr. Wexler once, and we addressed it in some detail. So yes.
All right. Thank you. If you'll just bear with me, let me get this set up. All right. And I'm going to push the magic button. And voila. I hope you can see what I'm looking at, Mr. Jarrett.
Yes, I can. I can see the 2 meters.
And I'll represent for context in the record that this is a photograph that is contained in Mr. Sidler's pre-filed direct testimony, and it is found on page 6 of that document. Mr. Jarrett, just for the edification of our general audience and those of us who aren't fortunate enough to be electricians or electrical engineers, I have a few questions for you about how all this works. I direct your attention to that photograph again, and the big gray box, the larger gray box to the right of the smaller gray box. Do you see that, sir?
Yes, I do.
Okay. Well, on both gray boxes, there is what I would call, I guess, a glass cover. Do you see that?
Yes, I do.
And what is it exactly that that glass cover is covering on this equipment?
Those cover the actual metering device behind the glass.
Okay. And who owns the metering device behind the glass?
P&M owns the meters,
Okay. So,
which
oh, please go ahead. I'm sorry.
I was just going to comment that the meter includes the glass as well as the contents behind the glass.
I see. Okay. So when a layperson looks at this and they call the whole item, the gray box and the pedestal and the poles holding it up and the glass and the meter in it, a meter, that is not correct, is it?
Correct.
So does P&M own the infrastructure to which the meter and its glass cover are attached?
No, it does not.
Did P&M design, create, and install the infrastructure that is contained within those gray boxes and the gray boxes themselves?
No.
And in this instance, with the benefit of your knowledge and examination, I trust of the facts in this case, do you know who owns all of the infrastructure behind the two P&M meters with their glass coverings?
The customer owns that equipment.
So if you can tell us, how did those two little P&M meters with their glass coverings come to be installed in the customer-owned equipment that we see in that photograph?
Typically, P&M will receive a release from the agency that performs the electrical inspections. Once a customer or their contractor pulls a permit or is issued a permit to allow them to construct the facilities, they call for an inspection from that agency when they're completed. The inspection agency, if they, through their inspection, they pass the equipment and deem it safe to be energized, will submit a release to P&M. We often refer to it just as the permit, but it's actually a release or an authorization to connect the power. So once that is received in our office, we would reach out to the applicant for new service, verify the responsible billing party, set up a new billing account within our system, and then generate a service order to have a meter tech or a journeyman lineman install the meter and energize the service.
And have you ever heard the term or the phrase, the customer side of the meter?
Yes.
And what does that mean to you, Mr. Jarrett?
Well, there's another term that's called the service point, which is defined in our rules and regulations, which is defined as the point where P&M's facilities or the serving utilities facilities terminate to the customer's equipment. And in that case, it's generally our wires are actually brought up into this gray container here and are terminated back behind where the meter sits there now. So that is technically the service point, and everything electrically beyond that is customer-owned equipment.
And the wires you just mentioned, I take it those are contained in the pipes that we see at the bottom of the photograph coming up into the two gray boxes, correct?
Yes, they would be in one of those tubes. There are probably customer-owned wires exiting that gray box in the other tubes, the other conduits.
Mr. Jarrett, was P&M involved in designing or establishing any of the electrical supply routes for the electrical needs of the property at issue in this case?
P&M's role in that would just be to reach an agreement on a metering location that would meet our criteria to make it readily available for reading and for future maintenance or exchange of the meter. So that would have been the extent of our involvement with this equipment.
And just for clarity, I'll rephrase it another way. Did PNM design any of the electrical infrastructure on the customer side of the service point?
No, we did not.
PNM construct any of the electrical infrastructure on the customer side of these service points?
No, we did not.
Were you present for the testimony earlier today regarding Don's Electric, Mr. Jarrett?
Yes, I recall that.
Do you have any recollection of any contact between PNM and Don's Electric in connection with the customer electrical infrastructure at issue in this case?
No, I do not.
Is that because PNM has a record retention policy that would have basically led to the dissipation of any such records if they ever existed?
I believe that is correct, yes.
Do you recall the testimony earlier today that basically, in effect, the last contact between the complainants in this case and Don's Electric took place approximately 15 years ago?
Yes.
Do you have any involvement in your capacity as manager of distribution engineering for new service regarding, I guess, the application of your various rates and tariffs to new customers?
Just from the extent of the initial rate that is applied to the customer. It's not an engineering function, but that function has sometimes resided within the engineering department.
Is that because to the extent that the rates are applied sometimes depends on what the characteristics or uses of a given structure or use point?
Yes, based upon the information that's submitted in the application generally from the customer, correct.
Mr. Jarrett, are you familiar with the configuration of the structures on the complainant's property located there at 19 San Marcos Trail?
I'm familiar with the picture that you're showing here and that configuration, but beyond that, I do have drawings that we did uncover that show general location of where the transformer would be installed at the time of service was requested, but that's the extent of my knowledge of that.
Okay. Well, based on what I see on the photograph contained in Mr. Sidler's testimony, is it fair to say that the larger service point represented by the larger gray box is assigned to what they call, I believe, the studio and the well? Is that your understanding, Mr. Jarrett?
I do not know for sure if that's the case or not.
Okay.
And I don't recall from Mr. Jack Sidler's testimony whether or not that was the case that he had determined or not.
Fair enough. Well, let's back out a bit conceptually and approach it this way. Is it your understanding that rate 2A is currently and has been applied to the building they call the studio and the well?
Yes, that's my understanding.
And what is it about the characteristics of the studio and the well that you understand make them not qualify for application of the residential rate to those two items?
My understanding is that those facilities do not meet the criteria as outlined in the applicability section of the residential tariff.
And so by default then, rate 2A is applied to those two items?
Yes.
Do you recall Mr. Sidler's response to one of the bench requests where he discussed a possible resolution of this dispute, Mr. Jarrett?
I believe I recall seeing that, but I don't recall the specifics of that resolution.
Do you believe it's possible that this dispute could be resolved by combining those two service points represented in the photograph contained in Mr. Sidler's testimony into one service point, thereby, I guess, rendering each of the structures on the property together what I would term a residential complex? If that happened, would it be acceptable then to apply rate 1A to all of those with just the one service point?
That's a question I'm not sure that I could properly answer. We have a rule, and I believe it's I believe it's 17. Or I'm sorry, it's in Rule 2, Character of Service. And it states that if both a residential and commercial facility are served behind a single meter, that the appropriate rate would be a non-residential or commercial rate. So if the facilities, the well and the studio are currently being billed under the commercial rate, if that was combined with the residential home behind a single meter per that rule, then the whole account behind a single meter would be billed at a commercial rate. Now, I know there may be some interpretation or perhaps latitude in that, but I would have to defer to our legal and regulatory subject matter experts in that case.
Thank you, Mr. Jarrett. So just to make sure I understand your position correctly, I'll throw out a hypothetical. Let's say I purchase some property and the first building I erect on that property is a lone garage. And then I create some infrastructure to serve that garage with electricity. Are you following me?
Yes.
Then I turn to PNM and I say, PNM, please come out and energize my customer side electrical infrastructure so I can have lights in my garage to work on all my projects that I need to commence construction of my home 6 months down the road. Still following me?
Yes.
Okay, so with that request, what of PNM's rates would you apply in that situation?
I believe the commercial rate would be applied until such time that the home is ready to receive electrical power from that service.
Okay. So then 6 months down the road, I complete construction of my home, and I consider my home and my existing garage now to be a residential complex. And my home's electrical service is going to come from the same existing point that currently provides my garage with power. Are you following me?
Yes.
And so that at that point, when I come back to PNM saying I'm all set and I need power for my home that is now part of a residential complex, what rate will you apply then?
The residential rate should be applied in that case.
You're not going to try to charge a commercial rate to my garage still under those circumstances?
If the garage does not house a commercial business, then I would say the garage supports the residents in providing a space for storing and parking the vehicles for the residents.
Thank you. And to be clear, all I will be doing is parking vehicles in my garage and making birdhouses for fun. Does that affect your analysis in any way?
No, it would still be residential.
Okay, so given your answers to my hypothetical then, if we turn back now, the complainant's situation, if they were to combine their two service points into one service point to serve electricity then to what I would term a residential complex, I wonder why they then would not be entitled to have the residential rate 1A applied to that fact scenario.
It's my understanding that a determination was made or admitted to by the Bergs that they were running a commercial business or operation out of the studio.
And if the facts were changed such that there is no longer a commercial operation being run out of the studio, would that affect your analysis, Mr. Jarrett?
Yes, it would.
Thank you. Mr. Hearing Examiner, if you'll permit me, I do have another item I'd like to share with Mr. Jarrett, which has not yet been admitted into evidence, but I think it's illustrative of the infrastructure under discussion in this case.
Very good.
Just bear with me, folks.
And Mr. Hearing Examiner, this is Kendra, the court reporter. I need to plug in real fast, so don't let anyone talk until I give you the thumbs up that I'm plugged in.
Okay, everybody be quiet.
Okay, I'm good. Thank you.
Okay, thank you. Go ahead, Mr. Bagacco.
Thank you. All right. Mr. Jarrett, are you still with me?
Yes.
All right. And do you see the photograph that I put up now that shows a rec meter box with a piece of cardboard in place of the circle in the middle of that box? Do you see that, Mr. Jarrett?
Yes, I do.
Can you tell us, based on this photograph, what the purpose is of this rec meter box?
My understanding is that the rec meter will measure the output of the solar facility.
And to be clear for the record, this is another photograph basically of the infrastructure at issue from the side. And you'll note there on the right of the photograph, we have an oblique view of the two service points we were just discussing with Mr. Jarrett as depicted in Mr. Sidler's direct testimony. Getting back to the rec meter, Mr. Jarrett, at some point, if the complainants elect to track their recs, as I understand it, will it be PNM that installs the meter there in that blank space?
Yes, that would be a PNM meter.
And again, as with the other service points, is it correct of me to understand that the only thing that PNM would own in connection with this rec meter would be the meter with its glass covering that would be installed in such an event? Is that correct, Mr. Jarrett?
Yes, that's correct.
And is it further correct then, as with our earlier discussion, that the rec meter itself and the attached infrastructure on the customer side of the service point is owned by the complainants in this case?
Yes, that's correct.
And then one last question, Mr. Jarrett, and I thank you for bearing with me. Here's another hypothetical. If the electric supply for the studio came directly from another building existing on the property, which is termed as the guest house, would the studio then be entitled to a 1A rate versus the currently applicable 2A rate?
I'm sorry, could you repeat the question?
Yes, sir. If the studio, the building known as the studio, which currently is charged the 2A rate, if the studio was reconfigured so that it received its power from the guest house on the property, which is currently under a 1A rate, would the studio then be entitled to that 1A rate as well under those facts?
I would say as long as a commercial operation is not run out of the studio.
Very good. Fair enough. Thank you for your time today, Mr. Jarrett. I pass the witness, Mr. Hearing Examiner.
Thank you. So, Mr. Jarrett, is it common, and I'm pretty sure this is touched upon in one of the bench request responses, so I'm not trying to ask friendly cross-examination. I'm simply trying to gain as much information as I can while you have us with us, while having you with us. Is it common for properties with only wells on them to be billed at 2A? And by that, I mean residential property.
I don't know if that is common or not. I don't know of the number of occurrences of that happening.
So the question is, and we've heard this from complainants, is look, we bought a residential property. We're going to build a house. Yes, we put up a well and powered the well first. But of course, that well was there because we were going to drink the water and live there. And I don't think it's misstating their position to say it never should have been a 2A property. How do you respond to that?
I would respond that at the time that service is provided, there is not a use of the power that meets the residential tariff applicability criteria. And until such time that there is a structure meeting that criteria of the tariff, that it would remain on a commercial rate and then transferred to the residential rate at such time that it became a residence.
Complainants also would argue we had a tractor, or not tractor trailer, we had a camping thing, and we stayed there in the camping thing, fifth wheel, I think that was the term someone used. And that's where we lived while we were building our house. Would PNM make inquiries of that nature, or would it be incumbent upon a person seeking service to alert PNM to the fact that, hey, we're not only going to have this well, but we're going to live in our trailer and power that? You understand my question?
The question related to that as to whether it would be a residential rate at that time?
Well, my question is if the complainant's point is, well, we also had our fifth wheel, and therefore that was also on the property, and therefore, look, proof that it should have been billed residential. The difficulty, as I understand it, is there's been no indication in the record as to PNM ever knowing that this, in fact, was the situation that complainants hope to have. And my question to you is, I mean, I guess number one, would anyone, do people submit that kind of a sort of thing to PNM for service? Like, hey, we're going to be living on this property with our fifth wheel in addition to this well. And if that's a circumstance that ever arises, I mean, is it incumbent upon the complainants or in this case, Ms. Berg and Mr. Sugaray, to have told P&M, hey, this is our intention. Is that clear, or are you still confused?
Yeah, I'm still a little bit confused. I don't think an RV would be considered a household or a residence under the
Okay.
applicability of the tariff.
That's
That's the
a
question.
well, that's one way of answering the question for sure, which is to say, it doesn't matter to P&M that you're living in a fifth wheel on this thing because that's not a residence. Is that your position?
Yes.
Okay. So it wouldn't matter then, even if plaintiff or complainants in this case said, we want a well, and then we're going to live here in this fifth wheel, so therefore give us residential service. What I heard you just say is, well, no, we're not going to do that because the well is the only structure that exists on the property, and that's how we're going to determine what tariff applies.
Correct.
Okay. Okay, now and this is, I mean, Mr. Bugacko is using hypotheticals to do this, and we'll just return back to and I thought that was all very productive discussion and very helpful to me. The complainants in this case also note that, well, look, eventually we had a guest house. If Mr. Sugaray and Ms. Berg felt strongly after building their guest house that the well should have merged with the residence, and I don't know if that's the correct technical term, I'm just using that to describe what their belief is, that it effectively merges the well and the guest house and becomes basically a residential structure. Would you agree? What is your response? Is that a circumstance you might envision as acceptable? That now the well is residential because now you have a guest house?
If I understand correctly, you're saying if they were still both separately metered, but it was just a well and a guest house or a residence, would they both be appropriate as residential tariff? And I would say yes, that they should be.
Okay. Would it have been incumbent upon Ms. Berg and Mr. Sugaray to notify P&M of that development if it occurred?
Yes.
Would P&M have any way of knowing that this development would occur other than them telling P&M?
No.
The business with the 2 meters. I mean, I think your discussion with Mr. Bugacko about, who owns what and P&M's side of the meter and the customer side of the meter. I don't believe that the complainants can plausibly argue in this case that somehow P&M is responsible for the presence of that equipment. It just doesn't stand to reason. There's no way. Do you agree with that basic proposition?
Yes, I do.
Yeah. Is it possible, and I realize I'm asking you to speculate, and the complainants don't even need to object, I'll just ask you to speculate because this is kind of, at least as to the 2 meters, $1 million question on some level, that the complainant's electrician wired this to have 2 meters, and maybe there's a reason for him to have done that?
I think that's certainly reasonable.
Okay. And I understand you have to basically, that's guesswork at this point, but in some ways, the fact that we're operating 17 or whatever, 15 years from when this all happened, it's inevitable. If I heard you correctly, and this has been a point of dispute during this case, Mr. Bugacko asked you if that studio is not considered a bakery, a commercial bakery, it sounds as though your discussion with Mr. Bugacko is that if it's not a commercial bakery and it's just a garage or a studio or whatever you want to call this thing, that could be part of a residential structure and subject to 1A.
Yes.
Is this case an anomaly to your knowledge? I mean, does this strike you as just all very strange?
I don't know that I would characterize it as strange. I think from the perspective that it's been billed this way for so long without question over that time, it's curious why that would happen, but
Without question by whom? Without question by the complainants or without question by PNM?
by the complainants, by the customer.
Does PNM, to your knowledge, rely on customers to examine their bills to bring to PNM's attention any objections? I mean, does PNM operate under that assumption that we rely on the customers to notify us if any problems appear?
I think your question may be getting into a lot of billing knowledge and
Okay.
Procedures that I may not be really adequately able to represent.
I'll save those
Responses on
questions for Mr. Baldwin. I don't think I have any further. I think Mr. Bogacco and you had a very good exchange and gave me a lot of information. So that was very useful. So Ms. Berg and Mr. Sugaray, you have an opportunity for what we call a redirect. That would mean if you have questions for Mr. Jarrett based on what you just heard from myself or Mr. Bogacco, you can now ask additional questions.
You want me to ask questions?
No, I don't want you to do anything. I'm just telling you, you have the opportunity at this juncture to ask questions based on what you just heard. If you don't have any, you don't have to ask any.
Mr. Hearing Examiner and maybe Mr. Jarrett, thank you. The commercial bakery seems to be a common theme, and I have reported over and over that I have never had a commercial bakery. And if I may, I would just like to read to you the New Mexico Environmental Department food program. It says here.
Okay, Ms. Berg, that's not a question. You need to ask a question of the witness. If you just want to.
Just ask him a question I asked. Hypothetically, the business is closed, and we convert it, we wanted to change to residential. That's all what you're asking. Well,
Mr. Sugaray, you can ask the question too. That doesn't have to come from Mr. Berg. Ms. Berg.
all right. Hypothetically, the bakery, because of the pandemic, has closed. So now we are going to be converting that garage into a garage, probably within a month. So we would like to request that we get our rate changed.
And I suppose the question for Mr. Jarrett is, what do you think about that? I think you kind of answered that question when I asked you what I asked you. But.
Well, again, the billing department is not my area of responsibility, but it sounds like it would be appropriate for you to request of PNM or inform PNM of the changed use of that facility, and if there's a more appropriate rate for that facility.
Thank you.
And Mr. Jarrett, if I did not have, I have never had a commercial bakery ever, why would I be placed in a commercial rate class when I have never had a commercial bakery?
Again, that's a billing question that I'm really not qualified to answer. Aaron may be able to answer that better than I can.
Thank you, Mr. Jarrett.
Who can answer that? Who did he say?
Mr. Baldwin will be able to answer. Will be able to respond to that question. I mean, there's problems with the question. You're assuming facts, but whatever. We'll get there. Any further questions from Mr. Jarrett?
No.
Thank you.
Thank you.
Anything from the party furthers before Mr. Jarrett goes? Ms. Padilla.
Go ahead.
I just have one fairly quick question for Mr. Jarrett to clarify the questions from your answers to the questions from Ms. Berg about the bench request response, where PNM stated that for commercial customers, all accounts are automatically started on rate 2A and their usage is evaluated for 4 months to determine further rate class placement. Do you remember that discussion?
Yes, I think it was 3 months rather than 4 that was mentioned, but
Oh,
yes, I
did I
remember
say
that.
4? It says 3 right there, 3 months. And you clarified that that evaluation is to determine whether the customer is in the correct commercial class, correct?
Correct. That's what I stated. And I should perhaps qualify that a bit as well, because I am not a billing expert, and that's my understanding of how those commercial accounts are monitored and evaluated after they've been established for 3 months. And I believe Aaron provided some of that response as well.
Okay. And you said in your response to Ms. Berg, though, it's not a review to determine whether a commercial non-residential rate class should be changed to a residential rate class, correct?
Correct.
Okay. That's all I have. Thank you, Mr. Jarrett.
Thank
Thank
you,
you.
Mr. Jarrett. If there's nothing further
Thank
from
you.
Mr. Jarrett, we'll excuse him. Thank you very much, sir.
Thank you.
And Ms. Padilla, you may call the next witness.
Okay. PNM calls Aaron Baldwin.
Ms. Tejas, if you could swear the witness.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Baldwin. Could you state your full name and your position at PNM for the record?
Aaron Baldwin, and I am a call center research specialist.
Okay. Did you prepare or contribute to the preparation of PNM's responses to the series of bench requests that were issued by the hearing examiner in this case?
I did.
PNM previously introduced exhibits 2, 3, 4, and 5, which were bench request responses from July, November, and January. Did you hear that discussion when I was discussing those PNM exhibits?
Yes.
Okay. I also I don't know if we need to introduce this or not. I think, yeah, I do. PNM Exhibit 1, what I've marked PNM Exhibit 1 and uploaded to Dropbox is PNM's answer to the formal complaint of Mr. Echegaray and Mr. Berg filed on August 5th, 2019. Have you reviewed that, or do you?
Yes, I have.
Okay. Attached to that, in support of PNM's answer, was an affidavit of Mario Cervantes in support of the answer. That was attached as Exhibit 1. Do you see that?
Yes.
Is Mario Cervantes your supervisor?
Yes, he is my manager.
Okay. Have you reviewed the statements contained in Mr. Cervantes's affidavit?
I have.
Okay. And do you understand them to be, is this your understanding as well of what Mr. Cervantes said in this affidavit?
Yes.
Okay. Mr. Hearing Examiner, I would just ask that Mr. Baldwin essentially be allowed to adopt Mr. Cervantes's affidavit if it's even necessary.
Is there any objection to that from any of the parties?
Okay.
That's fine. I mean, I see no problem with that.
And this is maybe a little odd, but the cover pleading to the affidavit, the answer itself, contains some inaccuracies. These are not, the errors are not in the affidavit, they're in the cover pleading. They were never corrected by PNM, unfortunately. I think it was a matter of just the long lapse of time between when we filed our answer and when the commission acted on our complaint. But we did misstate the facts concerning which meters and what the order of the complainant's development at their property was.
And this error appears on where again, Ms. Padilla?
On page 1 and 2 of P&M's answer to the formal complaint.
Okay.
That has all since been corrected in responses to bench requests, but I did want to make clear anyone looking carefully at the record will possibly be confused that in P&M's initial answer back in August of 2015, it did not correctly identify the service that was initially provided to complainants, and then the second service we flipped them.
Okay.
Okay. Well, with that, I would move for the admission of P&M Exhibit 1, the answer to the formal complaint.
Any objections? Hearing none, we'll admit Exhibit 1 P&M.
All right. And I would make Mr. Baldwin available for questioning. He did get sworn in, right?
Yes, he did.
Okay. Thank you. Okay. I would make Mr. Baldwin available for questions.
Mr. Ashugray and Ms. Berg, questions for Mr. Baldwin.
We don't have any questions for Mr. Baldwin. Hello, it's nice to see your face, Aaron.
Yours as well.
Yes, thank you. But we don't have any questions. Thank you.
Mr. Bogacco.
The hearing examiner, I do have a few for Mr. Baldwin. Good afternoon, Mr. Baldwin. Thank you for being here.
Good afternoon.
You were present for Mr. Jarrett's live testimony that concluded just a few minutes ago, correct?
Yes.
You recall the hypothetical situations I visited with Mr. Jarrett about concerning combination of service points and whether or not that would qualify the complainants for 1A. Remember that?
Yes.
You disagree with Mr. Jarrett's answers to those hypothetical questions.
I do not.
And if the complainant's 2 points of service were to be combined, let's say next week, and they came to P&M for reclassification of their rates, based on your last answer, then I can presume that P&M would be willing to implement the 1A for everything then that would be served under that single point of service. Is that correct?
That is correct.
And approaching it from a slightly different angle, if, let's say, the studio and the well were reconfigured to be served from the guest house itself, and the complainants eliminated the second service point, would that also qualify them possibly for application of rate 1A to their residential complex under that specific configuration?
Yes, it would.
And then I could take it then that the complainants would, under those scenarios, both of them be relieved of the burden of having 2 electric bills. Is that correct?
Yes.
Thank you for that, Mr. Baldwin. I have no further questions. Pass the witness.
Hello, Mr. Baldwin. How are you?
Doing good. How are you?
Fine, thank you. So one area I want to clarify is the process by which at some point during the informal proceedings, the plaintiffs or the complainants are offered to change. They say, oh, you have 1 meter at 1A and the other at 2A. Well, we think you actually should have had 1A the whole time. And then that later changes. And I think the specter that the complainants raise in some of their pleadings is that was a punitive measure imposed upon them for something that's not entirely it's not clear, that basically, I think the exact words that appear in one of the documents in this case, and I don't know which one, was that PNM got caught and therefore they decided they weren't going to let us have 1A, they were going to go back to 2A, and this is about them being greedy. I know that's said in one of the documents in this case. And so what I would like you to do, if you could, is just to walk me through what happens when you first get the case and there's an overture. Okay, we'll switch you all over to 1A account. And then there's a change in position later and it says, no, it's appropriately 1A and 2A. Do you understand what I'm asking you to do, sir?
I believe so.
Good. Can you just respond and give me your version of the events as you understand them?
So based on the way the service at the garage studio was described to us, to our CEAs, our customer experience agents, it appeared that we had been misbilling the account on commercial 2A for basically its entire existence.
And then you mean by how complainants alleged to you guys and factually when this case first began. That's what you're saying?
Correct.
Okay.
I believe it was referred to as basically a second residence. It was during the process of the informal complaint that I received an email from Ms. Berg that seemed to be describing business activities taking place on that premises, on the studio. And that that's subsequent to the initial descriptions. Now you're getting she's saying it's a second residence, and now you're saying to me that now you're discovering through emails that, oh, there's something other than residential activity going on there. Am I following you? Yes, correct.
Okay. Okay.
And so that's what led to the determination that rate 2A would likely be a better fit.
In other words, that you guys got it, you've got a representation that it would be more appropriate for 1A, and then in the course of the email conversations that are occurring in the informal proceedings, you say, oh, no, 1A was never really on the table because now we're understanding based on what you're claiming to us or what you're representing about this structure, it really was 2A and it was correct from the beginning.
That's correct.
Restated, okay. And there was was there any intention to act in a punitive manner in any way towards these individuals, Ms. Berg and Mr. Sugaray?
Absolutely not.
Okay. I'm not sure if you heard me earlier talking with Ms. Berg about her allegations regarding the inadequacy of the internal complaint procedures. She made a variety of representations about whether or not PNM's customer experience agents, did I get that right?
Yes.
Are otherwise known as customer service representatives. In any case, whether they're adequately qualified. And she has alleged in her pleadings that it is her belief that no one there is trained and that she is certain of this because of her experience. Can you talk to me about the training, a typical customer experience agent, perhaps yourself or your colleagues would go through in this job?
Well, it's definitely changed since I went through the process a decade ago. How we do it, and I'm no expert on the training, but as kind of a high level summary, we train new representatives. I think incrementally might be the best word. So we'll train them on like payment arrangements, for example, first, and that'll be the only type of phone call that they'll take. Our automated phone system is designed to try to get a customer to the properly trained agent based on the questions that the automated system asks the customer about why they're calling. So it's possible that if somebody's calling about one thing and they choose the wrong option, they may go to a representative that doesn't have the proper training for, like in Ms. Berg's example, for taking a meter reading. It may not be that they can't write down the number. It's just they're not able to, they don't have the knowledge to input that number into our billing system to create a bill based on that number.
Okay. And so then as time goes on and this person gets more experience, I assume you're sort of leading towards a point where they're getting different training on different aspects of the types of calls they might receive?
That's correct, yes. So it goes from there to high bill complaints, then it goes to, and these are just examples, I don't know if this is the exact order, but from high bill complaints to commercial complaints. So then at that point, that representative has knowledge of all three of those subjects and is able to take calls, regarding those subjects with customers.
Okay, so if I understand you correctly, you're saying that in fact the customer experience agents or customer service representatives at P&M do receive training.
Yes.
How would you characterize it as extensive training? I mean, pick an adjective, I guess.
I would say it's fairly extensive training, yes.
Okay. And again, how long have you been at P&M?
Just under 10 years.
And your role as, I heard your what is your title specifically?
Call center research specialist.
So do you have any sort of supervisory authority over folks?
I am not a manager, but I do advise the managers and supervisors in our contact center on how to handle certain complaints.
Okay.
I do that on the benefit, on behalf of Mario Cervantes, who's the call center director.
Okay. Would you describe the case involving Ms. Berg and Mr. Ashugare as a challenging one?
It was unusual. There was a lot of information to kind of cipher through. Maybe challengeable is the right word.
This was beyond the normal call about a billing dispute.
Yes, yes.
It sounds to me, I mean, because I read the informal complaint file several times, studied it more than I care to. I did, and I think throughout that document, there's multiple places where you say you have to take measures that go beyond what is typical in these types of cases. Is that correct?
That's correct.
Okay, so I don't dismiss Ms. Berg's frustration, but I think perhaps, and I'm asking for you to address this, but is her dissatisfaction with the customer experience agents she dealt with perhaps a product of the fact that she was asking for a lot?
I don't know that she was asking for a lot.
And by that, I mean, like, for people to do meaningful work to assist her, which understandably you have to do because it's your job, but like, that can't be done in 2 seconds.
Well, I'll say from the conversations that I listened to, at first Ms. Berg was just requesting the previous month's, a copy of the previous month's bill. And it's my understanding that those were never sent to her. I don't believe it was, well, let me think back on this. I don't believe the request for her entire billing history came up until the complaint was in the informal process.
I guess, I'm gonna ask you this question. Is there any aspect of working with Ms. Berg that you wish you had done differently?
Not on my behalf that I can think of right now. Something might come up. There was an instance on a phone call with Ms. Berg where one of our customer experience agents advised her that we would only be able to rebill her account for 1 month. That, of course, is incorrect. I'm not sure where the representative got that information. I probably should have said, I need to get that request to my supervisor. We train representatives to know PRC rules and things when it comes to dealing with high bills and rebilling of an account if we discover some kind of an error. So for the most part, they should be aware of the 12-month rule going back. So I think we could definitely probably could have handled that a lot better than how it was handled.
Okay. The PRC's rules talk about, and Ms. Berg and Mr. Sugar raised this in their documents in the proceedings today, require PNM's representatives to inform individuals who call them about the informal and formal complaint process. Are you familiar with that regulation?
Yes.
And it is Ms. Berg's position that that this was never relayed to her by a PNM representative. Are you aware that that's her position?
Yes.
Is that correct?
Excuse me. That is correct. I will add to that PNM likes to deal with customer complaints internally as much as possible. And typically we'll only refer a customer to a PRC complaint if we have a resolution offered to a customer that the customer is not satisfied with. In this particular case, it seemed that the main issue she had been calling about originally, the incorrect rate being charged to her second account, had actually been resolved, but that the billing credit side of things was kind of a side issue. It wasn't made clear to us on the phone conversations at the time that she made her dissatisfaction clear, but that she wanted to further contend that resolution. So that's.
I understand, yeah. And I guess, yeah, what you're saying is, I mean, the rule specifically reads, if the residential customer and utility are unable to resolve a dispute, the utility representative shall, one, advise the residential customer that if the complaint cannot be resolved to the party's satisfaction, each has a right to file an informal or formal complaint. So I guess what you're saying is that conditional if, it's your understanding that you had not yet reached the point that the complaint could not be resolved. Is that what you're saying to me?
Yes.
So the conditional if was not satisfied, thus you felt you did not have an obligation, or it's not about obligations, it's that you're telling me, well, look, PNM is trying to resolve this without PRC involvement, without other folks, so let's try to do that first, and only after that's absolutely not going to work out, we all know that's what's not going to happen, then I'm going to tell you about the rest of the stuff. Is that what you're saying?
Yes, that's correct.
Okay. Okay. The only other question I have for you is, were you aware, and I spoke with Mr. Jimenez from the PRC this morning and asked him this question, the informal complaint file, like it's very, very hard to keep track of what email is part of what string of emails, right? The way that document's filed, you don't know if you're reading a communication from one person or if you're reading a forwarded email from another person, right? So right. My question to Ryan Jimenez was basically, did Aaron Baldwin see at some point that you told, that Ryan Jimenez told Ms. Berg and Mr. Ashugare about the informal and formal complaint? In other words, did you see that in any of those message strings that Ryan had talked with them about the informal and formal complaint process?
Yes, I did. I can't recall an exact time, but I do recall seeing that.
In one of the messages in those strings, you did see something about the formal and informal complaint process?
Yes. Okay. I believe Ryan forwarded me what he sent to Ms. Berg regarding the formal complaint process.
And as I said, if you try to read those documents from start to finish, it becomes very difficult to see who is actually sending the message and who is like getting it as the forwarded message. So that's very useful for you to clarify that for me.
Sorry, Ryan, you said, and that's very easy to identify, and then you trailed off, and I didn't get that.
Oh, I'm sorry. I guess I was just trying to say that it's difficult to read the informal complaint file and keep clear in your mind who is the sender of the message and who has received it and who received it in the middle. That's the best I can do. And anyone who goes and reads that file will see exactly what I mean. That's all the questions I have for you, Mr. Baldwin. Thank you for that. If there's any redirect from Mr. Sugar Ray or Ms. Berg, any further questions for Mr. Baldwin?
I just have one question for Aaron. Thank you, Aaron, for being here. When you were talking about the training, you said that people are often trained in one area and then they are allowed to take phone calls pertaining to that specific area. If I call in my meter reading and I call the correct number according to your website, and the girl tells me she's not trained and that I will have to be transferred, is that something that I should expect every month when I call the correct number according to your website?
No, that's going to depend upon the choices that you make in our automated phone system. And I couldn't, off the top of my head, tell you exactly what options to choose to get to a representative that would be able to take that reading from you. Alternative.
A meter reading. I think there's an option. I've only done it twice, so forgive me, but I believe it's that the number is specifically on your website if you want to submit a meter reading. And should I expect the person that is handling that specific call to tell me I'm not trained to write down this meter number, but I will transfer you to the solar department? Because I was not able to submit my meter reading the second time I tried when I went to do it online. I was blocked, and that's why I had to call, and I would prefer to do it online.
So if there's a specific number on our website, and I'd have to look for that and review it because it technically should be our general phone number for you to contact. But if there's a specific number on our website, then that's something we would need to correct. The other thing, just kind of for your benefit, because I looked into that, our automated system didn't necessarily block you, but it couldn't take the reading at the time that you called it in, and
Why?
it wasn't the correct time of month. What I'm going to suggest is that I send you unless you've already received this, a meter reading schedule that'll tell you there's 2 days prior to your scheduled meter reading that those are the only 2 days that the system can accept it. So I'll make a note here to have a meter reading schedule mailed out to you, and so that way you'll be able to see that information.
I already got one, Aaron. Thank you for offering. But I was able to submit my meter reading for our little house. It just blocked me from allowing me to submit the meter reading for the studio. And so I was frustrated by that. And that's why I called and got the lady that said, I'm not trained. She was able to take the meter reading for the house, but she said, I'm not trained to take the meter read for the studio.
Okay. And
I appreciate you guys having a discussion, but we've got to stay focused on the task at hand. So Ms. Berg, is there a question that we're getting to in this, or if you and Mr. Baldwin want to have a discussion, you're free to do so.
Thank you for your time, Aaron. Aaron, I don't have any further questions for you. Thank you for your time. And it's nice to put a face with a name. Thank you.
thank you. You as well.
Okay, Mr. Bagacco, anything from Mr. Baldwin?
No further questions for Mr. Baldwin, and staff thanks both Mr. Baldwin and Mr. Jarrett for their participation today.
Ms. Padilla, did you have any further inquiry from Mr. Baldwin?
Just a fairly quick question. I know it's really not related to the case as we were just discussing, but the meter read that Ms. Berg mentioned that she had an issue with, I think you mentioned, Ms. Berg, that was your solar meter?
Yes, I didn't have any trouble the first time I submitted, only the second time.
Okay. And Mr. Baldwin, I apologize, it's not Ms. Berg who's on the stand, it's Mr. Baldwin. But Mr. Baldwin, does that change your answer at all in terms of whether customer service can assist with a solar meter reading?
No.
Okay. All right. Thank you. That's all I have.
Okay, thank you, Mr. Baldwin, for your time, sir.
Thank you.
Okay, that would bring us to staff's presentation. It's 4:40 now. I don't know, Mr. Sidler, well, how much time do you think, Mr. Begacco? Do you think we can do it by 5?
Let's see if we can.
Okay.
Staff and call Jack Sidler, our sole witness in this proceeding, to the stand.
Ms. Tejas, if you could swear Mr. Sidler in.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Hearing Examiner, I'm gonna, if it's acceptable to you, move staff exhibits 1, 2, 3, and 4 into the record in mass, since those consist of staff's filings in response to various bench requests and Mr. Sidler's prepared direct testimony. That would be exhibits 1 through 5.
Okay.
And I would just briefly, I guess, ask Mr. Sidler about those documents in mass. And unless anybody has any objections, move staff exhibits 1, 2, 3, 4, and 5 into the record after I have a brief conversation. Is that acceptable to Mr. Hearing Examiner?
Yes, that's fine, Mr. Begacco.
All right. Mr. Sidler, I trust that you've had access to Dropbox and that you've been able to look at staff exhibit 1, which consists of staff's verified response to order for a staff response that was filed on 9/18/2019. Are you familiar with that document, Mr. Sidler?
Yes, I am.
And that's the verified response that you did on that date, correct?
Correct.
And in the document that I've marked as staff exhibit 1, is that complete and accurate to your knowledge, information, Mr. Sidler?
It is.
And I take it you have no changes to make to staff exhibit 1, correct?
No changes.
Moving along now to staff exhibit 2, which consists of staff's verified response to order for a staff response filed on 9/18/2019. But this was the one that was performed by Mr. David Alt. Is that correct, Mr. Sidler?
That's correct.
You recall in this case that you've been authorized by Mr. Hearing Examiner to be substituted for Mr. Alt and to adopt Mr. Alt's verified response from back in 9/18/2019. Do you recall that, sir?
Yes, I do.
And you reviewed Mr. Alt's verified response, and
Yes,
and then with that understanding, is it complete and accurate to the best of your information, knowledge, and belief?
it is.
I trust then you don't have any changes to make to that document as filed, correct, Mr. Sidler?
No changes.
Moving along to staff exhibit 3, which is staff's response to July 13th, 2020 bench request, which was filed in the docket on August 27th, 2020. Do you see that document, Mr. Sidler?
Yes, I do.
That staff response, which is marked as staff exhibit 3, was sponsored by you, correct?
Yes,
It involved your input and your knowledge and your opinions regarding the questions posed.
yes,
Is it complete and accurate to the best of your information and belief as we sit here today?
yes, it is.
I trust that you have no changes to make to staff exhibit 3, do you?
No, I don't.
All right, very good. Moving along, staff exhibit 4 consists of staff's response to the November 11, 2020 bench request, which was filed in this matter on December 11th, 2020. Do you see that document, Mr. Sidler?
Yes, I do.
And like its predecessor, this one was dependent on your information and input to formulate the responses to that particular set of bench requests. Correct, Mr. Sidler?
Yes, I did.
The document you see before you marked as staff exhibit 4, do you have any changes or corrections to make to that item, Mr. Sidler?
No, I don't.
that it's therefore complete and accurate to the best of your knowledge, information, and belief. Is that correct, Mr. Sidler?
It is.
All right, finally, staff exhibit 5. This consists of a prepared direct testimony of Jack D. Sidler, which was filed in this matter on February 26, 2021. Do you have that in front of you, Mr. Sidler?
Yes, I do.
Is that an accurate copy of your prepared direct testimony filed in this proceeding?
Yes, it is.
Do you have any changes or corrections to make to your prepared direct testimony, Mr. Sidler?
No, I don't.
Here today, then, it is complete and accurate and otherwise undefiled to the best of your knowledge, information, and belief, correct?
Yes, it is.
All right, with that, Mr. Hearing Examiner, I would move en masse into the evidentiary record, staff exhibits 1, 2, 3, 4, and 5, which have been previously identified on the record.
Any objections? The documents will be moved indefinitely.
Very good. The remainder of our exhibits are things that, except for one, previously haven't seen the light of day in this case, but which I would move for the admission of the record because I think they're illustrative of what Mr. Sidler saw on his site visit to the complainant's property on or about July 17th, 2020. And with that, I would start, and if you'll just give me a moment, I'm going to display these so that we're clear and everybody can see exactly what we're talking about.
Very good.
The first item that I hope you see has been provisionally marked as Staff Exhibit 6, Positive Energy Solar Diagram Photograph. Do you see that, Mr. Sidler?
Yes, I do.
And is this a photograph that you took during the site visit that occurred on or about July 17, 2020?
Yes, it is.
And what does that, if you quickly summarize what this photograph depicts, Mr. Sidler?
Okay, it's basically a map created by Positive Solar from the installation of the solar system at the complainant studio. It shows the panels on the roof, an underground line running from the studio to the panel or to the metering point, and it shows boxes and that it's interconnected to the right panel. From the front, if you're looking at it from the side of the two service meters, it's the right panel. If you're looking at the back, it's the left panel.
I see. And do you see my little hand cursor on the photograph, Mr. Sidler?
Yes, I do.
And can you read for us what this notation says?
That says existing utility meter / existing main service panel.
And Mr. Sidler, am I correct that that diagram and its reference to the existing utility meter and existing main service panel, do you believe that those match up with the photograph of the service points contained on page 5 in your pre-filed direct testimony?
Yes, I do.
All right, with that, Mr. Hearing Examiner, I would move for admission of Staff Exhibit 6, which is the photograph of the positive energy solar diagram that is present on one of the complainant's service points.
Any objections? Admitted.
All right, moving along. I will pull it up momentarily. Here we are. Do you see that, Mr. Sidler? What's been provisionally marked as Staff Exhibit 7?
Yes.
Excuse me. Sorry about that, folks. All right, back to what we're looking at on the screen. This is Staff Exhibit 7, labeled Positive Energy Solar Line Diagram Photograph. Do you see that, Mr. Sidler?
Yes, I do.
Is that another photograph that you took on the site visit to the complainant's property?
Yes, it is.
Very briefly, what does this photograph depict?
It's a one-line diagram of the interconnection of the complainant's solar system on the studio building.
And was this diagram, this one-line diagram, something that was also located on the back of one of the complainant's service points?
It was located directly below the map in the previous picture.
And you're referencing staff exhibit 6, correct?
Yes.
All right, thank you, Mr. Sidler. With that, Mr. Hearing Examiner, staff would move for admission of staff exhibit 7 into the record.
Any objections? Admitted.
All right. Moving along. I have another item for your consideration, and this will be staff exhibit 8, which is labeled as diagrams together, and it simply depicts what's represented in staff exhibit 6 and staff exhibit 7 together as they occur on the back of that one service point. Mr. Sidler, is this another photograph that you took during the site visit that occurred on or about July 17, 2020?
Yes, it is.
Is my description of it as simply containing the solar diagram and the line diagram accurate?
Yes, it is.
And is this photograph otherwise accurately reproduced for purposes of exhibit 8?
I believe so.
Mr. Hearing Examiner, with that, I would move for admission of staff exhibit 8 into the record as it depicts the diagrams previously featured in exhibits 6 and 7 together.
Okay, as if there is no objection to 6 and 7, I can't see why I would object to 8, so I will admit that.
Thank you very much, Mr. Hearing Examiner. If folks will bear with me, we're getting very close to being done. Mr. Hearing Examiner, this is staff exhibit 9, labeled as Frigidaire commercial refrigerators. Mr. Would you please give us some context for this photograph?
Yes, that's a picture inside the studio bay of freezers and refrigerators used by Miss Berg.
And this again is a photograph taken in connection with the site visit that occurred on or about July 17, 2020, correct, Mr. Sidler?
Yes, it is.
With that, Mr. Hearing Examiner, I would move for admission of staff exhibit 9 into the record as it depicts the interior of the studio building that is one of the items at issue in this proceeding.
Any objections? Document will be admitted.
All right. Next up, we have staff exhibit 10, labeled as Frigidaire commercial close-up. Mr. Sidler, would you give us context for this photograph, please?
Yes, that's one of the tags on the freezer refrigerators that were shown in the previous picture.
And this, of course, is taken on the same day of your site visit that occurred on or about July 17, 2020. Correct, Mr. Sidler?
Yes, it is.
All right, with that, Mr. Hearing Examiner, staff moves for admission of staff exhibit 10 into the record.
Any objections?
I object.
Okay, Ms. Berg, what's the objection?
The appliances that we have, two of the appliances are for our own personal use, and 2 of the freezers were to store my baking products in. And I think that those appliances are irrelevant because I have never had a commercial business. And I guess I would like to object to the other picture too, because I also think that is irrelevant because I've never had a commercial business. I just happen to have bought appliances at Sears or Builder Source that are easily accessible to any homeowner.
Okay, Ms. Berg, I think that your objection goes to the meaning of the facts, not to their admissibility. You're objecting based on what they mean, not on whether they can come in. I understand your position, but this is, according to staff, a fair picture of things in your house, unless you tell me that that is not in your house and that is not a picture that depicts what is inside this building. I'm inclined to overrule your objection.
Jack, you took some lovely pictures of my kitchen. It's very pretty.
Thank you, Ms. Berg. Okay, continue on, Mr. Bogatko.
Yes, sir.
I will admit that exhibit to the extent which I didn't say that.
Thank you. If you just bear with me, I am having to recall my list.
I think you got through 10, right?
Sure. All right. Here we are. Let's pull it up. There we go. I hope you can see that. What I hope you see right now is staff exhibit 11. It's labeled stove adjacent refrigerator commercial. Mr. Sidler, would you give us some context for this photograph, please?
That is the stove in the studio.
And that's a photograph that was taken on the same date of your site visit that occurred on or about July 17, 2020, correct?
Yes.
And for the record, it is a lovely kitchen.
Great. I'm impressed, Ms. Berg.
Thank you, Mr. Bogatko.
I would for admission of staff exhibit 11 into the record.
Any objections? If Ms. Berg, if you have the same objection, I can acknowledge your continuing objection.
No objections.
Okay.
All right.
You proceeded with a compliment, Mr. Bogatko. Apparently it's coming in.
And then, here we go. This is staff exhibit 12, and it's just another shot from another angle of the service points that were previously depicted in prior exhibits and which were featured in Mr. Sidler's pre-file direct testimony. Mr. Sidler, is that a correct reproduction of the photograph that you took of the meters and the
I don't know. I don't see one.
Yeah.
And you're breaking up, Mr. Bogatko.
I'm gonna get fired. Here we go.
Yeah, you are breaking up.
Thank you.
All right, folks, can you see staff exhibit 12 now?
Yes.
And as I was trying to say before, that this is just another angle of the two service points with the PNM meters that have been previously discussed and depicted.
I'm sorry, you're breaking up still.
Ah, okay. How's that?
That's better, I think.
This is staff exhibit 12. It depicts meters and the complainant's infrastructure. It's just another angle of what you see, I believe, in staff exhibits 6 and 7, and which is fairly close, but not identical to what you see on page 5 of Mr. Sidler's pre-filed testimony. Mr. Sidler, do you have anything to add in terms of authenticating this photograph or what it depicts contextually?
Okay, that picture was taken on or about July 17th of last year. The equipment shown on the right feeds the studio. The equipment shown on the left feeds the guest house. The equipment, looking at it from side view on the side, is for future solar installation, I believe at the guest house.
Very good. And this is an accurate depiction of your photograph.
It's not currently being used.
Okay. I hope I'm still coming through clearly. Mr. Hearing Examiner, if you can hear me, I would request that staff exhibit 12 be admitted into the record.
Yeah, and I believe Mr. Sidler, he did ask a question, which was, it sort of broke up for a second, that this is an accurate representation of the picture you took. Is that correct, Mr. Sidler?
Yes, it's inaccurate.
Okay, yes. In which case, is there any objection to exhibit 12? None heard, it'll be admitted.
All right. Bear with me, folks. We're almost there. We're going to learn more about service points than we ever wanted to know. Here we are. This is one that I briefly discussed with Mr. Jarrett earlier, but it had not been admitted yet. This is staff exhibit 13, labeled as meters and complainants infrastructure, and this is the side view. And this was under discussion with Mr. Jarrett earlier. Mr. Sidler, can you confirm that this is a photograph that you took in connection with the site visit that occurred on or about July 17, 2020?
Yes, it is.
Is that an accurate reproduction of your photograph, sir?
Yes, it is.
With that, Mr. Hearing Examiner, I would move for admission of staff exhibit 13 into the record.
Objections? Documents admitted.
All right, and I believe,
The photograph is admitted.
and then finally, staff exhibit 14, labeled as a business license photograph. Mr. Sidler, is this a photograph, another photograph that you took in the course of the site visit that occurred on or about July 17, 2020?
Can't see it.
It's displayed. You got to display it, Mr. Gecko.
I'm sorry.
Okay. It's a lot of sharing. There we go.
This is it, I promise. It's got to be it.
Yes, I took that on July 17th of 2020.
Does that appear to be an accurate copy of the photograph you took, Mr. Sidler?
Yes, it does.
Well, with that then, finally, this would be it. Mr. Hearing Examiner, staff exhibit 14 depicting the business license photograph that was posted in the studio. Staff would seek its admission into the record, please.
Any objections? Admitted. Exhibit 14.
Then that's all I have in terms of admissions of staff's exhibits into the record.
So we've reached 5 p.m. and Ms. Tejas, I'm loath to ask you to stay later than you are obligated to. I suppose on one hand we can conclude for the day and have Mr. Sidler available for questions tomorrow, unless that's going to be a real problem for people.
Mr. Hearing Examiner, it's not a problem for me, but I can't speak for Mr. Sidler. Mr. Sidler, are you able to stay over a little bit?
It's not a problem for me.
Ms. Tejas, what is your feeling on the subject?
Well, I do have another hearing tonight, believe it or not. I have.
My view is that the court reporter's time is the most important in the room, frankly. So everybody else can deal with that.
I mean, if it's only going to be 15 minutes, I'm fine with that. But if we're going to be sitting here for another 30 or 45, I do need to grab dinner. I've only had a small lunch and a 9-minute break and a 5-minute break. So,
Ms. Padilla, are you going to ask Mr. Sidler some questions?
Ms. Berg or Ms. Padilla?
Ms. Padilla.
I have probably less than 5 minutes of questions.
And Ms. Berg, do you have questions for Mr. I don't think it's going to happen in 30 minutes. I think it's going to go over. I want to ask Mr. Sidler some questions, and I don't want to feel rushed about it.
Okay.
We've done enough work. Why are we going to sprint to the end? I'm sure people have other stuff, but I assume we'll get that done in an hour tomorrow morning, or maybe an hour and 15 tops. Is that going to work for you, Ms. Tejas?
yes.
Ms. Berg, is that going to be acceptable for you?
Yes, can my husband be excused tomorrow?
If he doesn't have any questions for Mr. Sidler, I'm not going to require him to participate.
Thank you,
So-
Mr. Thank you very
Yeah.
much.
I just think it's the smartest way. We can ask whatever Mr. Sidler has questions we have. I have some questions I'd like to have a conversation with him about and not feel rushed. So let's just use the time as best we can.
And Mr. Hearing Examiner, could PNM's witnesses also be excused at this point?
Yes.
All right.
Yes, they can.
Thank you.
I'm sorry I didn't do that earlier, but we'll all. Is there anything else for today, or can we all break at the moment? Anything from the parties?
Nothing further from staff. We'll be happy to reconvene tomorrow morning, and we have abundant thank yous for our court reporter. She's really put in the time today, and I think it's going well for her tonight.
Yes,
Absolutely.
That's the way I feel too as well. So good. All right, with that, we'll go off the record and we will reconvene
Hang
tomorrow.
on, I believe Ms. Berg has a question.
Oh, sorry, Ms. Berg, I didn't see you. What is your?
I just wondered, Mr. Hearing Examiner, will I have an opportunity when this is all over just to make a final statement?
You have what's referred to as an opportunity to present rebuttal testimony, but this is not a hearing like we see on TV where people make closing statements. What happens next after? Let's go over this tomorrow. We'll just deal with this. We've had enough today. I'll be prepared to answer your question more in depth. Don't worry about that now. I'll have some explanation tomorrow. Okay, let's go off the record. We're reconvening tomorrow morning at 9 a.m. It's the same Zoom link. Click the button, you'll get brought in. And we're just going to have questions from Mr. Sidler and then do procedural stuff, and that will be that.
Okay. Thank you, guys.
Thank you.
Thank
Good evening,
you.
everyone.